ಎಷ್ಟೊತ್ತಿ ಹೋಗಿದೆ ನೋಟಿಸ್ ನೋಟಿಸ್ ಹೋಗಿಲ್ವಾ ಥ್ರೂ ಕೋರ್ಟ್ ಏನಾಗಿದೆ ಅನ್ಕ್ಲೈಮ್ಡ್ ಬರ್ಕೊಳ್ಳಿ the notice issued to the respondent number 1 to 3 is not claimed. The notice of the respondents 1 to 3 mentioned in the writ petition, the address of the respondents 1 to 3 mentioned in the writ petition corresponds to the address, to their address mentioned in the cause title of the cause title before the trial court. The counsel for the petitioner has filed an affidavit stating that the counsel for the respondents 1 to 3 were served with a copy of this writ petition. Hence, notice to the respondents 1 to 3 is held sufficient. Office is directed to show their names in the cause list. In view of the above order, IA 1 of 24 does not warrant consideration. The same is dismissed. 17.1 allo same order. Bill number 18, Manvendra Reddy.
18ದಲ್ಲಿ I undertake to file a call on behalf of 4 to 7 my lords.
Srimati Ratna Shivayogimat undertakes to file wakalat for respondent number 4
4
to
to
7.
7 my lord. Then my lord, one more thing, Lord, 10 to 15 are placed ex parte before OS as well as the RA man.
He also submits that respondents 10 to 15 were placed ex parte before the trial court and the appellate court.
Please.
Since notice to the said respondents is dispensed.
Please.
What about 8, 9 and 10?
8, 9 and 10 my lord not at.
They have contested the matter.
List the petition after service of notice to
Next
respondents.
week my lord the matter RA is posted for judgment my lord therefore.
8, 9 and 10. Yes, next.
Interim order granted may be
Interim
extended.
order granted is extended till the next date.
Please, my lords, oblige.
List after service of notice to respondent number 3.
In this matter, minutes, may I appear for the respondent 4 minutes? The petition does not survive minutes. They fought for direction against the returning officer not to accept my nomination. My nomination is accepted. Now the election is declared minutes. I become a board of director. So any
challenge
given
is
section
election.
70 minutes.
This petition has become infructuous. You challenge his election if you
No.
want.
I said, my lord, regarding his disqualification, it is for the respondent number 2 to decide, my lord. Since the elections were announced, meanwhile, my lord, the writ petition was filed.
This is
Now,
a
so
case
far as
of-
filing nomination and get elected, my lord, that is a subsequent issue. But main issue with regard to his disqualification, my lord. His disqualification has to be decided by the second respondent.
What about disqualification?
Let's kindly see.
He gets a
minutes.
disqualification about the membership
They
because of
say minutes,
the.
kindly see minutes. There is a appellate tribunal order minutes at page 182.
Hmm.
Wherein minutes, may I read minutes 193? The application is partly allowed and the punishment of withholding our annual incomes with cumulative effect imposed upon the applicants, that is minutes respondent number 4 in the present writ petition, so and so, is confirmed and the further penalty of postponing their promotion for a period of 4 years is set aside. Let's kindly see the bylaw minutes. Bylaw item number minutes 55, page 87 minutes. Bylaw 55 minutes, clause 10. Their case is minutes, it attracts to my case. Kindly see minutes, has been convicted of any offense under the act. Nothing to do with my service conditions, minutes.
Column number 9, 55 nalli, disqualification, column number 9, my lord, has been convicted by any court of
Moral
India
turpitude.
or offense involving moral turpitude of or of any offense.
Offense king.
Moral.
Moral turpitude, my lord,
I have a
regarding
case.
the order passed by the KAT. There were 2 punishments, my lord. Only punishment of postponing the promotion is being set aside. So far as he has been convicted for the
Convicted angry.
annual increments, my lord.
How can KT convict, mister?
Please, no,
How can the KT convict?
no, one submission order. The withholding of the increments also amounts and moral turpitude, which is one kind of punishment, my lord. I'm not saying convicted. It is one kind of punishment. Once you suffered that punishment, my lord, my humble submission as per the bylaws.
ಅಪರಾಧ.
Please, my lord.
It could be a civil wrong.
Yes.
ಅಪರಾಧ ಹೆಂಗಾಗುತ್ತೆ?
Allala. Even if it is civil wrong, my lord, moral turpitude comes into picture. And thereby, as per the bylaws of the society, and also under section 17 of the cooperative society,
Hmm.
it gives a reason for being, keep him as a disqualified from membership, my lord.
Hmm.
That is what the main intention behind the disqualification which is being meant in the bylaws of the society, my lord. And that apart, not only that 55, my lord, kindly page 195, my lord. I have put separate clause of this bylaws, page 195.
Hmm.
This is clause 21, my lord.
ಆಯ್ತು ಓದಿ.
Cessation of membership,
Hmm.
ಇಲ್ಲಿ subsection 2, if a person becomes subject to any of the disqualifications mentioned in clause 1 of these bylaws, the board shall decide the question of cessation in accordance with the provisions of the act, the rules and bylaws after giving an opportunity being heard to the such person. So on such a determination about cessation of the person to be a member of the bank under clause 2 of this bylaw, the board shall remove his name from its list of members and shall pay back the value of shares together, so and so. So here, my humble submission, my lord, second respondent bank, which is represented by the board of directors, even if, my lord, because main grievance of the petitioner is that petitioner is also a member of the second respondent bank, my lord. And the second respondent petitioner has realized that the fourth respondent, in spite of holding disqualification, my lord, under the orders passed by the departmental inquiry and also upheld by the KAT. So my respectful submission would be, my lord, the second respondent should decide whether he is really could be maintained as a member of that society, my lord, that bank.
ಡೈರೆಕ್ಷನ್ ಇಶ್ಯೂ ಮಾಡೋದಕ್ಕೆ
Please, my lord.
there should be something contained in the bylaws which says that if he indulges in any misconduct,
No, it is
moral-
nothing but misconduct, my lord.
moral turpitude is different
Yes, my lord.
than misconduct.
Yes,
Moral turpitude ಬೇರೆ, misconduct ಬೇರೆ.
yes,
ಇದರಲ್ಲಿ bylaws ಅಲ್ಲಿ ಇರೋದು moral turpitude and there should be an offense.
yes.
For example, rape, for example, cheating. Moral turpitude is different from misconduct.
Yes,
What is the
but,
allegation against you?
As per section 17 of the act also, my lord. This is
Vijaypura
one kind of
lottery-
disqualification.
They're running a lottery institute called Big
Please, my lord.
in the names of their wives and deceive the teachers.
Yes. According to me, my lord, the Honorable KT's order puts him under a disqualification.
ಹೆಂಗಾಗುತ್ತೆ?
Because the penalty is being imposed upon him.
So therefore I'm saying your bylaws say
Please, my lord.
that if he is accused or convicted for any offense of moral turpitude,
Yes,
he cannot continue as a member.
please, my lord.
But if it's a case of misconduct, ಅಂದ್ರೆ conduct
Please,
rules
yes,
ಇರುತ್ತೆ,
yes.
conduct rules ಇರುತ್ತೆ.
So my humble submission, my lord, that moral turpitude also includes this penalty order or the punishment
ಯಾವ್ದು-
passed by the
ಕಾನೂನು ಇದೆ ಕೊಡಿ ಯಾವ್ದಾದ್ರು.
ಇದು.
ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಹೇಳ್ತಿದ್ದೀರಾ? On what basis? In government servant ನೀವು?
Please, my lord.
Government servant,
Government.
government servant, cooperative society.
Government ಅಂದ್ರೆ ಕಾಂಡಕ್ಟ್ ರೂಲ್ಸ್ ಇರುತ್ತೆ.
Conduct rules.
Conduct rules ಅಲ್ಲಿ the government servant cannot indulge in any business while being employed.
But where, so far as he is becoming a member of the bank, my lord, it is not part of his service. Merely because he is a government servant, the bank is constituted. and he has been made as a member, my lord. Here, my humble submission, my lord. Since in the service, he has suffered with some order, and that is a moral turpitude.
No, Barcode. The,
May I make one submission? My lord? Let the respondent number 2 clear, my lord. Under these circumstances,
no, first you convince the court how it's a case of moral turpitude at the hearing. How
that
is convicted,
the honorable Kate is order, my lord.
Barcode?
Yes.
The petitioner has sought for a writ in the nature of mandamus, directing the respondents 2 and 3 not to entertain the nomination, if any, to be filed by the respondent number 4. The election to the board of directors of the respondent number 2, in view of his disqualification suffered by him, in view of his disqualification.
Even while the nomination was under consideration, my lord, we made representation also. We brought to the knowledge of the returning officer that the writ petition is being filed, my lord.
The petitioner contends that he and the respondent number 4 are members of the respondent number 2.
Respondent number 2.
Full stop. The respondent number 1 proposed to hold elections to the board of the directors of the respondent number 2 and appointed the respondent number 3 as the returning officer to prepare the voters list and conduct elections as per the calendar of events. Full stop. The petitioner contends that the respondent number 4 was serving as an assistant teacher and was also running a lottery institute. Lottery.
He was running, my lord. When the department
in the
inquiry was
name of his
taken,
wife.
he was running a lottery institute. Because of that, D was held against him.
What is this lottery institute andre?
Lottery, ಒಂದು big name ಅಂತ lottery system ಇಟ್ಕೊಂಡು, he was operating that lottery which is against the conduct of the service rules, my lord.
Was running a lottery in the name of his wife and had deceived many teachers.
Yes.
Stop. A disciplinary inquiry was conducted against him and it was found that he was guilty of the charges. Full stop. He also submits that the respondent number 4 challenged the order of the disciplinary authority before the Karnataka State Administrative Tribunal, application number 20641/2021. And the said application was allowed in part and the punishment is imposed by the disciplinary authority was modified. Full stop. It is therefore contended that as per the bylaws of the respondent number 2, the respondent number 4 has ceased to continue as the member of this respondent number 2. Full stop. Imprisonment ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
ಮತ್ತೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 6 ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದಿರಾ?
That is also one kind of punishment that is, please, Lord.
Paragraph number 6 of your petition, ಓದಿ ಏನ್ ಹೇಳಿದೆ?
Yes, Lord.
Imprisonment.
He is being punished.
Yes.
ಎಲ್ಲಿದೆ
With
punishment?
fine 39(2)K of the act, my lord.
Sir, he is being punished and conviction ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
Not conviction, that withholding increments is also punishment according to me, my lord.
Contended that the respondent number 4 therefore not entitled to contest the elections to the board of directors. Nonetheless, the respondent number 3 nonetheless, the respondent number 4 had submitted his nomination and the respondent number 3 was in the process of accepting it. Therefore, the petitioner is before this court seeking
There is one authority of the Allahabad High Court, my lord,
for
regarding moral turpitude.
in the nature of mandamus to direct the respondent number 3 not to entertain the nomination of the respondent number 4. Next para. The learned counsel for the petitioner submitted that the bylaws provide that any member suffers disqualification if he is convicted of any offense of moral turpitude. He submits that the order of the disciplinary authority as modified by the appellate administrative tribunal convicted the petitioner of the allegations made against him, and therefore the petitioner suffered disqualification. Thus he submits that the respondent number 4 cannot be permitted to file his nomination. Per contra, the
There's
learned
one
counsel for-
authority of Allahabad High Court.
Stop. In support of this
Madam.
contention, he relied upon the judgment of the Allahabad High Court
Yes.
in
Para 4 ನಲ್ಲಿ regarding moral turpitude.
Mangali versus Chatkilal and others.
Yes.
Year 1963, Allahabad 527. And contended that the word moral turpitude is not defined anywhere, but has to be construed as meaning anything contrary to justice, honesty, modesty, or good morals. He therefore submits that the respondent number 4, having suffered an order of the disciplinary authority for conducting a lottery despite being employed as an despite being employed with the state government, has to be construed as having been convicted for an offense of moral turpitude. Full stop. Per contra, the learned counsel for the respondent number 4 submits that this writ petition has become infructuous as the nomination of the respondent number 4 is already accepted, and the elections that were held to the board of directors was declared
On 5/1/2025.
on
5/1/2025.
5/1/2025, and that he is elected as a director. Further, he submits that the petitioner is not the respondent number 4 is not convicted of any offense involving moral turpitude, and therefore the respondent number 4 has not suffered any disqualification under the bylaws. Next para. The respondent number 4 did not dispute the fact that a disciplinary inquiry was initiated against him on the allegation, on the charge that he was conducting a lottery in the name of his wife and that he had cheated many teachers. Full stop. The disciplinary authority had passed an order of, had imposed punishment of reduction of 4 increments with cumulative effect, and had also declared a promotion holiday. Full stop. It is not in dispute that this order was challenged before the Karnataka State Administrative Tribunal in application number 20641/2021. 20642/2021. Vinod Kumar Ratnakar, Arjun Gangu.
There were 2 appellants.
Full stop.
Yes.
The tribunal, in terms of its order dated 23/8/2023, modified the punishment imposed by setting aside the punishment of postponing the promotion for a period of 4 years. Full stop. Next para. The contention of the learned counsel for the petitioner that this amounted to an conviction for an offense involving moral turpitude, cannot be accepted for the simple reason the respondent number 4 was accused of misconduct for having conducted business even while being employed under the state government. Full stop. The allegation against him was one of misconduct, and till date there has been no offense registered against him, and he is not convicted of any offense involving his moral turpitude. Therefore, the contention of the petitioner cannot be accepted. Even otherwise, since the respondent number 4 is now elected as a director of the board of directors, the appropriate remedy for the petitioner is to challenge this election in accordance with law. In that way of the matter, this petition is dismissed. However, liberty as mentioned above is granted.
Like.
Sudha D. Sudha D. R3 ಯಾರು? ಗ್ರಾಮ ಪಂಚಾಯತ್. Await till 1 week. 1 week time is granted to do the needful. Sangana Basava Patil, list after service of notice to respondent number 1.
Stay may be extended.
Interim order granted or is extended. Correct.
Much.
Basuraj, correct D.
My lord, the state has to file objection, my lord. On 10th December, state was asked to give its response.
Learned AGS seeks time to file.
Yes, ma'am.
Statement of objections. List on
20.
23.
27, my lord.
ಯಾವತ್ ಬೇಕಾಯ್ತು? Deepak Barad,
Needful will run in a day's course.
the learned counsel for the petitioner undertakes to pay the process during
Today
the
it's-
course of the day.
Yes,
If process is paid, office is directed to issue notice.
no, there is interim order. On
ನಾ
last-
ಈ ತರ ಸ್ಟೇ ಕೊಟ್ಟು ನೀವು ಪ್ರೋಸೆಸ್
ಇಲ್ಲ,
ಕೊಡ್ತಿದ್ರಿ ಹೆಂಗೆ? When was the interim order
last,
granted?
13/12, my lord. 13.
13/12. 1 month is already gone.
I will today itself.
The process ಕಟ್ಬಿಟ್ಟು ಬನ್ನಿ. Yes, next. 24. List after service of notice to respondents 4 and 5.
21st, my connected matters are also posted.
Huh?
Connected matters are posted on 21, my lord.
20?
1.
LV ಯಾವತ್ ರೀ? 21 ಯಾವತ್ ನೋಡಿ? ಆಯ್ತು. List on 21.
My lord, in this case, on the last occasion, the counsel for the petitioner had made a submission that they have not filed appeal in first and third case. They already filed appeal, my lord.
Is it-
And we have filed objections also to the appeal, my lord.
What
My
is
lord,
it?
we have filed the objections also to the appeal.
Yes, Mr. Mali Patil.
And the reply was given on 4/10.
ಹಾಕಿದಾರಂತಲ್ಲಪ್ಪ statutory appeal.
My lord, kindly see, my lord, last date of hearing, this honorable court has given direction. Last date of hearing, my lord.
Order sheet.
The last date of hearing, my lord, the government advocate to.
There are reasons for rejection of technical bid.
That is already given, my lord. On 4/1/2012 itself, the reasons have been given and a letter has been returned to them, my lord.
What do you want,
And
Mr.?
they have filed appeal, my lord. They made a false submission.
Appeal ಹಾಕಿದಿರಂತಲ್ಲ.
My lord, only one appeal, my lord, in
In all three cases.
3 appeal ಹಾಕಿದಿರಂತೆ.
my
What
lord,
do you want to do?
my lord, I will verify, I will take instruction, my lord, I will take submission next date of
No,
hearing.
no, I will not adjourn it.
Meanwhile, my lord, I have, as per my instruction, my lord, serial number 26 is concerned, my lord, I have filed the appeal.
In other
26,
cases.
so
7 is concerned, my lord, there is no any
Pass.
rejection order, my lord.
pass over. Please
Yes,
find
sir.
out. Pass over. 27, all pass over.
3 matters.
Petition arising out of the order passed by the second respondent and the appellate authority under eviction of unauthorized occupants.
Is serial number of attention.
Lordship,
The office objection at serial number 17 is
17,
serial number of attention is not. Serial number of attention is not forthcoming in the affidavit.
ಅದು ನಂಬರ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿ ತಾಲೂಕಾ ಕೋರ್ಟ್ನಲ್ಲಿ ಮಾರ್ಕ್ಸ್ ತರಿಸಿದೆ.
Attention ಅಂದ್ರೆ? Attestation.
ಅಟೆಸ್ಟೇಷನ್ ನಂಬರ್ ಅವ್ರದ್ದು ನಂಬರ್ ಹಾಕಿಲ್ಲ ನೋಟರೈಸ್ ನಂಬರ್.
Purple. Office
Noting.
objection at serial number 17 is overruled. Book entry ಹಾಕ್ಬೇಕಲ್ವಾ?
ತಾಲೂಕಾ ನೋಟ್ರಿ ಅಲ್ಲೇ ಮಾಡಿ ಕಳಿಸಿ
ಇರಲ್ವಾ?
ಇರ್ತದೆ ಬಟ್ ಬೈ ಇನ್ವರ್ಟನ್ಸ್ ಇಟ್ ಅಪಿಯರ್ಸ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಮೆನ್ಷನ್.
Overruled. However, in the event of any dispute of the signature of the petitioner in the affidavit, comma, affidavit in any other proceeding, comma, the affidavit filed in this writ petition shall not be referred.
Yes, yes.
Office objection, seal number 27 is overruled. Yes, what is the case?
Lordship, this is a order challenging the order passed by the district judge, being the appellate authority under the Public Premises Eviction of Unauthorized Occupants Act. What has happened in this case, admittedly, these petitioners and others are the occupants as a tenant, and from 2010. And it was, their lease was extended from time to time. And even in the, immediately after the COVID period also it was extended. And 2023, up to 2023, it was extended. Thereafter, on 8/11/2023, MLA Sindhanu wrote a letter to Ministry Rural Development Panchayat Raj for seeking extension of the lease period for another 2 years. And that was taken up by the committee, and the resolution was passed. That resolution was forwarded to the taluka officer, to the chief executive officer, Jilla Panchayat, who in turn forwarded to the commissioner of the commissioner, Jilla Panchayat.
Time to vacate.
Lordship, in another connected matter,
Ah.
this series of same arising same, this court has granted stay. Once,
Time ಎಷ್ಟು ಬೇಕು ಅಂತ ಹೇಳಿದೆ ಬಿಲ್ 6 months.
yes, we'll make arrangement for that. Specific time ಕೊಟ್ಟಿಲ್ಲ ಅದರಲ್ಲಿ, but stay matter has been stayed.
Will grant you 6 months time provided to file an affidavit.
Yes,
Notice ಹೋಗಿಲ್ವಾ?
no, first time.
ಯಾರು ಸಿಂಧನೂರು ತಾಲೂಕ್ ಪಂಚಾಯತಿನಿ ಅಡ್ವೊಕೇಟ್
ಅವ್ರು ಯಾರಿದ್ದಾರೆ?
ಆ ಕೇಸಲ್ಲಿ ಅಪ್ಪೇರ್ ಆಗಿದ್ದಾರೆ ಯಾರಾದ್ರು? ಸಿಂಧನೂರು ಹಾ? ಸಿಂಧನೂರು ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಯಾದವ್
ಇಲ್ಲ, ಯಾರು ಅಪ್ಲೈ ಆಗಲ್ಲ ಸರ್.
Notice ಆಗಿಲ್ಲ.
ಯಾರು ಇಲ್ಲ, ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇದೆ.
ಯಾರು ಇಲ್ವಾ?
Notice ಆಗಿದೆ.
Issue emergent notice to the respondents till the next date of hearing, comma, the impugned order passed by the respondent number 2 and confirmed by the third additional district and sessions judge Raichur, sitting at Sindhanur in MA 5025 of 2024 is state. List on date put 2 weeks with.
Yes. Down. 17
This list WP number is 203865 of 2024 along with these petitions. Elladallu same order. Same as all cases are same. Yeah. 43. Mr. KM Gate. Notice ಹೋಗಿಲ್ವಾ?
A week's time.
Notice
To take steps for some of the respondent.
process ಕೊಟ್ಬಿಡಿ ಇವತ್ತು.
Yes, madam. Today only I will pay.
ಕೊಡಿ pass over.
Please.
44. Notice ಹೋಗಿದ್ಯಾ? Issue notice on IA number 123 of 2024. The notice issued to respondent number 1 is not claimed. The address of the respondent number 1 mentioned in the cause title of the writ petition corresponds with his address mentioned in the cause title of the suit before the trial court. Hence, notice to R1 is held sufficient. Office is directed to show his name in the cause list. Yes.
Here for the petitioner,
Ah,
government was directed to call for bring the records, my lord, with respect to the petition.
yes, government.
My lord, 1 week time may be granted. I will
And
send it.
AGA seeks time to comply the order dated 18/12/2024 as a last chance
Yes,
response.
ma'am.
Date good. Sachin Mahajan.
Date. Please.
Same case,
ma-
man. Senior Councillor Ravi Arma Kumar submitted, it is infractuous something.
ಅಯ್ಯೋ ಸಚಿನ್ ಮಹಾಜನ್ ಯಾಕೆ ಬರೋದೇ ಇಲ್ಲ ಅವರು
ಇಲ್ಲ ಬಂದಿದ್ದಾರೆ ಇವಾಗ, today has come.
ಪಾಸ್ ಓವರ್
Such
ನೀವು ಎಸ್
Matter more pertaining to
ಸೀನಿಯರ್
floating of tender.
ಹ್ಮ್
Initially, my lord, a notification was issued for my lord digging 65 mm dia borewell under Ganga Kalyana scheme.
ಹಾ
Then, my lord, there was a clause in the tender document that a pre-bid meeting would be called. In the pre-bid meeting, my lord, grievance would be accepted and, my lord, if necessary, changes would be made. Then, my lord, what they did, my lord, they issued a fresh tender, not a fresh tender notification, revised tender notification, not making certain changes. Even those changes, my lord, are not in consonance with the requirements, is, my lord, now the submission of the petitioner. Now, the amended petition, my lord.
ಹ್ಮ್
Lord, I'm slightly indisposed of, my lord. I'm so probably not well, my lord. I'm sorry.
ಹೂ ಇಸ್ ನಾಟ್ ವೆಲ್
I'm not well, my lord.
ಯು ಆರ್ ನಾಟ್ ವೆಲ್
I'm not well.
ಯು ಆರ್ ಡೀಲಿಂಗ್ ವಿತ್ ದ ಕೇಸ್ ರಿಲೇಟಿಂಗ್ ಟು ಬೋರ್ವೆಲ್ ಅಂಡ್ ಯು ಆರ್ ನಾಟ್ ವೆಲ್
I was down with fever, my lord, for a couple of days. I did not even come to the court.
Ah.
Probably, my lord, unable to take a grip of the situation.
ಎಂ
No.
ಫೀವರ್
My lord,
ಇಸ್ ಇಟ್ ಎಂ ಫೀವರ್
I don't know, my lord, but there's a lot of weakness, my lord.
ಮನಿ ಫೀವರ್
No, my lord.
ತುಂಬಾ ದುಡ್ಡು ಜಾಸ್ತಿ ಆದ್ರೆ ನೆಗಡಿ ಆಗುತ್ತೆ ಅದಕ್ಕೆ
That fever would always be there, my lord.
ದಟ್ ಯು ಲವ್
Everybody, my lord. If I, my lord, may kindly, my lord, gather myself and make submissions, my lord, may
ಪಾಸ್ ಓವರ್
kindly, my lord.
ಪಾಸ್ ಓವರ್
The Passover,
ಪಾಸ್
Passover, I have
ಓವರ್
some difficulty.
ಏನೋ ಹುಷಾರಿಲ್ವಂತೆ ನೋಡಿ ಹೇಳ್ತೀನಿ ಅಂತ
ಅಲ್ಲ
ಹೇಳ್ತಾರೆ
ಅವ್ರಿಗೆ ಇನ್ನೊಂದ್ ದಿವಸ ಕುಡಿ ತೊಂದ್ರೆ ಇಲ್ಲ. If he pleads indisposition,
ದಿನ ಬೇಕಂದ್ರೆ
ಇನ್ನೊಂದ್ ದಿವಸ.
My lord,
you want some other day.
concluded.
Senior counsel had said that this writ petition has become infructuous. You please convince the court as to how petition survives. If a
One day
fresh
also.
notification is already issued, then we can close it. Barcode.
It becomes more of a academic exercise.
The petitioner has challenged a tender notification, and during the pendency of this writ petition, the a revised tender notification was issued. Full stop. Therefore, this writ petition does not survive for consideration. Accordingly, the petition is dismissed. If the petitioner is eligible to apply against the revised tender,
My lord, that says.
No, that opportunity was given, he has not applied.
oh, he has not
That
applied.
opportunity was given.
Full stop. Since the petitioner has not applied against the revised tender, comma, this writ petition does not survive for consideration. Accordingly, the petition is dismissed as it does not survive for consideration. Sorry for keeping you waiting, Mr. Senior Counsel. ಎರಡ್ ಸತಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡಿದ್ದೀವಿ ಆಗ.
ಹೌದು.
Yes.
In fact, matter was fully heard.
No, I do not know. Sachin was not well. He was not there in the court 1 or 2 dates. We have forced you to log on to the video conference, though you said on the last date that you will not be in station.
Actually, I stayed back because my clients are very anxious. Thousands of borewells are stuck because of the writ petition.
ಹೋಗ್ಲಿ ಬಿಡಿ, ಒಳ್ಳೇದಾಯ್ತು. Yes.
Please.
Yes. Mr. Danappa P.
The petitioner is retired as a professor. The imposing two punishment, that is withholding 2 increments, and also suspension period was not regularized. If the conduct that is annexure B, page number 15, the punishment was not proved by the department. That is para number, last para, page number 15. ಶ್ರೀ ಶಿವಕುಮಾರ್ ಮಾಲಿ ಪಾಟೀಲ್ ನ್ಯಾಯವಾದಿಗಳು ಕಲಬುರಗಿ ಇವರು ತಮ್ಮ ಪತ್ರದ ದಿನಾಂಕ 30/4/2020 ಮೂಲಕ ಸದರಿ ಪ್ರಾಧ್ಯಾಪಕರ ಇಲಾಖಾ ವಿಚಾರಣೆಯಲ್ಲಿ 6 ಚಾರ್ಜುಗಳಲ್ಲಿ 1 ಚಾರ್ಜ್ ಸಾಬೀತಾಗಿದ್ದು ಉಳಿದ 5 ಚಾರ್ಜ್ ಸಾಬೀತಾಗಿಲ್ಲ ಎಂದು ತಿಳಿಸಿದ್ದಾರೆ. ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ಸದರಿ ಪ್ರಾಧ್ಯಾಪಕರು ಹ್ಯಾಸ್ ವೈಲೇಟೆಡ್ ರೆಗ್ಯುಲೇಷನ್ 5.2 of the regulation governing PhD degree program has he tried to take a candidate exceeding the quota as per the other charges. They are not directly convicted with the Dr. Bidiger for lack of complete evidence. ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ವಿಚಾರಣಾ ವರದಿಯನ್ನು ದಿನಾಂಕ 27/3/2018 ವಿಷಯಕ್ಕೆ ಸಲ್ಲಿಸಿದರು. ವಿಶ್ವವಿದ್ಯಾಲಯದ ಪ್ರಾಧಿಕಾರ ಸದರಿ ಪ್ರಾಧ್ಯಾಪಕರು ಸಲ್ಲಿಸಿದ ವಿಚಾರಣೆ ಮೇಲೆ ಯಾವುದೇ ಕ್ರಮವನ್ನು ಕೈಗೊಂಡಿರುವುದಿಲ್ಲ. If it is only a minor misconduct which can be extorted by the disciplinary authority, and his pension and other service benefits may be fixed regarding pendency of the SCST atrocity criminal case in which police has already filed final report to the court, so that cannot be an impediment for settlement of the pension ಎಂದು ಕಾನೂನು ಅಭಿಪ್ರಾಯವನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹೆಚ್ಚಿನ ವಿಚಾರಣೆಗಾಗಿ ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರ ಹೆಸರು ಮತ್ತು ವಿಳಾಸ ಕೋರಿದ್ರು. ಅದರ ಬಗ್ಗೆ ನ್ಯಾಯವಾದಿಗಳು ಯಾವುದೇ ಉಲ್ಲೇಖ ಮಾಡಿರಬೇಕು. ಅದರಲ್ಲಿ ಅವರು ಪನಿಷ್ಮೆಂಟ್ ಏನಪ್ಪಾ ಅಂದ್ರೆ ವಿಥೌಟ್ ಅದರಲ್ಲಿ ಡಿಸಿಪ್ಲಿನರಿ ಫೈಂಡಿಂಗ್ಸ್ ಇಲ್ಲದೆ ಏನಪ್ಪಾ ಅಂದ್ರೆ 2 ಇನ್ಕ್ರಿಮೆಂಟ್ ಅನ್ನು ಹೆಲ್ಡ್ ಅಪ್ ಮಾಡಿದ್ದಾರೆ. ಸಸ್ಪೆನ್ಷನ್ ಪೀರಿಯಡ್ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಕೊಟ್ಟಿಲ್ಲ. ಲಾಸ್ಟ್ ಇದು 17 ಪೇಜ್ ನಂಬರ್ 17ರಲ್ಲಿ ಇದು 5 ಸೀರಿಯಲ್ ನಂಬರ್ 5 ವೇತನ ರೂಪಾಯಿ 6,759 ದಿನಾಂಕ 16/6/2017 4/7/2018 ಅಮಾನತಿನ ಅವಧಿಯನ್ನು ಹೊರತುಪಡಿಸಿ ಉಳಿದ ವಾರ್ಷಿಕ ವೇತನ ಬಡ್ತಿಗಳನ್ನು ದಿನಾಂಕ 6/8/2020 ಮಾನ್ಯ ಕುಲಪತಿಗಳು ಅನುಮೋದನೆ ನೀಡಿದೆ. ಪ್ರಯುಕ್ತ 17ರ ವಾರ್ಷಿಕ ವೇತನ ಬಡ್ತಿಯನ್ನು ತಡೆ ಹಿಡಿಯಲಾಗಿದೆ. ನೆಕ್ಸ್ಟ್ ವೇತನ
ಗುಲ್ಬರ್ಗಾ ಯೂನಿವರ್ಸಿಟಿ ಯಾರು ಹುಸಾರೆ
ಅದೇ ಇವರು ಸುದರ್ಶನ್ ಲಾಸ್ಟ್ ಮೊಮೆಂಟ್ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಟೇಕ್ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಸುದರ್ಶನ್
ಎಂ ಸುದರ್ಶನ್ is directed to accept notice for respondents 1 and 2. Interim stay of the order. Next year B. Till the next date of hearing. List on. This 22. Much 22/1.
22/1
Copy serve ಮಾಡು.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ, ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಅಪಿಯರ್ ಆಗಿದ್ರು ಸ್ವಾಮಿ, ಅವ್ರದ್ದು ಏನೂ ಇಲ್ಲ ಸ್ವಾಮಿ.
Notice
ಸಬ್ಮಿಷನ್
ಆಗಿದೆಯಾ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಸಬ್ಮಿಷನ್ ಫೈನಲ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಸ್ವಾಮಿ ಅಷ್ಟೇ.
ಎಂ ಸುದರ್ಶನ್
ಅದ ಡಿಸ್ಪೋಸಲ್ ಸ್ವಾಮಿ ಅಷ್ಟೇ.
ಎಂ ಸುದರ್ಶನ್ seeks time to file objections. ಸ್ಟೇನು ಆಗಿದೆಯಾ ಲಾಸ್ಟ್ ಟೈಮ್
ಇಲ್ಲ ಸ್ಟೇ ಏನಿಲ್ಲ ಸರ್, ಆಲ್ರೆಡಿ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು. ಪೆನ್ಷನ್
ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ
ಮಾಡಿ ಹೋಗಿದ್ದಾರೆ. ಸಸ್ಪೆನ್ಷನ್ ಪೀರಿಯಡ್ ಮಾತ್ರ ಪೆನ್ಷನ್ ಕೊಟ್ಬಿಟ್ರು.
Mr.
ಆದ್ರೆ
Sudarshan,
ಇದ್ರಲ್ಲಿ
M. Sudarshan is that seeks time to secure instructions. List on 20th.
22 ಫಾರ್ ಡಿಸ್ಪೋಸಲ್ ಸರ್.
Disposal.
ಮಚ್
Mr. Dorairaj BH.
Petition. This is a matter, electricity matter, where one time non-refund.
Button up your coat, mister.
Sorry, madam.
ಕೂತಿದ್ದಾಗ ತೆಗಿಬೇಕು, ನಿಂತಾಗ ಬಟನ್ ಹಾಕ್ಬೇಕು. ಎಸ್
Sorry, madam.
ಸಾರಿ ಎಲ್ಲ, ಇಟ್ ಡಸಂಟ್ ಲುಕ್ ನೈಸ್ ಆನ್ ಯು ಅಷ್ಟೇ. ಯು ಆರ್ ವೆರಿ ಸ್ಮಾರ್ಟ್. ಕೋಟ್ ಹಂಗೆ ಹಾಕ್ಬಿಟ್ರೆ ಆ ಸ್ಮಾರ್ಟ್ ಆಗಿರೋದೆಲ್ಲ ಹೋಗ್ಬಿಡುತ್ತೆ.
Common infrastructure charges has been imposed by Karnataka KPTCL on a petitioner. Petitioner has commissioned the project in 2015, my lord. Commissioning certificate at page number 23. And the impugned annexure is annexure A. The demand charges are page number 21, my lord. So the commissioning certificate is at page number 22. At page 23, next page, your lordship will get commercial operation date 9th December 2015. It is there, my lord. At 5th line.
Page 22 ನಲ್ಲ?
23, my lord, 23 line.
23 is some table, matrix.
ಅದ್ರ ಮೇಲೆ, my lord, ಅದ್ರ ಮೇಲೆ COD ಅಂತ ಇದೆ ಅಲ್ಲಿ. Commercial operation date.
Yes.
2015 ಅಲ್ಲಿ ಆಗಿದೆ ಸ್ವಾಮಿ. So annexure C is the next page, my lord. 17/8/2012. This is the order of KPTCL which imposes common infrastructure charges. At para 2, my lord, at the same page,
24, the proposal provides for the creation of infrastructure at the cost of the applicant on KPTCL premises on payment of one-time non-refundable fee from IPP NCE project developers as per the formula. Based on this, I have developed my project by paying the common infrastructure fees, my lord. At page number D,
Page number D now.
sorry, my lord, page number 27, annexure D. This is a evacuation approval granted. If I pay all these charges, evacuation approval will be granted. At page number 29, my lord, X anta admele ide ಒಂದು para. This regular evacuation approval is issued for the purpose of facilitating early commissioning of the project. And interconnection request will be considered only after completing the regular evacuation approval. So I complete all of that. And they issue evacuation approval at page number 31, annexure E, my lord. In which interconnection is happened on 19th January 2016, my lord. At page number 31. Now, this being the case, KPTCL issues one common infrastructure order dated 3/9/2020, which is at page number 34, annexure F. This is with respect to common infrastructure project, my lord. The order is at page number 35. The order is respectively on the left-hand side and dated is 3/9/2020. This came to be challenged in the writ petition, which is at page number 38, my lord, annexure G.
Yes.
At page number 44 is the operating part. I'll read, my lord. The issue has now that driven to the petitioner to this court is the two orders that are passed by first respondent, that is KPTCL, on 3/9/2020. This is the order that I previously read, my lord.
Yes.
Now, this writ petition came to be dismissed. At page number, my lord, 69. 68 and 69 is the operating order. Writ petitions are dismissed or not entertainable. The same came to be challenged in writ appeal, my lord. At page number 70, annexure H. Now, my lord, page number 82 is the operating part, my lord.
Yes.
82, para 8. The relevant extract of section 62(1) of the Act reads as follows. Determination of tariff. Appropriate commission shall determine the tariff in accordance with the provisions of this Act for the supply of electricity by generating company to the distributive licenses. The entire section is followed by that, my lord. In which, my lord, thus, power to determine the tariff in accordance with the provision of the Act lies with the appropriate commission.
Yes.
Therefore, the order which I read, passed by the KPTCL, does not stand by law. Therefore, at page number 84, my lord, sorry, my lord, page number 85, last paragraph, page number 85, for the aforementioned reasons, order dated by 25/6/21, single judge, passed by the single judge in WP number so and so, cannot be sustained in the eye of law. It is accordingly set aside. However, it is open for the corporation to take an action to levy for one-time refundable charges towards the infrastructure. Or order na quash ಮಾಡಿ KPTCL go before the appropriate commission ಅಂತ liberty ಕೊಡ್ತಾರೆ, my lord. They go before the Karnataka KERC, and at page number 87, annexure J, KERC passes an order permitting KPTCL to demand infrastructure charges. Now, how they permit, page number, my lord, whether it can be permitted retrospectively is the question answered by KPTCL, sorry, KERC, my lord.
But why don't you produce some document to show that you have paid the money?
My lord, I have not paid the money, my lord. I'm seeking a stay of this demand.
You said that you have paid the one-time whatever infrastructure fee.
My lord, that is not disputed, my lord.
Well, that is not, where have they said that you have paid the
I have
money?
paid, my lord. The document I have not produced, in which I have averment I have made, my lord. At
Where do the respondents say that
my
you
lord,
had?
my lord, in the respondents annexure A, they are not saying my one time for creation of a terminal bay, they are not demanding. It's a new thing that they have charged called common infrastructure, which cannot be applied retrospectively, is a KERC order altogether. And the same has been clarified by KPTCL in their own clarification letter, my lord, at page number 114, annexure L. Inviting reference to your letter wherein clarification was sought regarding collection of charges from the existing generators towards the usage of KPTCL common infrastructure of the generators. Now, my lord, in this regard, I hereby directed to inform to collect the common infrastructures charges from the generators who have applied on or before 23/5/2023 and is yet to interconnect with KPTCL grid. I showed my letters which are given in 2014. Interconnection approval have been happened. My interconnection has happened and generating is started in 2015. This being the case, annexure A, which is imposed on me retrospectively, does not stand in law, even by what is clarified by KPTCL and passed by KERC, my lord.
Is there no appeal against this order?
No, my lord.
No appeal?
No appeals.
Purport, issue emergent notice. Yar is there others? KPTCL.
KPTCL and JESCOM.
Sir Ravindra Reddy. KPTCL yaru?
Arun Kumar Amargundappa iದ್ದಾರೆ.
Arun Kumar Amargundappa is there to accept notice for respondent.
JESCOM ಇದೆ.
JESCOM ಇದೆ.
JESCOM Krupasagar Patel ಇದ್ದಾರೆ.
Ravindra Reddy ilva?
Ravindra Reddy also there, my lord. ಅವರು ಇದ್ದಾರೆ.
Gopal Krishna B. Yadav, you are there.
ನಾವು ಇದೀವಿ.
Gopal Krishna Yadav is there to accept notice for respondent number 2. Till the next date of hearing, the impugned order. The order passed by the Karnataka Electricity Regulatory Commission dated 23/5/2023 in OP number 7/2022 shall not be made applicable to the petitioner. This on date could.
My lord, annexure A stay.
Annexure A. What is annexure A?
That is the demand notice, my lord, without giving opportunity.
Stay of annexure A ಅಂತ ಮಾಡಿ sir.
Much
Next.
obliged.
Mr. Manvendra Reddy.
My lord,
EP Ambekar.
please.
Here is, my lord, a suit, a sister have filed a suit for partition separate question in respect of agricultural land to the extent of 2 acres and odd. It was decreed, my lord. And it has reached finality.
Yes.
Unfortunately, my lord, this land was converted much before filing the suit. Is unnoticed by everything, and in the entire extent of 2 acres, a commercial buildings are come up.
How do you undo it?
Now, the commissioner, ADL Tasildar has been given a warrant. So that property is a commercial property now. CTS number, municipal number were given.
But why did you keep quiet?
Adke 1/8 share somewhere will, the shares are charged out between the brothers and sisters. Probably because even 1/8 share cannot be divided, cutting the building and giving to that petitioner. Therefore, a compromise talks are going to be placed, my lord. Last time also, he also requested.
Is talks going on?
Is the FDP proceedings, my lord. The court commissioner is appointed. My humble submission, if there is any objection to the appointment of the commissioner, that may be filed before the trial court and let the.
Okay, he says that some compromise talks are on.
ಯಾಕಂದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ಲಿ ಆಗೋದಿಲ್ಲ because
They have
I
to
have
verify.
filed the photographs.
Learned counsel for the petitioner submits that in view of the complexity of the issue, the parties are trying to work out a settlement.
Yes,
Hence list on yavat ಬೇಕು ಹೇಳ್ರಿ.
3 weeks,
Huh?
3 weeks.
2 weeks.
ಯಾವತ್ತು ಬೇಕಾದ್ರೆ ತಗೋ.
3 weeks.
3 weeks ತುಂಬಾ ದೂರ ಆಗುತ್ತೆ.
ಇಲ್ಲ ಬ್ರದರ್ಸ್ ಇದಾರೆ ಸ್ವಲ್ಪ ಕೂಡ್ಬೇಕಲ್ಲ ಮಲ್ಲ.
ಅಲ್ಲ ಯಾವತ್ತೊಂದು ಶಾರ್ಟ್ ಡೇಟ್ ತಗೊಳ್ಳಿ ಏನ್ ಸೆಟಲ್ಮೆಂಟ್.
3 weeks ಏನ್ ಮಾತಾ ಸ್ವಲ್ಪ ಇಶ್ಯೂ ಸ್ವಲ್ಪ 7
yes.
One more submission, my lord. There was no interim order actually, but it was
understanding.
No interim order is next.
No, it is understanding that they will not to reciprocate ಹೇಳಿದ್ರು last time.
it was inadvertently extended, so my submission is at the same minute.
ಏನ್ ಮಾಡೋದು ಹೇಳಿ. If you had undertaken that
No,
you
no,
not
my lord.
precipitate,
We had not
Charge
undertaken.
sheet.
That's the reason I am submitting.
so what was stated on the last date?
Interim order, if any is granted anta agide Swami, but it was inadvertent.
No interim order was granted.
No, it was not
Forward.
granted.
Since no interim order was granted, when the petition was listed, but no interim order was granted, comma, the order dated 18/12/2024 extending the interim order shall not be given effect to.
Much of.
So that understanding maybe.
Don't precipitate the matter.
Yeah, that is.
I'll seek next, I'll seek
Uh,
instruction, please.
Yes, next. Yashas
My
Dikshit.
lord, memo today is,
Huh?
Yashas, I have to give memo, my lord. Everything is ready, my lord.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
ಎಲ್ಲ ಅವ್ರ ಪ್ರೆಸೆನ್ಸ್ ಎಲ್ಲ ಇವತ್ತು.
I will ask one of my colleague to take the documents. Your
Yes,
Lordships.
my
If
lord.
it is furnished, I will ask my colleague to take.
No, will you come or shall I close it?
Your Lordships, I will ask I am out of the station for for some reason. I'll ask my
Well-
colleague to be present and seek the memo from.
Pass over.
Yes,
Please.
my lord.
Yes.
My lord.
Arun
52.
Kumar.
Last date of hearing, honorable court directed to secure records. 1 week time I have granted, I will secure record.
Learned counsel for the learned AGA seeks time to comply the order dated 27/11/24. List on ಯಾವತ್ ಬೇಕು ಹೇಳ್ರಿ. ಸುಮ್ನೆ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಬೇಡಿ
ಇಲ್ಲ, my lord, I
ದಯವಿಟ್ಟು.
will secure, my lord.
ಸುಮ್ನೆ ಲೆಟರ್
Yes.
ಬೇರೆ ಯಾರಿಗಾದ್ರೂ ಒಂದು ಆಪರ್ಚುನಿಟಿ ಹೋಗುತ್ತದೆ. Yes, Mr. Sachin Mahajan.
Please.
28.
Amresh
Lord,
Rose.
appointment as associate professor
Huh?
in University of Agricultural Sciences at Raichur.
Sealed cover.
Hmm?
It's in the last date of hearing, my lords. But there was an understanding that, my lords, the sealed cover needs to be
That
opened.
understanding, I think, was before the
Sealed
judge which has
cover?
released the matter. What
Sealed
happened, my lord, the matter was heard in detail, my lord, by my lord's predecessor. And my lord, in fact, it was parted. A sealed cover was supposed to be filed and my lord, that did not happen. However, my lord, the matter is now released from parted.
ಆಯ್ತು ಹೇಳಿ.
Now, matter pertains to my lord, appointment of petitioner as associate professor, my lord, in the University of Agricultural Sciences at Raichur. I may invite your lordship's attention to annexure A1 at page number 10, my lord. Notification dated 1/8/2016.
Yes.
The next page at page number 11, your lordship may kindly turn to. In that, my lord, under the heading B, Associate Professor Kedar. Name of the post Associate Professor, Hyderabad, Karnataka, there is, my lord, under local Kedar, there are around 45 posts, my lord. And my lord, non-Hyderabad, Karnataka, NHK, that is, my lord, that is also called as residual, my lord, parent Kedar. That has around 13 posts, my lord. Now, the system is such, my lord, that for Hyderabad, Karnataka, local cadre, my lord, absolutely no concurrence from the finance department is required. And immediately, my lord, after finalization is made, my lord, the authorities are well within their, my lord, power to make appointment orders. Now, it so happened, my lord, that these 13 persons, financial approval for non-HK was required and, my lord, the file was sent to the concerned board. They undertaken notion, my lord, that financial concurrence is required not only for non-HK but for also HK. They pass an order, my lord, holding that since 3 years have lapsed, we have to issue fresh notification. In the process, what has happened, my lord? Interview was conducted. The whole process, my lord, of there was, my lord, notification, there was applications were scrutinized, interview letter was called, interview was conducted. Results are also, my lord, kept in sealed cover. When at that stage, for non-HK, my lord, financial concurrence is required, and for HK, financial concurrence is not required. Under the mistaken notion, my lord, they pass an order stating that since financial concurrence is not given for 3 long years, we will withdraw this. Now that is challenge, my lord. In a nutshell, I have submitted this. My lord, how this is illegal, my lord, I may be able to, my lord, persuade your lordship. Whether concurrence is required or not, my lord, with regard to that, along with a memo, my lord, I had filed certain documents. Memo dated, my lord, 15/7/2024, which is filed subsequently, my lord.
Yes.
There is a notification dated, my lord, 6/11/2013, bearing number, my lord, DPAR 6 PLX 2012. Does my lord find it? In that, your lordship may kindly turn to the heading, my lord, Karnataka Public Employment Reservation and Appointment of Hyderabad, Karnataka Region Order 2013. The relevant portion, my lord, would be at page number 7, my lord. Handwritten page number 7, item number 10, my lord.
Yes.
Overriding effect. Number 1, provisions of this order shall have effect notwithstanding anything contained in any act or rules, regulations or bylaws made thereunder before or any other or after the commencement of this order in respect of direct recruitment or promotion to the post under the government or any local authority or body of organization. Concurrence of financial department shall be presumed for the direct recruitments and promotions under this order. No economic measure shall apply for reserved posts, so on and so forth. So concurrence, my lord, is presumed. Then, my lord, your lordship kindly turn to the next page. What was the communication that was sent, my lord, by the officials to which post, my lord, concurrence was required, my lord? 22/12/2017, there is communication at page number 10. Last page, paragraph, my lord. This is, my lord, ಮಿಕ್ಕುಳಿದ ವಿಷಯ ಮಿಕ್ಕುಳಿದ ವೃಂದಕ್ಕಾಗಿ ಹಾಗೂ ಒಂದೇ ಹುದ್ದೆ ಇರುವ ಅಧಿಕಾರಿಗಳ ಪ್ರಾಧ್ಯಾಪಕ ಹಾಗೂ ಸಹ ಪ್ರಾಧ್ಯಾಪಕರ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ಆರ್ಥಿಕ ಇಲಾಖೆ ಅನುಮೋದನೆ ಪಡೆಯುವ ಕುರಿತು. It is certainly not with respect to, my lord, the HK region, my lord. ಸದರಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಐ ರೀಡಿಂಗ್, my lord. ಸದರಿ ಸಭೆಯಲ್ಲಿ ಉಪಸ್ಥಿತರಾದ ಆರ್ಥಿಕ ಇಲಾಖೆ ಉಪ ಕಾರ್ಯದರ್ಶಿಗಳು ಇಲಾಖೆಯ 4 ಮತ್ತು 5 ಅಧಿಸೂಚನೆಗಳಲ್ಲಿ ಕ್ರಮವಾಗಿ ಮಿಕ್ಕುಳಿದ ವೃಂದ ಸ್ಥಳೀಯೇತರ ವಿಸ್ತರಣಾ ನಿರ್ದೇಶಕರು ಮತ್ತು ಡೀನ್ ಕೃಷಿ ಮಹಾವಿದ್ಯಾಲಯ ಭೀಮರಾಯನಗುಡಿ ಹಾಗೂ ಒಂದೇ ಹುದ್ದೆ ಇತರ ವರ್ಗಗಳನ್ನ ಇಂತಹ ಗ್ರಂಥಾಧಿಕಾರಿಗಳ ಹುದ್ದೆಗಳಿಗೂ ಹಾಗೆ ಮಿಕ್ಕುಳಿದ ವೃಂದಗಳ ಸ್ಥಳೀಯೇತರ ಪ್ರಾಧ್ಯಾಪಕರ 10 ಹುದ್ದೆಗಳು, ಸಹ ಪ್ರಾಧ್ಯಾಪಕರ 13 ಹುದ್ದೆಗಳು ಹಾಗೂ ಒಂದೇ ಹುದ್ದೆ ಇತರೆ ವರ್ಗವನ್ನು ಇಂತಹ ಪ್ರಾಧ್ಯಾಪಕರ 3 ಹುದ್ದೆಗಳು ಭರ್ತಿ ಮಾಡುವ ಕುರಿತು ಆರ್ಥಿಕ ಇಲಾಖೆಯ ಒಪ್ಪಿಗೆಯನ್ನು ಪಡೆಯುವುದು ಅಂಶವನ್ನು ಸಭೆಯ ಗಮನಕ್ಕೆ ತಂದಾಗ ವ್ಯವಸ್ಥಾಪನಾ ಮಂಡಳಿ ಸದರಿ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಲು ಆರ್ಥಿಕ ಇಲಾಖೆಯ ಒಪ್ಪಿಗೆಯನ್ನು ಪಡೆಯುವಂತೆ ಠರಾಯಿಸಿತು. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮಿಕ್ಕುಳಿದ ವೃಂದ ಸ್ಥಳೀಯತರ ಹಾಗೂ ಒಂದೇ ಹುದ್ದೆ ಇತರ ಮೇಲ್ಕಾಣಿಸಿದ ಹಾಗೂ ಹುದ್ದೆಗಳಿಗೆ ಆರ್ಥಿಕ ಇಲಾಖೆಯ ಅನುಮೋದನೆಯನ್ನು ಪಡೆಯಲು ತಮಗೆ ಈ ಮೂಲಕ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತದೆ. Again, my lord, there is another communication dated 11/12/2019 where, my lord, financial concurrence is required to ಅಧಿಕಾರಿಗಳು 3, ವ್ಯವಸ್ಥಾಪಕರು 10, ಸಹ ಪ್ರಾಧ್ಯಾಪಕರು 15. This is, my lord, purely pertaining to non-HK region where financial concurrence is required. Now, my lord, coming to the material that is placed on record along with the writ petition, your lordship, my lord, may kindly come to straight away, my lord, to page number 84, that is annexure F, my lord. In the light of these communications, my lord, how this matter has been dealt by, my lord, the Board of Management of University of Agricultural Sciences, my lord, which is empowered, my lord, to
Annexure F.
Annexure F, my lord, page number 84. Proceedings of the 34th special meeting of the Board of Management of University of Agricultural Sciences, Raichur. held in so and so for the appointment made professors, associate professors and other equivalent posts in US Raichur. The Additional Secretary, Department of Finance, Government of Karnataka, referring to the notification dated 1/8/2016, observed that FD's permission has not been obtained to 10 posts of professors, 13 posts of associate professors under the residual cadre NHK, non-Hyderabad Karnataka, and 3 posts of associate professors under single other category resolution. In the light of the observations made by the Additional Secretary, FD, GO, Government of Karnataka, the board resolved to consider according to approval for the recommendations of the selection committee in respect of the appointments made through direct recruitments, inter se merit to the post of professors, associate professors, and other equivalent posts in the US Raichur after obtaining necessary permission from the Department of Finance of Government of Karnataka. So, my lord,
371J ನೋಡಿ ಒಂದ್ಸತಿ ಕೊಡಿ. Constitution.
So, my lord, again, the discussion was, my lord, that concurrence is required to be obtained only for, my lord, non-HK.
Yes.
In the next meeting, what happens, my lord, at Annexure G, dated 20/11/2019, Lord, it starts at Annexure G, page number 87. The relevant portion, my lord, is at page number 92. Now here, my lord, they jumble the facts, whether, my lord, it is done inadvertently or, my lord, deliberately, my lord, it is beyond my item number 16, page number 92, my lord. ಅಧಿಕಾರಿ ವ್ಯವಸ್ಥಾಪಕ ಸಹ ಪ್ರಾಧ್ಯಾಪಕ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕ ಹಾಗೂ ಶಿಕ್ಷಕರ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಲು ಅನುಮೋದನೆ ಕುರಿತು ಠರಾವು ಕೃಷಿ ವಿಜ್ಞಾನಗಳ ವಿಶ್ವವಿದ್ಯಾಲಯ ರಾಯಚೂರಿನಲ್ಲಿ ಸ್ಥಳೀಯ ಹಾಗೂ ಸ್ಥಳೀಯೇತರ ವೃಂದದ ಅಧಿಕಾರಿಗಳು 11 ಹುದ್ದೆಗಳು, ಪ್ರಾಧ್ಯಾಪಕರ 38 ಹುದ್ದೆಗಳು, ಸಹ ಪ್ರಾಧ್ಯಾಪಕರ 61 ಹುದ್ದೆಗಳು ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ದಿನಾಂಕ 11/4/2016 ಮತ್ತು 1/8/2016 ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಸಂದರ್ಶನಗಳನ್ನು ಪೂರ್ಣಗೊಳಿಸಿ, ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್, ಸಂದರ್ಶನಗಳನ್ನು ಪೂರ್ಣಗೊಳಿಸಿ ಮಾನ್ಯ ವ್ಯವಸ್ಥಾಪನಾ ಮಂಡಳಿ ಅನುಮೋದನೆಗೆ ದಿನಾಂಕ 16/12/2017 ಜರುಗಿದ 34ನೇ ವಿಶೇಷ ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಲಾಯಿತು. ಆರ್ಥಿಕ ಇಲಾಖೆಯ ಒಪ್ಪಿಗೆ ಪಡೆದ ಸದರಿ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವ ಕುರಿತು ಆಯ್ಕೆ ಸಮಿತಿಯ ಶಿಫಾರಸುಗಳನ್ನು ಅನುಮೋದನೆಗೊಳಿಸುವುದು ಮಂಡಳಿಯ ಠರಾಯಿಸಿತು. ಸದರಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ 3 ವರ್ಷಗಳಿಗಿಂತ ಹೆಚ್ಚಿನ ಅವಧಿ ಮೀರಿರುವುದರಿಂದ ದಿನಾಂಕ 14/4/2016 ಮತ್ತು 1/8/2016 ಅಧಿಸೂಚನೆಯನ್ನು ಹಿಂಪಡಿಸಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ರದ್ದುಪಡಿಸಿ ಹೊಸದಾಗಿ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸುವ ಕುರಿತು ಚರ್ಚಿಸಲಾಯಿತು. ಠರಾವು ಪ್ರಸ್ತುತ ಚರ್ಚೆಯನ್ನು ನಂತರ ಕೃಷಿ ವಿಜ್ಞಾನಿಗಳ ವಿಶ್ವವಿದ್ಯಾಲಯ ರಾಯಚೂರಿನಲ್ಲಿ ಸ್ಥಳೀಯ ಹಾಗೂ ಸ್ಥಳೀಯೇತರ ವೃಂದದ ಅಧಿಕಾರಿಗಳು 11 ಹುದ್ದೆಗಳು, ಪ್ರಾಧ್ಯಾಪಕರ 38 ಹುದ್ದೆಗಳು, ಸಹ ಪ್ರಾಧ್ಯಾಪಕರ 61 ಹುದ್ದೆಗಳನ್ನು ಹೊಸದಾಗಿ ಅಧಿಸೂಚನಿಸಲು ಹಾಗೂ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಪ್ರಸ್ತುತ ಖಾಲಿ ಇರುವ ಶಿಕ್ಷಕರ ಮತ್ತು ಗ್ರೂಪ್ ಬಿ ಮತ್ತು ಗ್ರೂಪ್ ಸಿ ಅಡಿ ಬರುವ ಶಿಕ್ಷಕೇತರ ಹುದ್ದೆಗಳನ್ನು ನಿಯಮಾನುಸಾರ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳುವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಮಾನ್ಯ ವ್ಯವಸ್ಥಾಪಕ ಮಂಡಳಿ ಅನುಮೋದನೆ ನೀಡಿತು. ಮುಂದುವರೆದು ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಪ್ರಸ್ತುತ ಖಾಲಿ ಇರುವ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ಉದ್ದೇಶಿಸಿದ್ದಲ್ಲಿ ಅಂತಹ ಹುದ್ದೆಗಳಲ್ಲಿ ವಿವರಗಳನ್ನು ಸಿದ್ಧಪಡಿಸಿ so forth. So now, my lord, what they do is, even though, my lord, financial concurrence is not required.
Whether the petitioner is still interested with this,
my lord,
whether the petitioner is still interested to pursue.
My lord, he is still interested to pursue, my lord, and my lord, these many posts, my lord, there is an order of stay. They don't even take steps, my lord, to get the order vacated. And my lord, the sealed inquiry is there before your lordship, where for certain posts, my lord, I am the only candidate, my lord, who is eligible.
Lords, in pursuance to this resolution, my lords, the university issued, my lords, the fresh notification on 10/1/2020. Lords, this is in regard to, my lords, their contention is, my lords, they are, 371J candidates were not required, financial concurrence is not required, lords. As regards non-HK, 2 candidates files a writ petition, lords, and this notification is upheld, lords. May I pass, lords?
This discussion is over, sir.
Correct, whether it is upheld on these grounds.
No, it is, my lord, on
these grounds,
solely on the point of non-HK, my lord.
What I am submitting, my lords, the notification was upheld, my lords.
Correct, not on these grounds. If it is upheld on these grounds, then the petition is to be dismissed.
Not on these grounds.
Then?
Not on these grounds.
Then?
Paragraph number 6 of this order, my lord, is purely pertains to non-HK reason.
Now, this writ petition is also
I'm
the one
told-
that you filed.
No. Pardon.
This is authored by Justice Vishwajit Shetty.
Please, lords.
Now, was it in respect of HK or non-HK?
Non-HK, lords.
But
Subject
what should
concern to
happen to these
non-HK.
people? What should happen to these people?
Lords, I am told, my lords, next week, my lords, board has taken decision, my lords. Now, next week, he is promoted as associate professor, for which he is fighting now, my lords. Lords, board has taken decision. Next week, he will get an order of associate professor, my lords.
My lord, my brother, my lord, I have all sympathies for me. This exercise, my lord, was done, my lord, before the
Correct,
previous
but
bench.
shall we record your statement?
My lord, these statements have been recorded, my lord. In fact, if I am
Then-
not wrong,
Please,
my lord,
lords,
on the
please.
previous
I
occasion,
will-
my lord, these
I
very
will
statements were
I
made.
will file board resolution itself.
He will be promoted, is it?
Please, notes associate professor, as associate professor.
From what date?
Notes.
Tirga litigation go scope kodbadi.
ಇಲ್ಲ.
You have to give him the benefit of this recruitment or promotion. It's promotion, either. Case of promotion.
ಇಲ್ಲ, it's
No,
not a
this is
case
not
of
direct,
promotion, it's case of a recruitment.
Direct
It's a case of
recruitment.
direct recruitment.
ಮತ್ತೆ ಅವ್ರಿಗೆ ಹೆಂಗೆ ಅಸೋಸಿಯೇಟ್ ಪ್ರೊಫೆಸರ್ ಹೆಂಗ್ ಕೊಡ್ತೀರಾ ನೀವು?
Notes that-
He's already working there.
Working as an assistant professor in the agriculture university. Notes. He's a.
We have already undergone this exercise, my lord.
There are several
On
applications.
3 occasions, my
Then
lord, adjournment.
depriving him of the benefit of associate professor from 2016. From what date should it be given effect to?
Notes that could be from the date of resolution.
Huh?
From the date of resolution.
What
From the date of
resolution?
board take decision. Notes as regards. From the date of board
No,
decision.
correct, 2016, you are in 2024, 8 ವರ್ಷ ಆಯ್ತು. 8 ವರ್ಷ ನೀವು ರೆಸಲ್ಯೂಷನ್ ಮಾಡಿಲ್ಲ ಅಂತ how can we deprive him? There should be some notional date.
I may not be entitled for pay during that period because, my lord, I did not work in that capacity.
Purpose of pay, fixation of pay and pension. Yes, there should be a notional date of his appointment to the post of associate professor. It is your own mistake alone, ನಿಮ್ಮ mistake ಅದು. In HK region ಗೆ ಏನು ಅಪ್ರೂವಲ್ ಬೇಕಾಗಿಲ್ಲ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಂದ್ಮೇಲೆ it is your mistake.
The difficulty is, my lords, there are total 61 posts. Notes. While application of roster, my lords, the 75% has to be, my lords, reserved for a 371J. Notes. In case, my lords, this notification is set aside, my lords, there is a cascading effect.
ಕೇಸು ಅದೆಲ್ಲ ಬೇಡ.
Lords, that's the
That is
reason.
hypothetical.
That's the reason, my lords, the board taken
That
a
is
decision to
hypothetical.
withdraw the.
No, if you give a statement that he will be promoted from a
The date
notional
of board
date,
decision, my lords. From the
when,
date.
no, not from the board decision. When it is placed before the board for approval, on that day shall be the notional date. For the purpose of, we will dispose of this petition.
Notes. Kindly see, my lords, notification, my lords, at page. None read petition ಅಲ್ಲಿ ಸರಿಯಾಗಿ ಪೇಜಿನೇಷನ್ ಆಗಿಲ್ಲ.
Page number 10.
Annexure A1, my lords. Notes the instructions ಅಂತಿದೆ notification ಅಲ್ಲಿ. Instructions. ಅದರಲ್ಲಿ item number 13. Number of vacancies notified is provisional and subject to variations. The university reserves right to fill in any or all the vacancies. Notes, it is notified to the candidate, my lords.
No, but see, posts are reserved. ಇವಾಗ ನೀವು ಅಸೋಸಿಯೇಟ್ ಪ್ರೊಫೆಸರ್ DE ಆಫೀಸ್ ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದು?
Agriculture
ಯೂನಿವರ್ಸಿಟಿ. ಸೊ DE ಆಫೀಸಲ್ಲಿ ಒಂದು ಪೋಸ್ಟ್ ನಾನ್ HK ಗಿದೆ. ಯು ಆರ್ ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಇನ್ ವಿಚ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್? ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಿಮ್ದು ಸಚಿನ್?
My lord.
You are an assistant professor in which department?
Presently, my lord, FMPE, my lord. Farm manufacture machinery and products, something to do. FMPE, my lord. Farm machinery and power engineering.
Agriculture extension, agriculture entomology, agronomy, physiology, plant pathology.
I have applied, my lord, for various subjects, my lord, and Call letter, my lord, is
Farm
also.
power, associate professor, farm power and machinery engineering.
Yes.
ಅದ್ರಲ್ಲಿ ಮೂರು ಪೋಸ್ಟ್ ಇದೆ. ಮತ್ತೆ ಒಂದು ಪೋಸ್ಟ್ ಆದ್ರೂ ಕೊಡ್ಬೇಕಲ್ಲ ಇವ್ರಿಗೆ. It is reserved. If it was an inter-se seniority without fixing the reservation.
Notes, we could get an approval from the finance department, notes, already
what-
3 had lapsed. After issuing notification, notes, the government approved the financial this thing.
No. There is no need for you to seek for an approval from finance department if it is in respect of Hyderabad, Karnataka.
Notes, for-
ಮಿಕ್ಕಿದ್ ಬೇಕಾದ್ರೆ
notes,
ಮಾಡ್ಕೊಳ್ಳಿ.
For university, it's a difficult to issue appointment orders to the 371J candidates and later getting approval from it lapsed 3 years, notes, that's the
No.
reason.
371J, once people get into that bracket, they have to go in that bracket only. Prati claim ಮಾಡಿದ್ರೆ they continue to go in that bracket only for further promotion. Professor ಗೆಲ್ಲಾನು ಆ 371G ನಲ್ಲೇ ಹೋಗ್ಬೇಕು ಅವರು.
It's mine.
So you are depriving him an opportunity of even getting promotion to the post of professor. No, we will say that even if it is ಇವಾಗ ಹೊಸ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದೀರಾ?
ಹಾ ಮಾಡಿದ್ದೆ, ಅದನ್ನೇ ಚಾಲೆಂಜ್
That is stayed, my lord.
ಅದನ್ನೇ ಚಾಲೆಂಜ್. Annexure J1.
ಮುಂಚೆ ಮೀಟಿಂಗ್ ಒಳಗೆ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ. ಪ್ರಿವಿಯಸ್ ಬೆಂಚ್ ಮೀಟಿಂಗ್ಸ್ ಒಳಗೆ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ ಆಗಿತ್ತು.
ಈ ಹೊಸ ನೋಟಿಫಿಕೇಶನ್ ಸೇಮ್ ರಾಸ್ಟರ್ ಮೇಂಟೈನ್ ಮಾಡಿದೀರಾ?
Also,
In the new notification, whether the same roster is maintained?
please notes.
Roster is maintained, my lord, but there is
Roster
absolutely
maintained
no
ಮಾಡಿ,
progress
same.
because immediately
As-
there was an order of stay, my lord.
Ditto, there is no changes.
ಆಯ್ತು, ಯಾವಾಗ ಹೇಳ್ತೀರಿ ಹೇಳಿ? ಯಾವಾಗ, when will you give him?
Notes, I will take instruction as regard to promotion from which date, my lord.
ಯಾವಾಗ ಪ್ರಮೋಷನ್ ಫಸ್ಟ್ ಯಾವಾಗ ಕೊಡ್ತೀರಾ? ಅದನ್ನ
Next
ಹೇಳಿ.
week ಕೊಡ್ತಾರೆ sir.
ಯಾವಾಗ ಅಂತ ಹೇಳಿ? When do you want me to list
After
it?
15th,
My lord, this same submission was made, my lord, previously also.
just
ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ? ನನಗೆ ತಾರೀಖ್ ಹೇಳ್ಬೇಕು. ನೆಕ್ಸ್ಟ್
next
ವೀಕ್.
Thursday ತನಕ ಕೊಡ್ತಾರೆ.
ಮತ್ತು ಯಾವ ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವ ತರ ಇರೋದು? 22.
Please,
ಬರ್ಕೊಳ್ಳಿ.
please.
The Learned Counsel for the respondent number 3 submits that though a fresh notification was issued, fresh recruitment notification was issued superseding the earlier notification, steps are on for promotion of the petitioner from the post of assistant professor to associate professor. He submits that the promotion of the petitioner to the post of associate professor will be finalized shortly. Hence list on 22
Oh, bless.
1/2025. It is made clear that if the respondent number 3 fails to finalize the promotion of the petitioner by the next date, the petition shall be taken up for disposal on merits.
Oh, bless.
Like,
Vikram Vijay Kumar.
Tender notification pertaining to 20, my lord, even a
stay,
copy was not, I was directed to take notice, copy is also not served on me.
Is there any stay?
But the only direction was, he was permitted to participate in the proceedings, that's all.
So what happened? To participate. What has happened to the tender submitted by the petitioner? Is it accepted, rejected? Ravindra Reddy. Is the bid of the petitioner accepted?
That I have to verify, my lord, because he has not given the particulars of the tender notification, that is the. Even entire petition papers were not supplied to me.
So we'll dispose it of saying that if he succeeded in the writ petition becomes infructuous. If he is not
Yes.
succeeded in the writ petition will again become infructuous. Either way, it will become infructuous.
Yes.
Or could. The petitioner has challenged a tender notification dated 19/2/2021. In respect of several packages which related to providing manpower services for carrying out shift operations and minor maintenance works at 220 kV/120 kV substations in group number 1 to 16 located under KPTCL Kalaburagi Circle. Full stop. The petitioner also has sought for a writ in the nature of mandamus to direct the respondents to accept the bid of the petitioners and consider the same on merits on par with other bidders and allow them to participate in the tender process. Full stop. Next para. This court, in terms of the order dated 19/4/2021, permitted the petitioners to participate in the tender, which however was subject to the result of the petition. Full stop. If the petitioners have succeeded in the bid, they succeeded in the tender, then this writ petition would not survive for consideration. If the petitioners have not succeeded in the tender, then too, this writ petition would not survive for consideration. Hence, the petition is dismissed as it does not survive for consideration.
Please.
Niva Chim Code.
Petition. Sought for quashing, which is annexure F Lordship, page number 50. The order passed by the Deputy Commissioner, respondent number 1 Lordship. The facts being those, Lordship, the respondent number 4 and 5 have filed the application before the DDLR of Bijaypur for survey and fresh measurements. That has been rejected, Lordship. That order has been challenged before the Deputy Commissioner.
Now, what is the order challenge before the DDLR?
Section 49E, Lordship, for survey and measurements, Lordship. Actual measurements.
Mohan.
Yes, Lord. The respondent number 4 and 5 have filed the application before the DDLR of Vijaypur.
DDLR or ADLR?
ADLR, Lord.
Deshakaru.
ADLR. Respondent number 2, Lordship. That was order has been rejected, and same was challenged before the Deputy Commissioner, Lordship. That order has been passed on 15/7/2021, Lordship. During the pendency of this revision petition, Lordship, the government has issued notification, which is annexure E, Lordship, dated 31/5/2021. Lordship, the jurisdiction was vested with the Regional Joint Director Land Records of concerned division, Lordship. Annexure E, page 48, Lordship. The table has mentioned serial number 5.
So what has happened before the Deputy Commissioners?
He was allowed the revision petition, Lordship. The order has been passed on 15/7/2021. This notification has been issued on 31/5/2021.
Now, when was it published? When was the notification published? Gazette ಯಾವ publish ಆಯ್ತು?
31/5/2021. 31/5/2021.
Publish ಆಗಿದೆ ಯಾವಾಗ? When was it published in the Gazette? Or come to the last page, page 56. So the compiler Karnataka Gazette for publication in text issue of the official Gazette. Government orders under 162 becomes operable only after publication, alva.
Yes.
But when was it published? Madam, when was it published?
ನನ್ನ ಹತ್ರ ಇಲ್ಲ, ಬಟ್
ಅದ್ ನೋಡ್ಬೇಕಲ್ಲ ನೀವು.
when the publication date is considered, Lordship, after 2 months, this order has been passed. However, Lordship, in the meanwhile, the order has been circulated within the 1 week or 1 month, Lordship. After 2 months, the order has been passed, Lordship.
Where is the order?
Annexure F, Lordship, page 50.
At the common merits, what is your case?
Lordship, on the merits, Lordship,
What is the case of the respondents?
yes, Lordship, they have given the application.
Who are they?
Yes. I read the order of Deputy Commissioner. Lord. Yes. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ವಾದಿಗಳು ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕಿನ ಬಸವನ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 129/1 ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಭೂ ದಾಖಲೆಗಳ ಉಪನಿರ್ದೇಶಕರು.
ಎಲ್ಲೋತಿದ್ರಾ?
It starts from ಪ್ರಸ್ತಾವನೆ.
DDLR ಆರ್ಡರ್ ಓದಿ.
DDL. ಶ್ರೀ ರಾಜಶೇಖರ್ ತಂದೆ ಅಪ್ಪಾಸಾಹೇಬ್ ಗೌಡ ಪಾಟೀಲ್ ಮತ್ತು ಶ್ರೀ ದಾದಾಗೌಡ ಉರ್ಫ್ ಬಸವನಗೌಡ ತಂದೆ ಅಪ್ಪಾಸಾಹೇಬ್ ಪಾಟೀಲ್ ಇವರು ಶ್ರೀ ಮೋಹನ್ ತಂದೆ ಭೀಮರಾಯ್ ಬಣರೊಟ್ಟಿ ವಿರುದ್ಧ ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕು ಬಸವನ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 129/1 ದೂಷೆ ನಂಬರ್ 2017 and 18 ಪ್ರಕಾರ ತಯಾರಿಸಿದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳಿಂದ ಬಾಧಿತರಾಗಿ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ ಅಧಿನಿಯಮ 1964 ಕಲಂ 49A ರಡಿ ಶ್ರೀ AB ಪಾಟೀಲ್ ನ್ಯಾಯವಾದಿಗಳ ಮುಖಾಂತರ ದಿನಾಂಕ 5/12/2018 ಮೇಲ್ಮನವಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಮನವಿದಾರರು ಪ್ರಮಾಣ ಪತ್ರದೊಂದಿಗೆ ಪ್ರತ್ಯೇಕವಾದ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಪೋಡಿ ಪ್ರಕ್ರಿಯೆ ಅಡಿಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 129/1 ಇದು ನಂಬರ್ 2017 and 18 ಅಂತ ತಯಾರಿಸಿದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳ ಹೊರಕ್ಷೇತ್ರದ ಪ್ರಕಾರ ಸರಿಯಾಗಿ ಅಳತೆ ಮಾಡಿ PT ಶೀಟ್ ತಯಾರಿಸಿರುವುದಿಲ್ಲ. ಸದರಿ ವಿವಾದಿತ ಜಮೀನಿನಲ್ಲಿ ಎದುರುದಾರರು PT ಶೀಟು ಮಾಡಿಕೊಳ್ಳುವಾಗ ಮೇಲ್ಮನವಿದಾರರು ಗಮನಕ್ಕೆ ತರದೆ ಹಿಸ್ಸಾ ನಂಬರ್ 1ರಲ್ಲಿ ಗೈರು ಹಾಜರು ಅಂತ ತೋರಿಸಿ PT ಶೀಟನ್ನು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಸದರಿ PT ಶೀಟು ತಪ್ಪಿನಿಂದ ಕೂಡಿರುತ್ತದೆ. ಈಗ ಎದುರುದಾರರು ಸದರಿ ಜಮೀನನ್ನು PT ಶೀಟು ಇದ್ದ ಪ್ರಕಾರ ಕಬ್ಜಾ ಪಡೆಯಲು ಜಮೀನ್ ತಜವಿಜೆಯಲ್ಲಿ ಇರುವುದರಿಂದ ತಡೆಯಾಜ್ಞೆಯನ್ನು ನೀಡಲು ವಿನಂತಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಮೇಲ್ಮನವಿ ಪ್ರಕರಣದಲ್ಲಿ ಏಕಪಕ್ಷೀಯವಾಗಿ ತಡೆಯಾಜ್ಞೆ ನೀಡುವುದರಿಂದ ಎದುರುದಾರರಿಗೆ ಯಾವುದೇ ರೀತಿಯಿಂದ ನಷ್ಟವಾಗುವುದಿಲ್ಲವೆಂದು ತೀರ್ಮಾನಿಸಿ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ ನಿಯಮ 1964 ಕಲಂ 55 ಕ್ಲಾಸ್ D ಅಡಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕಿನ ಬಸವನ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 129/1 1-3 ಅಂತ ತಯಾರಿಸಿದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳನ್ನು ಆಧರಿಸಿ ಯಾವುದೇ ಪ್ರಕ್ರಿಯೆ ಮಾಡದೆ ಹಾಗೂ ಪ್ರತಿಬಂಧಿಸಿ ಮೇಲ್ಮನವಿ ಪ್ರಕರಣದಲ್ಲಿ ವಿಚಾರಣೆ ನಡೆಸಿ ಇತ್ಯರ್ಥಪಡಿಸುವವರೆಗೆ ತಡೆಯಾಜ್ಞೆ ನೀಡಿ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯನ್ನು ದಿನಾಂಕ 26/12/2018 ನಿಗದಿಪಡಿಸಿದೆ. ಮೇಲ್ಮನವಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುವಲ್ಲಿ ಆಗಿರುವ ಕಾಲ ವಿಳಂಬವನ್ನು ಮನ್ನಾ ಮಾಡಲು ಕೋರಿ ಕಾಲ ಮಿತಿ ಕಾಯ್ದೆ ಕಲಂ 5 ರಡಿ ಪ್ರತ್ಯೇಕ ಅರ್ಜಿಯನ್ನು ಪ್ರಮಾಣ ಪತ್ರದೊಂದಿಗೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಮನವಿದಾರರು ಸಲ್ಲಿಸಿದ ಮನವಿ ಹಾಗೂ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆಗೆ ಅಂಗೀಕರಿಸಲಾಯಿತು. ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಲು ತಿಳಿಸಿ ಉಭಯ ಪಕ್ಷಗಾರರಿಗೆ ತಿಳುವಳಿಕೆ ನೋಟಿಸನ್ನು ಅಂಚೆ ಮೂಲಕ ಜಾರಿ ಮಾಡಲಾಯಿತು. ದಿನಾಂಕ 26/12/2018 4/3/2020 ಕೈಗೊಂಡ ವಿಚಾರಣೆಗೆ ಮೇಲ್ಮನವಿದಾರರು ಮತ್ತು ಅವರ ನ್ಯಾಯವಾದಿಗಳು ಹಾಜರಿದ್ದರು. ಎದುರುದಾರರು ನಂಬರ್ 1ರ ಪರವಾಗಿ BS ಪಾಟೀಲ್ ನ್ಯಾಯವಾದಿಗಳು ವಕಾಲತ್ತು ವಹಿಸಿ ತಕರಾರು ಸಲ್ಲಿಸಲು ಅವಕಾಶ ಕೋರಿದರು. ದಿನಾಂಕ 27/2/2019 ಎದುರುದಾರ ನಂಬರ್ 1ರ ನ್ಯಾಯವಾದಿಗಳು ಲಿಖಿತ ತಕರಾರು ಹಾಗೂ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದರು. ದಿನಾಂಕ 9/10/2019 ವಾದಿ ನಂಬರ್ 1 ಮತ್ತು ಅವರ ಪರ ವಕೀಲರು ಹಾಜರು, ಉಳಿದವರು ಗೈರು. ದಿನಾಂಕ 4/3/2020 ಮೇಲ್ಮನವಿದಾರರು ಮತ್ತು ಉಭಯ ಪಕ್ಷಗಾರರು ವಕೀಲರು ಹಾಜರು ಮೇಲ್ಮನವಿದಾರರ ಲಿಖಿತವಾದ ಪತ್ರ ಮತ್ತು ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ಎದುರುದಾರರ ನ್ಯಾಯವಾದಿಗಳು ಸದರಿ ಪ್ರತಿಯನ್ನು ಸ್ವೀಕರಿಸಿ ಪ್ರಕರಣವನ್ನು ಆದೇಶಕ್ಕೆ ಎತ್ತಿಕೊಳ್ಳಲು ವಿನಂತಿಸಿರುತ್ತಾರೆ. ಕಾರಣ ಸದರಿ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿ ಆದೇಶಕ್ಕಾಗಿ ಎತ್ತಿಕೊಂಡ ಉಭಯ ಪಕ್ಷಗಾರರು ಸಲ್ಲಿಸಿದ ಮನವಿಯನ್ನು ಮುಖ್ಯಾಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಗಿನ ಅಂಶಗಳನ್ನು ಕಂಡುಕೊಳ್ಳಲಾಯಿತು. ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕಾ so and so they have shown the charts lordship. I'll directly come to the para number 3. ಖಂಡಿಕೆ 1 ಮತ್ತು 2 ಪರಿಶೀಲಿಸಲಾಗಿ ರೀಸರ್ವೆ ನಂಬರ್ 129/1 ಆಕಾರ ಬಂದ್ ಒಟ್ಟು ಕ್ಷೇತ್ರಕ್ಕೆ ಹಕ್ಕು ರಿಜಿಸ್ಟರ್ ಒಟ್ಟು ಕ್ಷೇತ್ರಕ್ಕೆ ಹೊಂದಾಣಿಕೆ ಇರುತ್ತದೆ. ರೀಸರ್ವೆ ನಂಬರ್ 129 ಹಿಸ್ಸಾ ದಾಖಲೆಗಳು ಹೊರಗಳಲ್ಲಿ ಕಾಲೋಚಿತಗೊಂಡಿರುತ್ತದೆ. ಮೇಲ್ಮನವಿದಾರರು ತಮ್ಮ ಮೇಲ್ಮನವಿ ಅರ್ಜಿಯಲ್ಲಿ ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕು ಬಸವನ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ನಂಬರ್ 129/1ರಲ್ಲಿ ಇದು ದೇಶ ನಂಬರ್ 2017-2018 ಅಡಿ ತಯಾರಿಸಿದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳನ್ನು ರದ್ದುಪಡಿಸಿ ವಾಸ್ತವಿಕ ಕಬ್ಜಾ ವಹಿವಾಟು ಮತ್ತು ಹರ ಪ್ರಕಾರ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳನ್ನು ತಯಾರಿಸಲು ನಿರ್ದೇಶನ ಮಾಡಬೇಕೆಂದು ವಿನಂತಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಎದುರು ದಾಳಿ 1ರ ಪರ ನ್ಯಾಯವಾದಿ ತಮ್ಮ ವಾದ ಮಂಡಿಸಿ ಸದರಿ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳನ್ನು ರದ್ದುಪಡಿಸಬಾರದೆಂದು ಬಲವಾದ ಆಕ್ಷೇಪಣೆ ವ್ಯಕ್ತಪಡಿಸಿರುತ್ತಾರೆ. ಉಭಯ ಪಕ್ಷಗಾರರು ಮಂಡಿಸಿದ ವಾದ ಹಾಜರುಪಡಿಸಿದ್ದ ದಾಖಲೆಗಳನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಈ ನ್ಯಾಯಾಲಯ ಈ ಕೆಳಗಿನಂತೆ ಅಭಿಪ್ರಾಯಪಟ್ಟಿದೆ. ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕು ಬಸವನ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ರೀಸರ್ವೆ ನಂಬರ್ so and so ರೆಡಿ ತಯಾರಿಸಿದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳು ಕಂದಾಯ ದಾಖಲೆಗಳಲ್ಲಿ ಕಾಲೋಚಿತಗೊಂಡಿರುತ್ತವೆ. ಮೇಲ್ಮನವಿದಾರರು ನಂಬರ್ 1ರವರು ರೀಸರ್ವೆ ನಂಬರ್ 129 ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ 24 ಗುಂಟೆ ಪೈಕಿ 35 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಶ್ರೀ ಬಸವನಗೌಡ ತಂದೆ ಸಂಕನಗೌಡ ಪಾಟೀಲ್ ಇವರಿಗೆ ನೋಂದಾಯಿತ ಖರೀದಿ ದಸ್ತು ನಂಬರ್ 402 ದಿನಾಂಕ 18/5/1998 ಕ್ರಯಕ್ಕೆ ಕೊಟ್ಟಿರುವುದು ಖರೀದಿ ಪತ್ರದಿಂದ ಖಚಿತಪಟ್ಟಿದೆ. ತದನಂತರ ಸದರಿಯವರು ವಿಜಯಲಕ್ಷ್ಮಿ ತಂದೆ ಶಿವನಗೌಡ ಪಾಟೀಲ್ ರವರಿಗೆ ಈ ಜಮೀನನ್ನು ಹಸ್ತಾಂತರವಾಗಿರುವುದು ತಿಳಿದು ಬರುವುದು. ಆದರೆ ಈ ಜಮೀನನ್ನು ಹೇಗೆ ಹಸ್ತಾಂತರವಾದ ಬಗ್ಗೆ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ವಿಜಯಲಕ್ಷ್ಮಿ ತಂದೆ ಶಿವನಗೌಡ ಪಾಟೀಲ್ ಇವರು ತತ್ಕಾಲ ಪೋಡಿ ಯೋಜನೆಯಡಿ ಇದು ನಂಬರ್ so and so ರೆಡಿ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳನ್ನು ತಯಾರಿಸಿಕೊಂಡಿರುವುದು ಹಿಸ್ಸಾ ನಮೂನೆ 4ರಲ್ಲಿ ರುಜು ಮಾಡಿರುವುದರಿಂದ ತಿಳಿದು ಬರುತ್ತದೆ. ಅದರ ಅರ್ಜಿ ಸಂಖ್ಯೆ ನಂಬರ್ so and so ಇರುತ್ತದೆ. ಸದರಿಯವರು ತಮ್ಮ ಪಾಲಿಗೆ ಬಂದ ಹಿಸ್ಸಾವನ್ನು ಎದುರು ದಾಳಿಗೆ ಮಾರಾಟ ಮಾಡಿರುವುದು ದಸ್ತರ್ ಸಂಖ್ಯೆ so and so 11/12/2017 ಖರೀದಿ ಪತ್ರದಿಂದ ತಿಳಿದು ಬರುತ್ತದೆ. ಮೇಲ್ಮನವಿದಾರರು ತಮ್ಮ ಮೇಲ್ಮನವಿ ಅರ್ಜಿಯಲ್ಲಿ ಇದು ನಂಬರ್ so and so ತಯಾರಿಸಿದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳು ರೀಸರ್ವೆ ನಂಬರ್ 129/1ರ ಹಕ್ಕುದಾರರ ಕಬ್ಜಾ ವಹಿವಾಟಿಗೆ ವ್ಯತ್ಯಾಸವಾಗಿರುವುದಾಗಿ ತಿಳಿಸುತ್ತಾರೆ. ಹಿಸ್ಸಾ ದಾಖಲೆಗಳಿಗೂ ಕಬ್ಜಾ ವಹಿವಾಟಿಗೂ ವ್ಯತ್ಯಾಸವಾದ ಬಗ್ಗೆ ದಾಖಲೆಗಳ ಸಮೇತ ನಿರೂಪಿಸಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ರೀಸರ್ವೆ ನಂಬರ್ 1ನಲ್ಲಿ ಉಳಿದ ಹಕ್ಕುದಾರರನ್ನು ಈ ಪ್ರಕರಣದಲ್ಲಿ ಪಕ್ಷಗಾರನಾಗಿಸಿರುವುದಿಲ್ಲ. ಈ ಮೇಲಿನ ಎಲ್ಲಾ ಕಾರಣಗಳಿಂದಾಗಿ ಈ ಮೇಲ್ಮನವಿ ಅರ್ಜಿಯನ್ನು ಮಂಜೂರು ಮಾಡಲು ಸಮರ್ಥನೀಯವಾದ ಕಾರಣಗಳು ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳನ್ನು ರದ್ದುಪಡಿಸುವುದು ಸರಿಯಾದ ಕ್ರಮವಲ್ಲ ಎಂದು ತೀರ್ಮಾನಿಸಿದೆ ಮತ್ತು ದಿನಾಂಕ 6/12/2018 ಈ ನ್ಯಾಯಾಲಯದಿಂದ ನೀಡಿದ ತಡೆಯಾಜ್ಞೆಯನ್ನು ತೆರವುಗೊಳಿಸಿ ಸದರಿ ವಿವಾದಿತ ರೀಸರ್ವೆ ನಂಬರ್ 129/1ರಲ್ಲಿ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಸಲ್ಲಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಆಧರಿಸಿ ಮತ್ತು ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ನೀಡಿದ ಹೇಳಿಕೆಗಳ ಆಧಾರದ ಮೇಲೆ ಖಂಡಿಕೆ 1ರಿಂದ 7ರವರೆಗಿನ ಅಂಶಗಳನ್ನು ವಿಚಾರಣೆಯಿಂದ ಕಂಡುಕೊಂಡು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 1964 ಕಲಂ 49A ಅನ್ವಯ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರದಿಂದ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿದೆ. ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕು ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ರೀಸರ್ವೆ ನಂಬರ್ 129/1ರಲ್ಲಿ ಇದು ನಂಬರ್ so and so ರೆಡಿ ತಯಾರಿಸಿದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳು ನಿಯಮಾನುಸಾರ ರಚಿಸಲ್ಪಟ್ಟಿರುವುದರಿಂದ ಅವುಗಳನ್ನು ಎತ್ತಿ ಹಿಡಿದು ದಿನಾಂಕ 5/12/2018 ಸಲ್ಲಿಸಿದ ಮೇಲ್ಮನವಿ ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡಿದೆ.
ಯಾರಿದು ಬಸವನಗೌಡ ತಂದ ಸಂಕಣ್ಣಗೌಡ? ಹೂ ಇಸ್ ದಿಸ್ ಮೋಹನ್? ಭೀಮರಾಯ ವನ ರೊಟ್ಟಿ. So where is this Vijayalakshmi?
Lordship, for this aspect, for this aspect, Lordship, I'll take the clarity.
ಅಲ್ಲ, ವಿಜಯಲಕ್ಷ್ಮಿ ಇವರು ತತ್ಕಾಲ್ ಪೋಡಿ ಯೋಜನೆಯಡಿ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳನ್ನು ತಯಾರಿಸಿಕೊಂಡಿರುವುದು ಹಿಸ್ಸಾ ನಮೂನೆ 4ರಲ್ಲಿ ರುಜು ಮಾಡಿರುವುದರಿಂದ ತಿಳಿದು ಬರುತ್ತದೆ. ಅದರ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸದರಿಯವರು ತಮ್ಮ ಪಾಲಿಗೆ ಬಂದ ಪೂರ್ತ ಹಿಸ್ಸಾವನ್ನು ಎದುರಾಳಿಗೆ ಮಾರಾಟ ಮಾಡಿರುವುದು ಖರೀದಿ ಪತ್ರ ತಿಳಿದು ಬರುತ್ತದೆ. So if 35 guntas is already sold by you, ನೀವು ಸೇಲ್ ಮಾಡಿದ್ದೀರಿ ಅಂತ ಹೇಳ್ತಿದ್ರಲ್ಲ, 35 ಗುಂಟೆ ಸೇಲ್ ಮಾಡಿದಿರಲ್ಲ,
ದಿಕ್ಕಿನ ಜಮೀನನ್ನು ಖರೀದಿ ಮಾಡಿ
Read page 41, second paragraph. ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕು ಬಸವನ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 129/1ರಲ್ಲಿ ಶೇತ್ ನಂಬರ್ 2017-18 ರಡಿ ತಯಾರಿಸಿದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳು ಕಂದಾಯ ದಾಖಲೆಗಳಲ್ಲಿ ಕಾಲೋಚಿತಗೊಂಡಿರುತ್ತವೆ. ಮೇಲ್ಮನವಿದಾರರು ನಂಬರ್ 1 ರವರು ಸರ್ವೆ ನಂಬರ್ 129/1ರ ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ 24 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಪೈಕಿ 35 ಗುಂಟೆ ಜಮೀನನ್ನು ಬಸನಗೌಡ ತಂದೆ ಸಂಕನಗೌಡ ಪಾಟೀಲ್ ಇವರಿಗೆ ನೋಂದಾಯಿತ ಖರೀದಿ ದಸ್ತಾವೇಜ್ ನಂಬರ್ 18/98 ರಲ್ಲಿ ಕ್ರಯ ಕೊಟ್ಟಿರುವುದು ಖರೀದಿ ಪತ್ರದಿಂದ ಖಚಿತಪಟ್ಟಿದೆ. ತದನಂತರ ಸದರಿಯವರು ವಿಜಯಲಕ್ಷ್ಮಿ ತಂದೆ ಶಿವನಗೌಡ ಪಾಟೀಲ್ ರವರಿಗೆ ಈ ಜಮೀನನ್ನು ಹಸ್ತಾಂತರವಾಗಿರುವುದು ತಿಳಿದು ಬಂದಿರುವುದು. ಆದರೆ ಈ ಜಮೀನನ್ನು ಹೇಗೆ ಹಸ್ತಾಂತರವಾದ ಬಗ್ಗೆ ದಾಖಲೆಗಳು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ವಿಜಯಲಕ್ಷ್ಮಿ ಇವರು ತತ್ಕಾಲ್ ಪೋಡಿ ಯೋಜನೆಯಡಿ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳನ್ನು ತಯಾರಿಸಿಕೊಂಡಿದ್ದು ಹಿಸ್ಸಾ ನಮೂನೆ 4ರಲ್ಲಿ ರುಜು ಮಾಡಿರುವುದರಿಂದ ತಿಳಿದು ಬರುತ್ತದೆ. ಅದರ ಅರ್ಜಿ ಸದರಿಯವರು ತಮ್ಮ ಪಾಲಿಗೆ ಬಂದ ಪೂರ್ಣ ಹಿಸ್ಸಾವನ್ನು ಎದುರಾಳಿಗೆ ಮಾಡಿರುವುದು 2017 ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ. ವಾಟ್ ಈಸ್ ರಾಂಗ್ ಇನ್ ದಿಸ್? ಆಯ್ತು, ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಹ್ಯಾಸ್ ಅಲೋಡ್ ದಿ ಅಪೀಲ್. ಕರೆಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ.
Lordship, I'll take the clarity regarding the hissas. In fact, I don't have clarity regarding the hissas and on the merits of the.
I didn't get you. Please come again.
Please, Lordship.
What did you say? I didn't understand. ಏನ್ ಹೇಳಿದ್ರಿ?
Lordship, regarding the hissas, I'll take the instructions and the clarity, Lordship.
Madam, there are two hissas.
Yes.
129/1. Ididu. Total extent is 5 acres 24 guntas.
Yes.
ಆ 5 acres 24 guntas ಅಲ್ಲಿ ನೀವು 25 ಗುಂಟೆ ಮಾರಾಟ ಮಾಡಿದಿರಿ, 35 ಗುಂಟೆ ಮಾರಾಟ ಮಾಡಿದಿರಿ ವಿಜಯಲಕ್ಷ್ಮಿಗೆ.
No.
ವಿಜಯಲಕ್ಷ್ಮಿ ಪೋಡಿ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಪೋಡಿ ಮಾಡಿಸ್ಕೊಂಡು ಮೋಹನ್ಗೆ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ.
No.
Now you have challenged that podi effected in the name of Vijayalakshmi. On what ground?
Lordship, I am not challenging, Lordship. The
You
respondent-
challenge.
Respondent number 4 and 5 have challenged.
No. You are for Mohan. Yes, Mr.
Yes.
I appear for 4 and 5, not.
Ah.
Not my colleague has instructions in this.
No.
Not
it-
4 and
decided-
5.
To be decided now.
My Wednesday. one
No,
itself.
no Wednesday. ಈಗಲೇ. You have sold the property to Vijayalakshmi.
I'll take instruction on
No
that. My
instruction.
colleague has appeared. Password ಮಾಡಿ, I'll take it.
ಬರ್ಕೊಳ್ಳಿ. ಇಲ್ಲ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ.
ಇಲ್ಲ, password ಮಾಡಿದ್ರೆ
Password.
bless.
Allowing this petition. You sell it, ನೀವೇ ಮಾರಾಟ ಮಾಡಿದ್ರಿ 35 ಗುಂಟೆ.
Yes, I'll let it.
ಮಾರಾಟ ಮಾಡಿದ್ರೆ you don't deny that. If you don't deny it, how can you stop the podi? How can you
Wednesday
challenge
ಇಟ್ಕೊಂಡ್ರೆ Wednesday I'll make submissions. what-
Password. No Wednesday. Nagaraj M. Naidu. There is no representation for the petitioner. There is no representation for the petitioner. List on date. As a last chance, list on 20. Same order. Ravi B. Patil.
So in this case, I have to file statement of objections, Your Lordship.
Ah,
Short accommodation,
you want to file?
I have to file yours as secret.
Here case is.
My lord, the petitioner was allotted with a site
Hmm.
under KSSIDC, my lord, Karnataka Small Scale Industrial Development Corporation.
Hmm.
My lord, pursuant to, my lord, order dated, my lord, 19/2/2019 at Annexure B, page number 30. He was required to, my lord, carry out the construction within 1 year and, my lord, required to pay the remaining amount within 90 days.
Hmm.
But he being the only son, my lord, the father of, my lord, petitioner, my lord, was infected with eyes and, my lord, ultimately has lost both eyes. Because of which, my lord, the petitioner could not, my lord, repay the remaining amount and, my lord, could not carry out the
That is
construction.
not a ground.
My lord, that is the only reason, my lord, and this is entire issue is during, my lord, the course of COVID also. My lord, 18/11/2021, my lord, without even issuing a notice, they, my lord, cancels, my lord, the
So
order.
if you're not paid the
For
money, it goes automatically.
EMD amount to 50,000 katidar. Remaining
EMD
amount requires to be paid. my lord.
Allotment goes. See, we're losing the purpose of allotment. Allotment purpose, so, Kelsa. So that you will generate employment. What is the purpose? 5 ವರ್ಷ ಆಯ್ತು, you not done anything.
There is some valid reason, my lord. Father had lost both the eyes. He being the only son, not requires to be take care, my lord.
Yes. You might take care, mister. This is also
My lord,
part of.
if my lord, within 1 month, my lord, we will, my lord, start putting up construction and, my lord, if given an opportunity. We have given also, my lord, the representation before the authority saying that, I am ready to pay the present market value also.
Yes. Ganesh Kalaburagi, present market value.
Yeah, admittedly, Your Lordship, but as per the instructions, the second notification is also issued and so there are some participants or applicants
Right to
also
say.
there.
Present market value.
Yes, Your Lordship, but the other also are in the bid competitions. Other bidders also there in
But even
competition.
this man has to be given an opportunity.
2 years from the date of allotment, 2 years nothing has done, Your Lordship. Neither a approach.
Therefore, we are saying, you take the present market value.
Kindly pass over, Your Lordship. Officer is coming, so I will just have instructions and just I will put.
We'll put him on terms, present market value within 2 years, commercial production.
Yes.
Within 2 years, commercial production.
No, I have to put for the reality regarding the fresh bidders are there also.
Here.
The fresh bidders are then also he will be one of the competitor for them. The person who will be highest bidder will be given the opportunity to that effect also.
Well, I think highest bidding guy though.
Yes, bidding is.
Allotment alwa idu.
ಅಲ್ಲ
Is it bidding?
bidding with this. Other auction bidding ಅಲ್ಲಿ ಇದು ಆಗಿದ್ದು.
ಅಲ್ಲ ಇದು ಕೊಡಿ ಇಲ್ಲಿ annexure B is auction or what? Allotment.
My lord, they have called, now they had called auction before, my lord, filing of the writ petition. That is the reason, my lord.
No, no,
Yes,
annexure
sir.
B was it given it at an auction or?
No, it was a call for made by the
Allotment,
authority. Annexure B, page number 30, my lord. It's not auction.
ನೀವು ಆಕ್ಷನ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ? ಅಲಾಟ್ಮೆಂಟ್ ತಾನೇ ಮಾಡ್ಬೇಕಾಗಿರೋದು.
Allotment ಆಗಿದೆ. Annexure B.
Where is the notification now issued?
Now, my lord, they have issued notification in which, my lord, my site is not notified, in spite of which I have produced that document.
ಎಲ್ಲಿದೆ?
Annexure B, my lord, starts from page number 41, my lord.
ಹಂಚಿಕೆಗಾಗಿ ಪ್ರಕಟಣೆ.
There are more than 6, if any applications are more than 6, then the procedure is to for auction among them, Your Lord.
ಏನೇಳಿ ಪ್ರೊಸೀಜರ್?
If there are 6 applicants to the single plot, which same plot, then the rule is that has to be conducted, auction has to be conducted. So by way of, as per instructions, by way of auction, the second, this one notification, there are bidders are there already some amount they have deposited.
2021 ಇದು. ಆಯ್ತು, get instruction.
Yes.
Pass over.
Sir, in this case, Your Lordship, earlier there was the directions for me to file the affidavit of respondent number 3 and 5. Sir, whereas your lordship, respondent number 3 office is closed as per the instructions. It is from the Hubballi. That's nowhere concerned to this area, your lordship, this respondent number 3's office.
ಏನ್ ಮಾಡ್ಬೇಕು?
So he is not necessary party, your lordship, respondent number 3. And moreover, that office at the Hubballi has been closed as per the instructions. And the respondent number 5, your lordship, the present office at Kalaburagi, whereas there is a in-charge officer is recently appointed, is on the way, your lordship, I will face it.
Why the affidavit was sought for?
Why Wakalat has not been given to the advocate for appearing on their behalf?
I think you appear ಆಗ್ತಿದ್ದೀರಲ್ಲ.
Yes, for already for 2 I have appeared. But respondent number 3 is not necessary parties because their office is already closed. A3 for respondent number 5, I am filing Wakalat for them.
What about on merits?
Lord, the petitioner is
also.
Lord B graduate and belong to Lord SC community, and he applied for the Lord plots. As per the notification issued on 12/3/2020, that is annexure A. Lord, he applied for 3 plots. One is special plot number 3 at Bidar and the special plot number 25 and 41 at Humnabad industrial area. Lord, there is a criteria for the Lord appointment of order for the allotment of the site. At page number 22, Lordship may kindly see the there are various marks you will get if you, my lord, belong to the graduation and other things. That is the, my lord, page number, my lord, 22. According to me, Lord, I have applied annexure B is the plot, special plot number 3. I am the B graduate. Lord, now they issued a final notification, the final allotment list annexure E, you lordship may kindly see. My name found at serial number 8. They have allotted plot number, my lord, 24 at, my lord, Humnabad industrial area. I have scored, my lord, highest marks, my lord, all the candidates, 75 marks I have, my lord, got. In spite of that, my lord, my first preferential is to plot number 3 at Bidar. Lord, without for the plot number 3, they have allotted respondent number, my lord, 7, and that is serial number 3. He got, my lord, only 70 marks. In spite of that, my lord, I got a 75. My lord, they have refused to.
Is there any interim order?
No, my lord, there is no interim
No
order.
interim order.
No, there is no.
What is the respondent number 7 done?
7 and 8, my lord, according to me, they have not even put up any, my lord, they have not started. They have, both they have served and unrepresented before this honorable court also.
Can you
For
find out?
publications, yes.
Now, what is the stage of the, what is the?
I will
status?
get the information. But as per these documents, your lordship, he has filed 2 separate applications, one for the Bidar and another for the Humnabad place. So as per the annexure C, where he sought for special plot number 41 at the Humnabad. As per his application, that plot at Humnabad he has been allotted.
No,
Is
but,
what is annexure C, your lordship.
ಬೀದರಲ್ಲೂ ಕೇಳಿದಾರಲ್ಲ.
It is a,
A ಮತ್ತು B and C ಪ್ರಕಾರ ಬೀದರಲ್ಲಿ ಒಂದು ಹುಮ್ನಾಬಾದಲ್ಲಿ ಒಂದು 2 ಕಡೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. ಅವರು ಬೀದರ್ ಹುಮ್ನಾಬಾದಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
it is a smaller plots, not this what they allotted. My this plot number 3 is a bigger size. The size is also there, my lord.
Will get the.
Is there any bar that if he has applied once, he cannot apply it again?
That is not the criteria. That is not even, that is not any conditions to that effect.
There is no, as per annexure A, aya kaige was.
The screening committee single window there, it is their decision, your lordship, not for ours. The state commissioner has.
He has secured higher marks.
Yes.
And is in a better position to be allotted a site.
Yes.
Than the respondent 7 and 8.
Yes.
How do you deny it?
It is not me, my screening committee, the deputy commissioner has the pass that order.
They are deputy commissioner.
No, it is a,
the commissioner.
KSSIDC, where is
allotment?
Deputy commissioner ಬರ್ತಾರೆ ಎಲ್ಲಿ ಬರ್ತಾರೆ? Allotment is made by you.
There is a committee, your lordship, where the chairman is the deputy commissioner of it.
Official ಇರ್ತಾರೆ.
Yes.
ಬರ್ಕೊಳ್ಳಿ.
I will just, I kindly, one submission, your lordship. Kindly pass over, your lordship. They are also coming and I will have a instruction and submit my detailed objection.
ಅಲ್ಲ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬೇಕು ನೀವು.
Yes.
7 and 8.
I will.
Pass over. 63, J. Augustine, Mr. C. Jagadish, C. Jagadish, ಕೊಡ್ರಿ ಇದು 1992 ಆರ್ಡರ್ ಕೊಡಿ. ಕರ್ನಾಟಕ ಎಸ್ ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಅಂಡ್ ಶೆಡ್ಯೂಲ್ ಟ್ರೈಬ್ಸ್ ಕೊಡ್ರಿ ರಿಸರ್ವೇಶನ್ ಅಂತ ಇದೆಯಲ್ಲ 1992 ಆರ್ಡರ್. Mr. Jagdish. ಕೊಡಿ. The petitioner has challenged an order dated order bearing number so and so dated dash annexure J, by which the district caste verification committee cancelled the caste certificate granted to the petitioner. Next para. The petitioner claimed that she belonged to scheduled caste. She applied for a post. She applied for a post of assistant teacher at Prashant Nursery cum Primary School, Brahmapur, Gulbarga, on 12/7/1982. Full stop. Her appointment was approved on 12/1/1983. Full stop. The post was reserved for scheduled tribes. Scheduled caste, scheduled tribe. The said post was reserved for scheduled tribe. She claimed that she belonged to Gond community, which was recognized as a scheduled tribe. He claimed that her grandmother had given a declaration in form number 1 on 2/8/1982, declaring that the petitioner belongs to Gond community. The said declaration was made before the Deputy Tahsildar Gulbarga on 20th of August 1982. He claimed that on 11/3/2002, the state government issued an order dated bearing number so and so, bearing number SWD 713 SAD 93, directing all persons who have obtained caste certificates and under scheduled tribe category to surrender the same to the issuing authority. The petitioner filed a letter with her employee to bringing to its notice the government order dated 11/3/2002 and requested it to treat her appointment as one made against the general category. While the petitioner was looking forward for cancellation of the caste certificate, the application filed by the petitioner was forwarded to the block education officer Gulbarga. Full stop. Looking for while the petition. It is claimed that the employer of the petitioner forwarded the application filed by her to the block education officer Gulbarga and requested him to return the original caste certificate submitted by the petitioner at the time of approval of her appointment, so that the same could be surrendered for cancellation. Full stop. The petitioner contends that the government of Karnataka in terms of a communication dated 4/3/2014 approved that persons belonging to Kuruba community in Bidar, Gulbarga and Yadgir as scheduled tribes. And included Gond and Raja Gond in the list of scheduled tribes in the state of Karnataka. Next para. The petitioner contends that a notice was issued to her at the instance of a complainant to inquire into the caste of the petitioner. Accordingly, the petitioner appeared for an inquiry before the Superintendent of Police CRE Directorate, Kalaburagi. The Superintendent of Police CRE Directorate, in terms of his letter bearing numbers, will not call it, para 7, dated 30/4/2019, affirmed that the petitioner obtained a false certificate though he had not obtained the certificate from the concerned office. The petitioner therefore submits that the report of the Superintendent of Police, CRE, submitted to the Additional Director, CRE, was without application of mind. Later, the Additional Director of Police, Additional Director General of Police, CRE Directorate, addressed a communication to the District Caste Verification Committee to determine the caste of the petitioner. Full stop. The District Caste Verification Committee thereafter passed the impugned order, cancelling the caste certificate and declared that the petitioner did not belong to scheduled tribe. Full stop. Being agreed with the said order, the petitioner is before this court. Next paragraph. The learned counsel for the petitioner reiterated the above contentions and claimed that by virtue of the notification issued by the state government, Gond and Raja Gond castes are recognized as scheduled tribes in the state of Karnataka, and therefore the petitioner was entitled to the benefit. Besides this, she contends that full stop. Next paragraph. The learned special counsel for the respondents submitted that this writ petition is not maintainable in view of an appeal provided
Under 4D, my lord, I am sorry, my lord, I could not able to come. Section 4D.
Section 4D.
Kurba antano agide swami idರಲ್ಲಿ. Kurba antide. How a Kurba can become a Gond, my lord? Kurba is notified as backward class category 2A.
He claims to be a Gond, not a Kurba.
His inquiry report reveals that he belongs to a Kurba.
Relative file.
Appeal.
Appeal is maintainable under 4D of the Karnataka Scheduled Caste, Scheduled Tribes and other backward classes, Reservation of Appointment, etc. Act 1990. Thus, he contends that the petitioner is bound to approach the Director of Tribal Welfare and file an appeal in such form and in such manner as prescribed. Full stop. Next para. The Act 1990 provides for verification of caste and income certificate. Section 4C provides for constitution of a committee, verification committee. Section 4C provides for constitution of a verification committee for each district for verification of caste and income certificate. Full stop. The verification committee, after holding such inquiry as it deems fit, could either grant a validity certificate in the prescribed form or reject it. Full stop. Any person aggrieved by an order passed by the verification committee under Section 4C is bound to file an appeal before the appropriate authority as provided under Section 4D. Therefore, the petitioner cannot approach this court directly by short-circuiting the appellate remedy. Hence, the writ petition is dismissed as not maintainable. It is open for the petitioner to file an appropriate appeal against the impugned order before the appropriate authority as provided under section 4D of the Act 1990. Full stop. If an appeal is filed, comma, the appellate authority shall consider the same after deducting or after excluding the period consumed in pursuing this writ petition. Full stop. Hmm. 64, huh?
But it's covered. I am proxy
Uh,
counsel Case by allotment, my lords. for Sukumar Malipati, my lord.
uh,
Next week.
Similar matters have been disposed by this court.
ಏನಂತ?
Allotment has been set aside, subject to payment of interest, my lords. That allotment, my lords, set aside of this allotment order is also washed. The allotment was set aside on the pretext that, my lords, the entire consideration amount was not paid. In fact, in the rule of allotment letter itself, it is specifically stated that subject to payment of interest, allotment shall, my lords, continue. Annexure A ali, if I may draw your lordship's attention to Annexure A, page page 14 ಅಲ್ಲಿ. That is rule 4. ಮನೆಯ ಅಂತಿಮ ಬೆಲೆಯ ಬಾಕಿ ಹಣವನ್ನು ಮೇಲೆ ಸೂಚಿಸುವಂತೆ 4 ಸಮ ಕಂತುಗಳಲ್ಲಿ ಪಾವತಿ ಮಾಡಬೇಕು. ಇಲ್ಲದಿದ್ದರೆ ಯಾವುದೇ ಮುನ್ಸೂಚನೆ ಹಾಗೂ ಕಾರಣ ನೀಡದೆ ಹಂಚಿಕೆ ರದ್ದುಪಡಿಸಿ ಪ್ರಾರಂಭಿಕ ದೇವಣಿಯ 25% ಹಣವನ್ನು ಮುಟ್ಟುಗೋಲು ಹಾಕಿಕೊಳ್ಳಲಾಗುವುದು. ತಡವಾಗಿ ಹಣವನ್ನು ಪಾವತಿ ಮಾಡುವವರಿಗೆ ನಿಯಮಾನುಸಾರ ಬಡ್ಡಿ ವಿಧಿಸಲಾಗುವುದು. In light of this rule, my lords.
What does the allotment rules say? What does the act say? Allotment rules ಏನಂತ ಹೇಳುತ್ತೆ?
ಅಲ್ಲ, that allotment, my lords, was set aside only on the pretext that, my lords, there is consideration amount was not totally paid.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದು?
ಅಲ್ಲ, in this particular case, my lords, I have already paid. Annexure C is the.
So you are supposed to pay it when?
ಅಲ್ಲ, 25% for every ಕಂತಲ್ಲಿ ಮಾಡ್ಬೇಕು ಅಂತ.
ಆಯ್ತು, ಯಾವಾಗ?
I have totally paid, my lords, in the year 2000.
ಯಾವಾಗ ಕಟ್ಟಿದ್ರಿ? Totally paid when?
By the year 2011 itself, my lords, I have paid.
Date ಹೇಳ್ಬೇಕು. ಯಾವ ಕಟ್ಟಿದ್ರಿ?
Last, my lords, I had paid on 15/11/2011. Annexure C3, page 25 ಅಲ್ಲಿ. That is the last kantu. Annexure C3, page 25. That is the last installment I have paid, my lords.
25, huh?
Huh.
This is 15/11. ಯಾವಾಗ allotment ಯಾವಾಗ?
Allotment ಆಗಿದ್ದು
16/6.
Yes. 2010 ಅಲ್ಲ.
2011. 2010.
Yes, my lords.
ಪ್ರಕಟಣೆ ದಿನಾಂಕ 31/7.
16/6/2011 is the allotment.
16/6/2011.
Yes.
And within how many days you are supposed to ಮನೆಯ ಅಂತಿಮ ಬೆಲೆಯ ಬಾಕಿ ಹಣವನ್ನು ಮೇಲೆ ಸೂಚಿಸಿರುವಂತೆ
4 ಸಮ ಕಂತುಗಳಲ್ಲಿ
26/10 ಕಟ್ಟಬೇಕಾಗಿತ್ತು. 16/10 ಕಟ್ಟಿ 1 ತಿಂಗಳು ಡಿಲೇ ಮಾಡಿದಿರಿ.
Subject to payment of interest.
Yes, Mr.
Similar
Proxy
matters.
counsel, my lord.
Close one. Take interest for 1 month. Good. The petitioner allotted. Yeah, sorry, the petitioner, what is the order challenged?
Order challenge, my lords, Annexure E.
The petitioner is challenged an order dated.
Subsequently, it was reallotted to respond number 3.
The
Annexure
petitioner
D is the
challenged
cancellation of the
order
allotment.
dated 19/3/2021, bearing number Annexure E, issued by the respondent number 1 and 2. 1 ಅಂತ ಮಾಡಿ, ಬೆಂಗಳೂರು 1. ಕ್ಯಾನ್ಸಲ್ ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ?
ಅಲ್ಲ, annexure D ಅಲ್ಲಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ, annexure E ಅಲ್ಲಿ ರೀಅಲಾಟ್ ಮಾಡಿದ್ದಾರೆ.
Annexure D
Yes, my lords, annexure D is the cancellation.
has challenged the order dated, order bearing number so and so dated 10/2/2016. Annexure D cancelling the allotment of in flat or ಮನೆನಾ ಇದು?
ಮನೆ ಇದೆ my lords.
Cancelling the allotment of a house for non-payment of the allotment price within the time stipulated. They have also challenged the allotment of the house to the respondent number 3 in terms of the order bearing number so and so dated 3/1/2022. Full stop. Next para. The petitioner was allotted with a house on 16/6/2011 and was required to pay a sum of rupees 1,22,000, sorry,
12,22,450
in 4 equal installments, the last of which was on 26/10/2011. Full stop. The petitioner paid the last installment on 16/6/2011. 16/6 or 26?
ಅಲ್ಲ, ಲಾಸ್ಟ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಪೇಡ್ is my lords on 15/11/2011.
15/11/2011. Full stop. The respondent number 1 and 2 have therefore passed the impugned order cancelling the allotment of the house to the petitioner on the ground that the petitioner agreed to, on the ground that the petitioner was required to deposit the entire amount in one lump sum. Entire amount in one shot. Full stop. The respondents also issued letter of allotment allotting house to the respondent number 3 herein. Again?
Shivkumar.
He appears for R1 and 2.
R1 and R2.
R1 and R2. What about R3?
R3 is a private party, third and unrepresented. Third and unrepresented.
Being agreed with the said orders, comma, the petitioner is before this court. Next, for the learned counsel for the petitioner contends that the petitioner was required to deposit the value, the value of the site, the house in 4 installments, namely installments of rupees 3,05,600 each. He contends that the last installment was due on 26/10/2011. While full stop, he contends that the petitioner had paid the amount on 26/8/2011. Innondu yadu idu? Annexure C1, what is the date? Twenty-six?
7 ಇದೆ my lords.
26/7 ಅದು.
Yes.
26/7/2011, 15/11/2011 and 15/11/2011 respectively.
No, I'm
He
sorry.
submits
It
that
appears it is 9, my lords. Because it appears it is 9 because on earlier, my lords, first installment was on 26.
only.
Pardon, my lords.
ಸೀಲು ಹಾಕಿದ 15/11 ಅಂತ ಎರಡರಲ್ಲೂ.
ಅದು annexure C2 ಆಯ್ತು. C2 ಅಲ್ಲಿ I paid only 6,521.
What was that?
That was part of the let's say entire consideration amount.
Full stop. He submits that as per the letter of allotment, in the event of any delay in allotment, the petitioner was bound in delay in paying the allotment price, the petitioner was bound to pay interest. He therefore contends that the impugned or he therefore contends that the petitioner is willing to pay the interest for the delayed payment of the allotment price, and hence prays that the impugned orders passed by the response 1 and 2, and cancelling the allotment of the plot and re-allotting it to the respondent number 3 be set at naught. Full stop. The learned counsel for the response 1 and 2 submitted that the petitioner has failed to pay the allotment price as per the letter of allotment, and therefore the respondents 1 and 2 were well within their powers to cancel the allotment and allot it to a third person. Accordingly, he contends that the response 1 and 2 have cancelled the allotment and have allotted it to the respondent number 3. Next para. It appears from the letter of allotment that the petitioner was required to deposit, required to pay a sum of rupees 12,22,400 being the allotment price in 4 equal installments of rupees 3,05,600. These installments fell due on 26/11/2011, 26/8/2011, 26/9/2011, and 26/10/2011. However, the petitioner failed to deposit the allotment price on the dates mentioned above. But belatedly deposited the amounts on 26/8/2011, 26/7/2011, and 15/11/2011, 15/11/2011 respectively. Full stop. Therefore, though the petitioner had paid the allotment price, the same was not done within time. This at any rate did not empower. Thus it was not justified for the respondents 1 and 2 to cancel the allotment of the house after receiving the entire consideration and after 5 years thereafter. Full stop. Under the circumstances, the impugned order of cancellation of the allotment of the house to the petitioner deserves to be set aside. And consequently, the order of allotment of the site of the house to the respondent number 3 also deserves to be set aside. Hence, the following order: writ petition is allowed. The impugned order cancelling the allotment of the house to the petitioner is set aside, and consequently, the allotment of the house to the respondent number 3 by the response 1 and 2 is also set aside. The petitioner is directed to pay the interest payable to the respondents 1 and 2 within a period of 3 months from the date of receipt of a copy of this order.
The delay may be also notified because they can levy interest for a period of 5 years. Like in 2016 only.
Pay interest from the date the respective amounts fell due till the date the petitioner made the payment. Nagaraja N. Naidu. There is no representation for the petitioner. List on the Yalo Puttidola, Avate Putty. 5758 Yalo Puttidola, Avate.
My lord, submission, my lord. My the serial number 11 stay may please be extended, my lord. Serial number. Yes, sir. Yes, my lord.
You're practicing in the High Court, sir. There should be some, you should wait for your turn.
Yes,
ಒಂದೂವರೆ
apologize.
ಆಗಿಲ್ವಲ್ಲ?
Apologize, my apologize, my.
Hmm.
65, my lord, I am for the petition. Matter.
55 minutes.
Sir.
My lord, I am applying for the respondent number 4 to 6, my lord. Well,
56.
the prayer, my lord, or the petitioner has sought for the prayer for quashing the certificate of registration issued by the Waqf board, my lord.
Birthday. I'll come to that point also. May I take your lordship, my lord, the property bearing land in survey number 5, my lord, totally measuring 7 acre 18 guntas.
What is the document, order that is challenged?
My lord, the order under challenge is, my lord,
Annexure?
annexure V, annexure N,
ಏನಂತ ಹೇಳಿದ annexure ಈ ವಿ ಓದಿ?
V, my lord, what my learned friend is objecting is with regard to annexure N, my lord.
ಅಲ್ಲ, annexure V.
V.
273.
My lord. Now, my lord, the municipality, my lord, by virtue of this annexure V, at page number 273, ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖಿತ ಅರ್ಜಿ ಹಾಗೂ ರಾಜ್ಯ ಪತ್ರದಂತೆ ಹೈದರಾಬಾದ್ ರಸ್ತೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಕಾಲೇಜ್ ಪಕ್ಕದಲ್ಲಿರುವ ಗ್ರೇವ್ಯಾರ್ಡ್ಗೆ ನಗರಸಭೆಯಿಂದ ಹೊಸ ಆಸ್ತಿ ನಂಬರ್ ಸೊ ಎಂದು ನಂಬರ್ ನೀಡಿ ಅದರ ವಿಸ್ತೀರ್ಣ ಉದ್ದಳತೆ 183 by 83 SAS ಪುಸ್ತಕ ಪುಟ ಸಂಖ್ಯೆ 86ರಲ್ಲಿ ಗ್ರೇವ್ಯಾರ್ಡ್ ವಕ್ಫ್ ಆಸ್ತಿ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಎಂದು ನೋಂದಣಿ ಮಾಡಿಕೊಳ್ಳಲಾಗಿದೆ ಎಂದು ಈ ಮೂಲಕ ಹಿಂಬರ ನೀಡಲಾಗಿದೆ. This is at the instance of Karnataka Adhyaksha HS Jamale Bahar Hushir avara arji. My lord, they make an application to register, enter, my lord, in the municipal records as a work property. This property belongs to us. That is the reason, my lord,
Can you file a writ petition?
I'll take only 2 minutes of the court, how to, my lord, how this powers entrusted under the Waqf Act are been misused by the authorities. My lord, may I take your lordship to page number 155. This is the Khasra Pani of the year 1954-55. Type version at page number 156. Survey number 5. Survey number 5, my lord, totally measuring 7 acre 18 guntas. This is owned by my grandmother, Chanbasappa, son of How Shetty Patil. My lord, this is a patta land, my lord, since 1954-55. My lord, How Chanbasappa and Sharanappa were 2 brothers. My lord, Sharanappa filed a suit for partition in the year 1973. May I take your lordship to page number 28, which is the annexure A. This suit was filed in OS number 16, annexure A, my lord, page number 28. May I take your lordship to page number 30, my lord, for the reference, my lord. OS number 161 of 1973 was the original suit, which was renumbered as, my lord, 135/1992. This is a suit filed by Sharanappa, son of Haushetti, who is the brother of my, he is also my grandmother. Chanbasappa is my grandfather. My lord, he had filed a suit in respect of all the joint family properties. The properties could be found, my lord, in the schedule to this judgment, my lord, at page number 83.
Yes.
My lord, the first item, schedule A, first item is survey number 5, measuring 7 acre 18 guntas, along with other properties, my lord, which are the properties owned by the family. My lord, then, my lord, this judgment was passed, granting a share, my lord, half share in favor of, my lord, the Sharanappa. Then, my lord, it was a subject matter of a challenge before this honorable court in RFA number 11970 of 2002, annexure B, page number 85. My lord, appeal preferred by, my lord, my grandfather came to be dismissed, confirming, my lord, the grant of share of half share in favor of Shivshanap. Then execution was also preferred. After FDP, my lord, execution was also preferred at annexure C, page number 136. In the execution proceedings, a commission warrant was issued to the Tahsildar. Tahsildar drawn the Panchanama at page number 145, may I request. Then, my lord, the property is been divided. May I take lordship to page number 150, who is the Tahsildar, which has reported, my lord, bifurcating the portion.
Yes.
My lord, there is a railway track which has passed on in between the land during, my lord, pendency of the suit. Therefore, 26 guntas of land, my lord, is which bifurcates, my lord, survey page number 150, may I request.
Yes.
This entire 7 acre 18 guntas is bifurcated due to, my lord, passing of a railway line. Therefore, 1 and 2, my lord, at the top, and, my lord, 1 and 2 at the bottom. There is no dispute with regard to 1, 2, 1, 1. Now, my lord, these properties, my lord, are already been, my lord, subject matter of detailed civil proceedings, my lord, before this on court. And Hissa number 2 is already been converted as, my lord, the NA land, belong to Sharanappa, pursuant to the very same order. My lord, the name of my grandfather stood from 1954 till 2020. And thereafter, after his death, my lord, it was stood transferred in our name. Even till today, my lord, the revenue records stands in the name of, my lord, the petitioners. Now, my lord, what happens during pendency of this civil suit? My lord, one person, my lord, claiming himself to, my lord, may take lordship to page number 189. This is an application filed by one Kudrat Khan. This is not a notified Waqf under, my lord, section 5 of, my lord, that. One person, my lord, approaches, my lord, the Waqf board. My lord, graveyard Sunni, my lord, he gives, my lord, a description: East Karnataka School, West open space, in column number 2, may I request, my lord. This discussion ಹೇಳ್ತಾರೆ, survey number ಇಲ್ಲ, ಏನು ಬೇರೆ boundary ಏನೂ ಇಲ್ಲ. Then, my lord, he gives this application for
area of railway ಅಂತ ಏನೋ ಇದೆಯಲ್ಲ, area of railway.
South area of railway.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದು?
ಇದು 1979 ನಲ್ಲಿ ಕೊಡ್ತಾರೆ. This application is in the year 1979. My lord, based on this application, he also submits a sketch at page number 193. His own sketch, my lord, he prepares this sketch. And then, my lord, application filed by such person is being forwarded, my lord, by the chairman, local Waqf committee. Then, my lord, Waqf authority, my lord, puts a specific, my lord, query. Page number 196, may I request.
Yes.
Whether graveyard is notified in the Gazette, if so, page number 196. Page number 196, my lord.
Yes.
The Waqf secretary to, my lord, Karnataka Board of Waqf, they asked for, my lord, few clarification to the chairman, district Waqf committee. There are 4 points, my lord: whether graveyard is notified in the Gazette. If no, the correct survey number at which it is notified, total extent of a graveyard, who is the mutawalli, whether he is hereditary or nominated by Jamaat, whether the graveyard is attached to any mosque or separate management, the reason, if any, for its omission during the survey. Then, my lord, the reply, my lord, to this. My lord, at page number 198. The typed version at page number 199.
Yes.
Number 1, the graveyard has not been notified in the Gazette. The extent of any may be find out from the map already sent to your office. The petitioner is not the hereditary or nominated by Jamaat as Mutawalli. No records are available in this office about the appointment of Mutawalli in this office. Graveyard is in separate management. It is not attached to any mosque, since the graveyard situated in a unknown place. So it appears that it was not surveyed during the survey due to oversight. This is the report what they produce. Then, my lord, based on this, they ask, my lord, the secretary, my lord, directs, my lord, for issuance of a public notice. That is also very much relevant, my lord. May I take your lordship to page number 207. My lord, they issue this public notice, Janab Mohammed so and so, so and so. They give the proper description of the property, graveyard near Law College, Bidar, then east, west, north, south, they provide. My lord, the publication of this notice, my lord, is in the notice board of the board office, Bangalore. The chairman, district Waqf. Our office nalli, our notice board ಮೇಲೆ ಹಚ್ಕೊಳ್ತಾರೆ. Then, my lord, based on this, my lord, page number 209. I'm sorry, 205. 205, my lord. A certificate of registration under section 2526 of Karnataka Waqf Act 1954 came to be issued. No public notice, no individual notice, property stands in our name since, my lord, last 6 decades. My lord, this certificate is been issued and this publication is not been done even till today. I have secured the records under RTA also, whether there was any further notification of this property. My lord, may I take your lordship to 219 and 220. This is the latest order sheet maintained by, my lord, the Secretariat Office.
You will continue at 2:30.
Please.
My God, on submission. Serial number 3 amend the calculator ಬೇಡ. Stable extension.
ಮಾಡಿದಿರಾ?
ಮಾಡಿ ಸರ್. ಬೆಳಗ್ಗೆ
ಎಲ್ಲದರಲ್ಲೂ ಮಾಡಿದಿರಾ?
ಮಾಡಿ ಸರ್, ಆಲ್ ಕೇಸಸ್.
ಮಾಡಿದಾರ? ನೋಡಿದ್ರಾ ಇಲ್ಲ? ನೋಡಿ ನೀವು. ಎಲ್ಲದರಲ್ಲೂ ಮಾಡಿದ್ರೆ ವಿಲ್ ಎಕ್ಸ್ಟೆಂಡ್. ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನೋ ಎಕ್ಸ್ಟೆಂಡ್.
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಸರ್.
ಎಸ್ ಮಿಸ್ಟರ್ ಎಲ್ ಅಪೀಲ್ ಏನು ಹಾಕೊಳಕ್ ಹೇಳಿದೀನಿ. ಸರ್ ನಿಮ್ದು ಯಾವ್ದೋ ಒಂದು ಪಿಟಿಷನ್ ಇತ್ತು ನೋಡಿ.
ಮಾಡಿ ಹೇಳ್ರಿ.
ನಂಬರ್ 3 ನಾ ಮಾಡಿದೆ.
ಅಪೀಲ್
ಬೋತ್ ಇಬ್ರು ಮಾಡಿ ಸರ್.
ಇಬ್ರು ಮಾಡಿ.
ಇಲ್ಲ ಅಗಸ್ಟಿನ್ ಅವ್ರೆ, ನಿಮ್ದು ಯಾವ್ದೋ ಇನ್ನೊಂದು ಸಿ ನಂಬರ್ 63 ಇದೆ.
63
ಅದು ಕ್ಯಾನ್ಸಲೇಷನ್ ಗಿಫ್ಟೆಡ್ ಇದೆಯಾ, ಇದು ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್. ಅದು ಡೈರೆಕ್ಟರ್ ಮುಂದೆ ಅಪೀಲ್ ಹಾಕೋಬೇಕು.
ಪ್ಲೀಸ್.
ಸೊ ಐ ಪರ್ಮಿಟೆಡ್ ಯು ಟು ಫೈಲ್ ಅನ್ ಅಪೀಲ್.
ಪ್ಲೀಸ್.
Lots of serial numbers.
Pardon?
Serial number 17 interim order may kindly be extended.
Number
17, 17 may not.
ಚೆನ್ನಾಗಿದೆಯಾ?
serial number L1 model.
Yes, lordships.
ಚೆನ್ನಾಗಿದೆಯಾ ಅದು? Entry model extension.
Obliged. Sir, 17 ಒಳಗೆ ಆರ್ಡರ್ ಏನಾಗತ್ತೆ ಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್. ಸರ್ 17 ಸೀರಿಯಲ್ ನಂಬರ್ 17 ಒಳಗೆ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ? 17 ಒಳಗೆ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ?
17 ಹೇಳಿದಾರೆ
ಹಾ.
stay extend ಹೇಳಿದಾರೆ ತಗೊಳ್ಳಿ.
ಅಲ್ಲ, ಸ್ಟೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಯ್ತು, ಅದ್ರೊಳಗೆ ಏನೋ ಒಂದು IN 1 ಮೇಲೆ ಏನೋ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ ಅದಕ್ಕೆ ಕೇಳ್ತಿದ್ದೆ.
ಅದೆಲ್ಲ ಇಲ್ಲ, ಅದೆಲ್ಲ
ಏನಾಗಿದೆ? ಓಕೆ ಸರ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Court officer, sir. Serial number L1, sir.
ಸರಿ ಸರ್.
Sir, sir. Court officer. Sir. Sir.
ಸರಿ ಸರ್.
ಪಾಟೀಲ್
ಸರ್
ಪಾಸ್ವರ್ಡ್ ಕಂಟಿನ್ಯೂ ಆಗಲ್ಲ.
ನೋಡ್ಬೇಕು ಏನ್ ಮಾಡ್ತಾರೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 6 ನಲ್ಲಿ 6 ನಲ್ಲಿ ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ ಡೇಟ್.
ಹಾ, ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಪಾಸ್ ಆಗಿದೆ.
ಆಲ್ರೆಡಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿಡ್ ಔಟ್ ಮಾಡ್ಯದ, ಅಮೆಂಡ್ಮೆಂಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದೆ.
ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಇಲ್ಲ ನಮ್ಮ ಪೋರ್ಟಲ್ ನಲ್ಲಿ 2 ನಲ್ಲಿ ಇದ್ರೆ
ನಾನು ಇದ್ದಾಗ
ಅದೇ,
ಹೇಳ್ತಿದ್ರು, ಮಾಡ್ಯಾರ.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ ಎಲ್ಲೇ ಒಂದು ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದಿಲ್ಲ ನೋಡಿ ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಸರ್ 2:15 ಬರ್ರಿ, ನಾವು ಊಟ
Hello?
ಮಾಡ್ಬೇಕು. ಬ್ರಾಂಚ್ ಅವ್ರಿಗೆ ಹೇಳ್ರಿ ಮೇಡಮ್, ಹೇಳಿ ಅವ್ರಿಗೆಲ್ಲ ಬಂದು ಇದನ್ನ ಮಾಡಕ್ ಹೇಳ್ರಿ, ನೋಡಕ್ ಹೇಳ್ರಿ. ನಾವೆಲ್ಲಿ ನಮ್ಗ್ ನೋಡಕ್ ಟೈಮೇ ಸರಿ ಇರೋದಿಲ್ಲ. ಇಲ್ಲ ನಮ್ಗೂ ನನಗಂಟಿ ಟೈಮ್ ಇರುದಿಲ್ಲ, ಇಲ್ಲಿ ಯಾವ್ದು ನೋಡ್ಬೇಕು ಯಾವ್ದು. ಇಲ್ಲಿ ಹೋದ್ರಿಪ್ಪ ಅವ್ರು. ನನಗೆ ಅವ್ರ ಹೆಸರು ಸದೇ ಗೊತ್ತಿರೋದಿಲ್ಲ, ಅಡ್ವೊಕೇಟ್ ಹೊಸಬ್ರು. ನಿಮಗೆ ಇನ್ನೇ ಇಲ್ಲೆಲ್ಲ ಐಡಿಯಾ ಇರುತ್ತೆ.
ಏನಂತ್ರಿ ಏನ್ ಕೇಳ್ತ್ರಿ? 81 ಎದಕ್ಕೆ? 81 ನಿಮ್ದಲ್ಲ.
Production.
ಹೇಳಿ ಇವ್ರೆ ಸರ್ ಹೇಳಿ.
ಸರ್ ಮಂಜುನಾಥ್ ರಾಯಪ್ಪ ಸರ್ ಸರ್
ಹಾ ಹೇಳಿ
ಅಡ್ವೊಕೇಟ್
ಇವ್ರೆ.
ಕೇಳಿಸ್ತಾ ಇದೆಯಲ್ಲ ಸರ್?
ಅಲ್ಲ ಪಾಸ್ ಅವ್ರ ಮ್ಯಾಟ್ರ್ ಫಸ್ಟ್ ತಗೊಳ್ತಾರಾ?
ಅದೇ 1000 ಬಂದ್ಮೇಲೆ ಕೇಳ್ತೀವಿ ಸರ್, ಯಾಕಂದ್ರೆ ಒಂದು ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರ್ ಇದೆ, ಅದ್ ಮುಗಿದ್ಮೇಲೆ.
ಆ
ಒಂದ್ ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರ್ ಇದೆ, ಅದ್ ಮುಗಿದ್ಮೇಲೆ ನೋಡ್.
ಅದೇ ಬೆಂಗಳೂರಿಂದಾನೆ
ಹಾ ಬೆಂಗಳೂರು
ಸೀರಿಯಲ್ ನಂಬರ್ 5.
ಅಲ್ಲ ಸರ್, ಇಲ್ಲ ಬೆಂಗಳೂರು ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಒಂದಿದೆ,
ಹಾ
ಅದಾದ್ಮೇಲೆ
ಹಾ ಓಕೆ ಪಾರ್ಟ್ ರೆಡ್ ಅದು.
ಇಲ್ಲ.
ಸರಿ ಸರ್, ಓಕೆ.
ಯಾರು ಬೇಡ
The end of the list file number. File.
ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಗೌರ್ಮೆಂಟ್ ಬೇಡ ಬಿಟ್ಬಿಡ್ತೀವಿ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 5 ನಂಬರ್ ಪಾಸ್ವರ್ಡ್ ಆಯ್ತಲ್ಲ ನಂಬರ್ 5 ಅವ್ರು ಆನ್ಲೈನ್ ಮೇಲೆ ಅದಕ್ಕೆ ಮತ್ತೆ ಅದಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಕನ್ಸಂಪ್ಷನ್ ಆಯ್ತು, ನಾವು ಫೈಲ್ ವಾಪಸ್ ಕಳಿಸ್ತೀವಿ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ. ಆಮೇಲೆ ಮೇಡಮ್ ನಿಮ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನೋಡು.
ಹೇಮಾ ಮೇಡಮ್ 3.
Ravi Patil the first. Nandu registration. आप बाहर टंगा देना, नहीं टंगाते रोज, वो दैट इज अ फॉर्मेलिटी। कभी भी आते बराबर ही बाहर डाल देना, नहीं तो वो भी नेचुरल जस्टिस वायलेशन मिलती है।
Just to impugn order no.
अभी ಫಾರ್ಮಸಿ ಏನಂದ್ರೆ
ಆಲ್ರೆಡಿ
ಏನೋ ಎಂಟ್ರಿ ಮಾಡಿ ಏನ್ ಕೊಟ್ಟಾರ ನಿಮ್ಗೆ?
ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
ನಿಮ್ಗೆ ಎಂಟ್ರಿ ಮಾಡಿ ಏನ್ ಕೊಟ್ಟಾರ?
ನಾವು ಎಂಟ್ರಿ ಮಾಡ್ತಾ ಲೀಸ್ಟ್ ಫೈನಲೈಸ್ ಮಾಡಿ ಎಕ್ಸಾಮಿನೇಷನ್ಸ್ ಎಲ್ಲ ಅವ್ರು ಕೊಟ್ಟರು. ಅದಕ್ಕೆಲ್ಲ ಮತ್ತೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಎಲ್ಲ ಆಯ್ತು. ಈಗ ಅವ ಏನಂತಾನ ನಂದು ಆರ್ಡರ್ ಸ್ಟೇ ಇಲ್ಲ ಅಂತ. ಅಡ್ಮಿಷನ್ ತಗೊಂಡಿರುತ್ತೆ ಒಂದ್ ಏನೋ ಲೆಟರ್ ಬರ್ತಾನೆ ಅಡ್ಮಿಷನ್ ಮುಗಿದ ಡಿಸೆಂಬರ್ದಾಗೆ ಅದಕ್ಕೆ ಇಟ್ಕೊಂಡು ನನ್ನ ಆರ್ಡರ್ ಸ್ಟೇ ಇಲ್ಲ, ಇದು ಇನ್ಕಂಪ್ಲೀಟ್ ಆರ್ಡರ್
हाकिरे वेरी गुड। क्योंकि कभी भी क्या होता मालूम, यहाँ आपको झुक झुक के पूछना पड़ता है, क्या भिखारी मांगे जैसा होता
5 ಬೇಕೇ ಸರ್ ನನಗೆ.
है, मालूम होगा तेरा।
ಫಸ್ಟ್ ಏನ್ ಪಾಸ್ಔಟ್ ತಗೋತಾರೆ?
ಇಲ್ಲ ಇದು ನೀವು ನಿಮ್ಗೆ ಏನಿಸ್ತು ನಾಳೆ ಹೇಳೋದಂತ ಪ್ರಕಾರ ಮಾಡಿ ನೀವು ಹೇಳಿದ ಪ್ರಕಾರ 8 hours so comes to 68
Double multiple.
multiplier is
GST ಮತ್ತೆ 10%. ಅಲ್ಲೇ ಬರ್ತದೆ.
ಅಷ್ಟೇ ಅಷ್ಟೇ ಹೇಳೋದು ಅವ್ರಿಗೆ ನಾವು ಅಷ್ಟು ಕೊಟ್ರೆ ನಾವು
ಕಾಪಿ ಕೊಡ್ಲೇನು ಸರ್? ಒಂದು ಜೆರಾಕ್ಸ್ ಒಂದಿದ್ದು ಆದರೆ ಒಂದು ಒರಿಜಿನಲ್. ಇದು ಜೆರಾಕ್ಸ್, ಇದು ಒರಿಜಿನಲ್ ಅಲ್ಲ. ಆಯ್ತು ಇಟ್ಕೊಳ್ಳಿ.
Subject.
That's
13-1. 25 by 3, not 24. ಅದಕ್ಕೆ ಹೇಳಕತ್ತೀನಿ ಬರ್ರಿ ಮುಂದಕ್ಕೆ ಅಂತ.
ಇಲ್ಲ ಇದೆಯಲ್ಲಪ್ಪ ಇಲ್ಲ ಎಷ್ಟನೇ ಮೀಟರ್ ನೋಡೋದು
Millard on submission, Millard. Serial number 5 passover matter, Millard. Kindly have to day after tomorrow, Millard. Today some serial number 5 passout matter, Millard. Kindly have it of day after tomorrow, Millard.
ಯಾವ್ದೋ ಒಂದು ಸಣ್ಣ CPC ಮ್ಯಾಟರ್
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಫೈಲು ಏನಾಗಿದೆ ಹೋಮ್ ಆಫೀಸ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, ಹಂಗಾಗಿ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಮಾಡ್ತೀನಿ.
ನಾನೇ ನೋಡ್ಕೊಂಡು ಏನೋ ಮಾಡ್ತೀನಪ್ಪ.
ಅಲ್ಲ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ ಪ್ಲೀಸ್.
2012
ಹೌದು ಸ್ವಾಮಿ, ಐ ಅಗ್ರಿ ಗೊತ್ತಾಯ್ತು ಸ್ವಾಮಿ.
ಗೊತ್ತಾದ್ರೆ ನೀವು ನೋಡ್ಕೊಂಡೆ
ಅಲ್ಲ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಮಾಡ್ತೀನಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನಲ್ಲಿ ಆಲ್ರೆಡಿ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಸರ್. ಅದು ಬೆಳಗ್ಗೆ ನಾ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಗೆ ಸರ್. ಸ್ಟೇ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗ ಸರ್.
Interim order in force is extended till the next day.
ಡೇಟ್ ಬಿ ಫಿಕ್ಸ್ ಆಫ್ಟರ್ ಫಸ್ಟ್ ವೀಕ್.
ನೀವು ಯಾವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ? ನೀವು ಯಾವ್ದು ಒಂದು ಕೇಸು ಆರ್ಗ್ಯುಮೆಂಟ್ ಒಂದು ವಾರದಲ್ಲಿ ಯಾವ್ದು ಮಾಡಿಲ್ಲ, ಎಲ್ಲ ಅಡ್ಜರ್ಮೆಂಟ್.
ಎಲ್ಲ ಒಂದೇ
ಸತಿ ಥರ್ಡ್ ಟೈಮ್ ಯು ಆರ್ ಕಮಿಂಗ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಫಾರ್ ಅಡ್ಜರ್ಮೆಂಟ್.
ದಿಸ್ ಮ್ಯಾಟರ್ ನಾಟ್ ಟುಡೇ ಓನ್ಲಿ ಸರ್.
ಏನ್ ಹೇಳ್ತೀರಿ ಮತ್ತೋಗಿದ್ರೆ ಅಷ್ಟೇ. ನಾನು ಐ ಡೋಂಟ್ ಫರ್ಗೆಟ್.
30 ಸರ್. VS-ನಾಗ ಬರ್ತಾವ ಸರ್ ಬೆಂಗಳೂರು 30
ಸರ್. ನೀವು ಅಲ್ಲಿದೆ ನೋಡಿ, ಕೊಟ್ರಿ ಅದು ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ರಿ. ಅಲ್ಲಿದೆ ನೋಡಿ ಅಲ್ಲಿ. ನಿಮ್ಗೆ ಯಾವತ್ತು
ಅಲ್ಲ ಅದರ 27 ಅಲ್ಲ GM
ಯಾವತ್ತಿದೆ ನೋಡಿ
27 ಹಾಕ್ಸಿ ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡ್ಸಿ. ಬೆಂಗಳೂರು VS-ನಾಗ ಬರ್ತಾವ ಸರ್.
ಇದು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ ಕಣ್ರಿ. ಇದು ಯಾವತ್ತು ಬರುತ್ತೆ?
29 ಮಾಶೋ.
Serial number 10, my lord. The matter was passed over. The copy served ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರಿ. We have not received the copy yet, my lord.
Please wait. Yes, Rajeshwar.
My lord, I appear for the petitioner. My learned friend is also.
we are appearing for the respondents here. Lord, all the balance amount, my lord, is ready, my lord, by way of DD, my lord. We are handing over the DDs. The respondent is also here.
My lord, one humble submission before this honorable court, your lordship, unknown person DD ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರು ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಅದು ಮೆಮೋನಲ್ಲಿ ಬಂದ್ಬಿಡ್ಲಿ ಅಂತ ರೆಕಾರ್ಡ್ DDಗಳು ಅಂತ ನನ್ನ ಒಂದು.
ಈಗ ಒಂದು ಮೆಮೊ ರೆಡಿ ಮಾಡಿಟ್ಟಿದೀವಿ. ಈಗ ಅವ್ರು ಹೇಳ್ದಂಗೆ ಕರೆಕ್ಷನ್ ಮಾಡ್ಬಿಟ್ಟು ರೆಡಿ ಮಾಡಿ ಅವ್ರ ಹತ್ರ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡು ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡ್ತೀವಿ. ಈಗ DD ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ. 52 lakhs 50,000 ಡಿ ನ ರೆಡಿ ಆಗಿದೆ, ಡಿ ನು ಕೊಡ್ತಾ ಇದೀವಿ. ಲೆಟ್ ದಮ್ ಅಕ್ಸೆಪ್ಟ್ ದಿ ಡಿ ಮಲಾಡ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೇರ್ ಓನ್ ಟರ್ಮ್ಸ್ ಮಲಾಡ್. ವಿ ಆರ್ changing the version of the memo, and after getting the signature of all the parties malaad, we are going to file the memo in the registry. That's all malaad.
Please receive the DD, don't encash it. Please
ಅದು
receive the
ರೆಕಾರ್ಡ್
DD,
ಆಗಿದೆ.
only for the record of it.
Yes, ಮೆಮೊ ಒಂದು ಹಾಕ್ಬಿಟ್ರೆ ಕಂಪ್ಲೀಟ್ಲಿ.
The learned counsel for the respondent in serial number 1. Learned counsel for the response 1 to 3 has today handed over a demand draft for a sum of rupees.
Three demand drafts.
Three demand drafts malaad for a rupees of 52,550,000 malaad.
3 demand drafts dated.
Malaad, 3 different dates malaad. One is 4/1/2025, another is 26/12/2024, and 9/12/2025.
Basaraj 3/1/2025 ಒಂದು 4/1.
One ಅದು 4/1/2025. First.
For a sum of rupees only. For a sum of rupees 5,83,350. Another demand draft dated 26/12/2024, drawn on State Bank of India, 23,33,333.33, drawn by Lata my lord. Another my lord, dated DD dated 9/1/2025, drawn on State Bank of India for a sum of rupees 23,33,316.67 my lord.
4/1. Then
9/1/2025 my lord date.
26/12/24. For a sum of rupees 52 lakhs.
In total.
Full stop.
To 52,50,000 my lord. In total. Earlier they have paid 17,50,000 my lord. Overall total 70 lakhs my lord.
So the learned counsel for the respondent above. Learned counsel for the petitioner contends that the respondents 1 to 3 have not disclosed as to from whose account the demand drafts are drawn. Therefore, it is prayed that the respondents 1 to 3 be directed to disclose the particulars of the account from which the demand drafts are drawn.
And also PAN card my lord.
Full stop. The learned counsel for the respondents 1 to 3 undertakes to furnish the said information. List on yavat beko.
10th close my lord.
It may be closed my lord. We will file a memo to that effect.
File a memo. Yavat ಮಾಡ್ತೀರಿ?
My lord, day after tomorrow my lord.
ಅದು ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು.
Yes, next.
Please.
17. Correct. ಮಾಡಿದಿರೆ?
ಮಾಡಿದ್ವಿ ಸರ್.
Learned counsel for the petitioner has amended the cost rate. He is
And
also
ಕಾಸ್ಟ್ ನು ಕಟ್ಟಿದ್ದೀನಿ.
he is also paid the cost of rupees 2,000. Will you slip? 2,000. Full stop here. Receipt. 2,000. Full stop.
And ಅದರಲ್ಲಿ
Next para. The respondent number 4, an affidavit is filed by the petitioner stating that the respondent number 4 is alive.
Yes.
Therefore, IA 1 of 23 and 2 of 23. IA 1 of 23.
1 of 23 my lords already not press ಮಾಡ್ಕೊಂಡಿದೀವಿ. Already not press ಮಾಡ್ಕೊಂಡಿದೀವಿ 1 of 23. Because there is a office objection is there my lords. I am not.
IA 1 of 20, affidavit is filed stating that the respondent number 4 is alive. In that way of the matter, question of filing application for setting aside the abatement, etc. would not arise. List the petition for yavat beku.
Not any date my lords.
Yes, next.
ಅವ್ರಿಗೆ ನಾನು ಫ್ರೆಶ್ ನೋಟಿಸ್ ಕಟ್ಬೇಕು
On-
R4 ಗೆ.
List the petition for preliminary hearing in B group.
ಅಲ್ಲ R4 ಗೆ ನೋಟಿಸ್ ಕಟ್ಬೇಕು. R4 ಡೈಡ್ ಅಂತ ಬಂದಿದೆ, ಈಸ್ ಅಲೈವ್ ಮೇಲೆ ಸರ್.
Issue notice to
Correct.
R4.
ಎಸ್ ಮ್ಯಾಮ್.
Yeah,
ಇದ್ರೆ ಆಯ್ತಾ? ಇದಾರೆ ಆಯ್ತು ಸರ್. ಒಂದು ಡೇಟ್ ನಿಮಗೆ ಒಂದು
R4 either.
ಹೌದು ಸರ್ ಆಯ್ತು.
List for preliminary hearing B group on date could.
27 much obliged.
Biradar. AM Biradar. Seal number 6. 5 ಆಯ್ತಲ್ಲ ಮಾಡಿದಾರ ಬಂದಿದ್ರ ಬೆಳಿಗ್ಗೆ ಬಂದಿಲ್ವಾ? There is no representation for the petitioner as a last chance list on so and so. Ramachandra K.
Appearing for
Needful
R2.
Needful is done, my lord.
Counsel for the petitioner has amended the cost title. Office is directed to check and verify. Is there any interim
Copy.
order?
Copy is to be served on R2, my lord. Petition copy.
Counsel for the petitioner is directed to serve copies of the writ petition to
R2, my lord. Implemented respondent.
the respondent number 2. Yes. Liaquat ಮಾಡಿದಿರಾ?
Yes, my lord.
Allowing counsel for the petitioner has completed the office objections. Office is directed to check and verify. Interim order ಇದೆಯಾ?
No, my lord.
List this petition along with WP number so and so. ತಗೊಳ್ಳಿ. See number 13, 14, 15, 16 ಅದೇನಾ?
Yes, my lord.
13, 14, 15, 16 ಎಲ್ಲ ಸೇಮ್ order.
Please.
Full is done.
When the learned counsel for the petition submits that the required process fee and other requisites are deposited, office is directed to check, verify and proceed to issue notice. Interim order granted earlier is extended till the next date. Yes, Mali Party.
My lord, in this case, my lord, I am appearing for the petitioner, my lord. I'll take instruction, my lord. My client has filed the appeal before the state government on the basis of annexure F, my lord. But subsequently, my lord,
appeal file ಮಾಡಿದಾರ ಇಲ್ವಾ?
ಮಾಡಿದ್ದಾರೆ.
Recall, learned counsel for the petitioner, the petitioner has challenged the rejection of the technical bid in this writ petition. Next para. The petitioner, the learned counsel for the petitioner submits that the petitioner has filed a statutory appeal before the competent authority challenging the order of rejection of the technical bid. In view of the aforesaid submission, this petition does not survive for consideration. Hence, the petition is dismissed.
My lord,
However, it is open for the petitioner to urge all the contentions raised in this writ petition in the statutory appeal filed. Yes, what about 26?
Same, my lord. 26,
Same
26.
order. 27, same order. Either HCGP is permitted to file memo of appearance within 10 days. AGA is directed to permit within 10 days. Next. Same rate.
25, 26, 27. Same.
Puru same. 43. Mr. NM Gate.
I have taken steps, my lord.
Huh?
I was directed to take hand summons to the respondent number 2 LRs. I have served the hand summons, my lord, to the respondent counsel before the trial court. On 16/11/2023, I have filed a memo, my lord.
Trial court ಅಲ್ಲಿ record ತಂದಿದಾರಾ?
Yes, my lord.
In the trial court, whether LRs of respondent number 2 is brought on record.
They are brought on record, my lord. They are brought on record and represented by the counsel. So I was directed to serve them, counsel, my lord. So counsel has served, my lord.
ಕೊಡಿ ಅದು. Where is the hand summons?
Hand summons, the file ಮಾಡಿದೆ ನಾವು serve ಮಾಡಿ.
ಕೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ವಾಪಸ್?
Yes, my lord. 16/11/2023 memo. The acknowledgement itself I have produced, my lord, signed by the respondent advocate. Yes,
ಏನು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ.
please.
ಸುಮ್ನೆ ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ.
ಇಲ್ಲ, the acknowledgement along with presentation form I have produced, my lord.
ನೋಡಿ ನೀವು ಮೆಮೊ ಬರ್ದಿರಿ ನೋಡಿ. I filed a writ petition with regard to FDP challenging so and so. High Court has ordered to serve a copy of the writ petition
Yes,
on the advocates who represents the respondents before the trial court.
yes, my lord.
As you represent respondents before the trial court in FDP, I am serving. Respondent number 2 LRs ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
LRC ಅಂತ ಹೇಳಿದ್ದೀನಿ.
ಕೊಡಿ ಇಸ್ಕೊಳ್ಳಿ.
Install ಮಾಡಿ. LRC.
LRs ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ ಸರ್? ಎಲ್ಲ ಕೊಡ್ರಿ ಅವ್ರು ಓದ್ಲಿ.
LRs of respondent number 2.
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ? ಎಲ್ಲಿ ಹೇಳಿದಿರಾ ಲೆಟರ್ LRs of respondent number 2 ಅಂತ? ಕೊಡಿ ಅವರು.
Respondents before the trial court. But the LRs of respondent number 2, they are already.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್. I can't put it in writing. ಕರೆಕ್ಟ್ ನೀವು ಸರ್ವ್ ಮಾಡ್ಕೊಂಬನ್ನಿ, I can take it. ಬರ್ಕೊಡಿ.
May kindly be directed to reissue. Now paid the PF also today.
Pay the process. 1 week time is granted. You have paid the process.
I have paid.
Learn counsel for the petitioner.
Today also I have paid the process.
Submits that he has paid the process to issue notice to the LRs of R2.
Yes.
The process is paid and is in order, office is directed to issue notice to the LRs of R2. On IA number 1, 2,
3,
3, 1 of 23, 1 of 24, and 2 of 22. Same matter, either IA 1 of 24, 2 of 24, 3 of 24. Connected matter. Yes, next. Connected matter R4, amma.
My lord, I served copy, my lord.
I have received the copy, your lordships.
The learned counsel for the petitioner. The petitioner has challenged the rejection of the technical bid.
Yes, your lordships.
Rejection of the technical bid. In this writ petition, the petitioner has challenged the rejection of his technical bid by the respondents. When it was brought to the notice of the learned counsel for the petitioner that a statutory appeal is provided under section 19 of the
16.
16 of
16
of the
ATP.
Karnataka Transparency in Public Procurements Act 1999. 1999.
Yes.
The learned counsel submitted that the respondents have not furnished the reasons for rejection of the technical bid. Full stop. The learned AGA has today handed over copies of the reasons for rejection of the technical bid of the petitioner. In that way of the matter, this writ petition is disposed of, permitting the petitioner to challenge the rejection of the technical bid before the competent authority in accordance with under section 16 of the KTPP Act 1999. Full stop. The time consumed in pursuing this petition shall be excluded while considering the period of limitation applicable to an appeal. Yes.
Obliged, lordships.
51, 52 same, 51.1 same. Yes, next. 50? 56.
For respondent 5 and 6.
Yes.
It's the only purpose of approaching the respondent number 2, where respondent number 4 and 5. Notes was that Ali's division was with, lords, in the absence, conducted in the absence of the respondent number 4 and 5.
But you sold it.
Lords, I have not sold it.
Who has sold it?
It was one Vijay Lakshmi who has sold it, my lords.
Vijay Lakshmi heng bantu?
She has
Number
purchased.
4.
From whom?
No, not
From
respondent number 4. Lords, I am the owner of survey number 129/1.
You are the owner.
Yes.
But Vijay Lakshmi yarinda purchase madodu?
Adu.
In page 40, my lord.
DC order ಓದಿ. Page
Page 40. it has come.
DDLR order ಇದೆ ನೋಡಿ ಓದಿ.
Annexation. BLS.
Page 41.
Srimati Vijay Lakshmi.
ಬಸನಗೌಡ ಸಂಕನಗೌಡ ಪಾಟೀಲ್ ಓದ್ರಿ.
ಎದುರುದಾರರು ಶ್ರೀಮತಿ.
ಅಲ್ಲಪ್ಪ ಬಿ ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕು ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ಪೇಜ್ 41.
Yes,
ಆರ್ಡರ್ ಆಫ್ ದಿ ಡೆಪ್ಯೂಟಿ ಡೈರೆಕ್ಟರ್.
ನಾನು ವಿಜಯಪುರ ಜಿಲ್ಲೆ ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕು ಪೈಕಿ ಬಸವನ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 129/1ರಲ್ಲಿ ತಯಾರಿಸಿದ ಸೋ ಅಂಡ್ ಸೋ ಆಕಾರ ಬಂದ್ PT ಶೀಟ್ಗೆ DDLR ವಿಜಯಪುರ್ ಇವರ ಆದೇಶ ಇದರಿಂದ ಬಾಧಿತರಾಗಿ ಈ ರಿವಿಷನ್ ಅರ್ಜಿಯನ್ನು ಮಾಡಿಕೊಂಡಿರುತ್ತೇವೆ. ಸದರಿ ರಿವಿಷನ್ ಅರ್ಜಿಯನ್ನು ನಾನು ನಿಗದಿತ ಸಮಯದಲ್ಲಿ ಮಾಡಿದ್ದು.
ಅದೆಲ್ಲ ಬಿಡು. ಪ್ಲೀಸ್ ಕಮ್ ಟು ಪೇಜ್ 41, ಇಂಟರ್ನಲ್ ಪೇಜ್ 3 of the DDLR order.
DDLR order, yes. ಬಸವನ ಬಾಗೇವಾಡಿ ತಾಲೂಕು ಬಸವನ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 129/1ರಲ್ಲಿ ಇದು ಸೋ ಅಂಡ್ ಸೋ ತಯಾರಿಸಿದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳು ಕಂದಾಯ ದಾಖಲೆಗಳನ್ನು
ಅಂದ್ರೆ ಹಿಸ್ಸಾ ದುರಸ್ತ್ ನಂಬರ್ -17/18 ರೆಡಿ ತಯಾರಿಸಿದ ಹಿಸ್ಸಾ ದಾಖಲೆಗಳು
ಕಂದಾಯ ದಾಖಲೆಗಳಲ್ಲಿ ಕಾಲೋಚಿತಗೊಂಡಿರುತ್ತದೆ. ಮೇಲ್ಮನವಿದಾರರು ನಂಬರ್ 1 ರವರು ಸರ್ವೆ ನಂಬರ್ 129 ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ 24 ಗುಂಟೆ ಪೈಕಿ 35 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಜಮೀನನ್ನು ಶ್ರೀ ಬಸವನಗೌಡ ತಂದೆ ಸಂಕನಗೌಡ ಪಾಟೀಲ್ ಇವರಿಗೆ ನೋಂದಾಯಿತ ಖರೀದಿ ದಸ್ತ ಸಂಖ್ಯೆ ಕ್ರಯಕ್ಕೆ ಕೊಟ್ಟಿರುವುದು ಖರೀದಿ ಪತ್ರದಿಂದ ಖಚಿತಪಟ್ಟಿದೆ.
ಏನಂದ್ರೆ ಅರ್ಥ?
Notes, my father although have sold it, my lords, but then it is my specific contention that, my lords, my major portion of the property runs on the roadside, my lords. Road, my lords, lies on the eastern side of the property. So now,
where is the sale deed? Where is the sale deed executed by your father?
Sale deed I do not have now, but all the records, my lords, earlier records, which shows that, my lords, the property is divided because there is also a well. It was the understanding between my father and, my lords, one other person, Sankan Gowda, that well should lie to both of us. That should be, my lords, in possession of both of us.
Not the issue. See, ಹಂಗೆಲ್ಲ ಇದ್ರೆ ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ.
ಅಲ್ಲ, the earlier records show that, my lords, that is running from east to west.
That is not the issue. ನೀವು ಸೇಲ್ ಡೀಡ್ ಬರ್ಕೊಟ್ಟಿದ್ದೀರಿ.
Yes, my lords.
35 ಗುಂಟೆಗೆ ಸೇಲ್ ಡೀಡ್ ಬರ್ಕೊ.
Yes, my lords.
If you, then Baswangowda sold it to this lady,
Vijay Lakshmi.
Yes,
Vijay Lakshmi files an application for Podi.
yes, 129/3 ಆಗುತ್ತೆ.
ಅದು 129/3 ಆಗುತ್ತೆ. She has sold it to this Mohan.
And it's by virtue of that sale deed, my lords, they are contending major portion of the land which runs, my lords, adjacent to the road. Now they want that portion of the land rather than which is sold to them.
Raipatra ತೋರಿಸಿ, what is the boundary? You have a copy?
I do not have the
Madam,
copy.
copy.
ಇಲ್ಲ ಅವ್ರ ಕಾಪಿ ಇಲ್ಲ, ನನ್ ಸೇಲ್ ಡೀಡ್ ಇದೆ.
ಅದೇ ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ತೋರಿಸಿ.
Yes.
ಬಸವನಗೌಡನ್ ಸೇಲ್ ಡೀಡ್ ಇದೆಯಾ?
ಇಲ್ಲ. Lordship, page number 24. Page number 24, Lordship. Vijay Lakshmi sold to Mohan. That sale deed is there, Lordship.
It is not your case.
That itself is my contention that, my lord, she has wrongly shown the boundaries anta.
ಯಾವುದು?
My lord, sir, that ಪೂರ್ವಕ್ಕೆ ರಾಜಶೇಖರ್ ಪಾಟೀಲ್ ಇವರು ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ಬಾಬುಗೌಡ ಪಾಟೀಲ್ ಇವರ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ನಾಗೂರ್ ರಸ್ತೆ ಟು ದ ಸೌತ್, ಅಂಡ್ ಉತ್ತರಕ್ಕೆ ದಾದಾಗೌಡ ಪಾಟೀಲ್ ಇವರ ಜಮೀನು.
Is it your case that the Podi
Yes.
sketch does not correspond to these boundaries?
Yes.
Source.
I do not have that document. ಅದಕ್ಕೆ ನಾವು
Appeal ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದೆ ತೋರ್ಸಪ್ಪ. Where have you said that the boundaries mentioned in the sketch do not correspond with the boundaries mentioned in this deed? ಏನಾದ್ರು ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ?
ರ್ಯಾಂಡಮ್ ಆಗಿ ತಗೊಂಡಿದ್ದೆ. ಪ್ಯಾರಾ ನಂಬರ್ 3. That first, my lord's appeal memo. May I kindly read? ತಾಲೂಕು ಸರ್ವೆ ನಂಬರ್ so and so ಬಸವನ್ ಬಾಗೇವಾಡಿ ರವರ ಬಸವನ್ ಬಾಗೇವಾಡಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 129ರಲ್ಲಿ 1 ಮತ್ತು 3 ಹಿಸ್ಸೆಗಳನ್ನಾಗಿ ತಯಾರಿಸಿದ ಆಕಾರ ಬಂದ್ ಪ್ರಕಾರ ಮೇಲಿನ ಜಮೀನುಗಳನ್ನು ಸರಿಯಾಗಿ ಅಳತೆ ಮಾಡಿ ತಯಾರಿಸಿರುವುದಿಲ್ಲ. ಸದರ ಜಮೀನುಗಳು ಅಳತೆ ಒಂದಕ್ಕೊಂದು ತಾಳೆ ಹೊಂದುತ್ತಿಲ್ಲ. ಈಗ ಸದರಿ ಜಮೀನುಗಳನ್ನು ಅಳತೆ ಮಾಡುವ ಸಲುವಾಗಿ ನೋಡಿದರೆ ಸದರಿ ಆಕಾರ ಬಂದ್ PT ಶೀಟ್ ಪ್ರಕಾರ ಇಲ್ಲದ್ದು ಕಂಡು ಬರುತ್ತದೆ. ಸದರಿ ಆಕಾರ ಬಂದ್ PT ಶೀಟಕ್ಕೂ ವ್ಯತ್ಯಾಸವಿರುತ್ತದೆ. ಇದರಿಂದ ಭಾರಿ ತೊಂದರೆಯಾಗುತ್ತಿದೆ. ಅಪೀಲ್ದಾರರಲ್ಲಿ ಭಿನ್ನಾಭಿಪ್ರಾಯಗಳಾಗಿ ಭಾರಿ ತೊಂದರೆಯನ್ನು ಅನುಭವಿಸುತ್ತಿದ್ದಾರೆ. ಎದುರುದಾರರು ಸದರಿ PT ಶೀಟ್ ಅನ್ನು ಮಾಡಿಕೊಳ್ಳುವಾಗ ಅಪೀಲ್ದಾರರನ್ನು ಹಿಸ್ಸಾ ನಂಬರ್ 4ರಲ್ಲಿ ಗೈರು ಹಾಜರ್ ಅಂತ ತೋರಿಸಿ ಬೆಕ್ದೇಸಿರಿ PT ಶೀಟ್ ಅನ್ನು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಸದರಿ PT ಶೀಟ್ ತಪ್ಪಿನಿಂದ ಕೂಡಿದ್ದು ಇರುತ್ತದೆ. ಈಗ ಎದುರುದಾರರು ಸದರಿ ಜಮೀನನ್ನು PT ಶೀಟ್ ನಲ್ಲಿ ಇದ್ದ ಪ್ರಕಾರ ತಮ್ಮ ಕಬ್ಜಾಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲು ತರಾತುರಿಯಲ್ಲಿರುವುದರಿಂದ
produce all the sale deeds. Whatever sale deeds that are executed, produce them.
Yes.
If that is the case, one of you will have to go before the civil court. Barcode, the learned counsel for the petitioner and the learned counsel for the respondents. 4 and 5 are directed to place on record the sale deeds dated 18/5/1998, comma, the sale deed in favor of Srimati Vijay Lakshmi, respect of 35 guntas of land in resurvey number 129/1. Yavat martira? When will you do it?
2 weeks time.
Just ask your client to send it by WhatsApp.
I'll check.
Next week, ಹಾಕೊಳ್ರಿ.
Note 21 lordship, 24.
ಯಾಕೆ ಕಲಬುರ್ಗಿ ಲಾಯರ್ಸ್ ಎಲ್ಲ ಸ್ಲೋ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಾ ಚಳಿ ಅಂತನ? All lawyers have become slow. I don't know why.
24.
ಯಾರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿಲ್ಲ, ಎಲ್ಲಾ ಕೋರ್ಟಲ್ಲೂ ಟೈಮ್ ತಗೋತಿದ್ದೀರಾ. I don't know what is wrong
One
with you people.
request in this matter.
Huh?
In this matter, lordship, one request. However, lordship, the deputy commissioner have no jurisdiction to pass
No,
the
that's
order.
okay.
that,
If
not
it is,
insofar as that is concerned.
Transfer to the.
I don't want to send you back to the same authority. Let me decide it once and for all. If
This
not.
One
either
of my
this-
submission, lordship, if
That
at the time of call-
notification does not
I'll
have
get the records
retrospective effect.
first. I'll get the
Produce
sale date,
ಮಾಡಿ ನೋಡು.
please.
ತಿರ್ಗಾ ಅವ್ನು madam, sending a litigant back to another forum, it's easy for you to say.
Yes,
But litigant ಎಷ್ಟು ಕಷ್ಟ ಇದೆ ಅಂತ if you don't understand.
yeah, I can understand, but lordship,
ಮತ್ತೆ ಒಬ್ಬ ಲಾಯರ್ ನೋಡ್ಬೇಕು, DC ಆಫೀಸ್ಗೆ ಹೋಗ್ಬೇಕು, ಎಷ್ಟು ಕಷ್ಟ ಇದೆ ಅದು.
one of my submission, lordship, it is, well, at the final argument, it may be considered, lordship.
Yes,
Meanwhile,
produce-
I'll get the
produce
records.
documents.
Yes, lordship, I'll get the
Right.
records.
Yes, Anant.
Yes, sir. As per the instructions, your lordship,
Hmm.
already there are about 15 to 15 members have filed their application for the same plot.
That is for the
And
subsequent.
they were about to auction the plat as there were more than 6 persons were there for the single plot. So the meantime, this writ petition is filed and the interim order is sought. For that, the entire further proceeding is stopped for that reason only. So we have no objection if he is also competent with the others also.
Who are you to say no objection?
No, this is,
Who are you to say? ನೀವು ಅಪ್ಪನ ಮನೆದ ಆಸ್ತಿ ಮಾರ್ತಿದ್ದೀರಾ
no, no,
ಗೌರ್ಮೆಂಟ್ ಆಸ್ತಿ ನೀವು ಮಾರಾಟ ಮಾಡ್ತಿದ್ದೀರಾ ಮತ್ತೆ ಅವ್ರು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂದ್ರೆ ಹೂ ಆರ್ ಯು ಟು ಸೇ ನೋ ಅಬ್ಜೆಕ್ಷನ್
we have, if he is,
ಮಿಸ್ಟರ್ ಹೂ ಆರ್ ಯು ಟು
Yes.
ಗಿವ್ ಪರ್ಮಿಷನ್ ಯು ಹ್ಯಾವ್ ಟು ನೋಟಿಫೈ ದೇ ಹಿ ಪರ್ಮಿಟ್ ಏನು ಧರ್ಮಕ್ಕೆ ಕೊಡ್ತಿದ್ರ ನೀವು
Nila. He is already, we have issued notice.
participate, he will participate.
Yes, he is already issued notice. He received it. He replied to that notice of cancellation.
Is okay.
Yes, you are.
But now auction permit ಮಾಡಕ್ಕೆ no objection ಅಂದ್ರೆ who are you to say that?
Sorry.
You can participate as a matter of right. ನೀವೇನ್ ಕೊಡ್ತೀರಾ ಅವಕಾಶ ಏನು ಕೊಡೋದಿಲ್ವಾ? Making a statement, be
Sorry.
conscious of what you are saying, mister.
Yes.
You again ದುಡ್ಡು ತಗೋತೀರ ಆಸ್ ಆಫ್ ಮಾರ್ಕೆಟ್ ರೇಟ್ ದುಡ್ಡು ತಗೊಂಡು ಅವ್ರಿಗೇನು ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ? ಇಲ್ಲಿ ಆಗುತ್ತಾ ಇಲ್ವಾ ಅದನ್ನ ಹೇಳಿ.
As per rules, it is not permitted, Your Worship,
Illi
because
the-
already we have cancelled it, we have informed it. And new notification has been also published on 17/12/21.
Where is
As
that?
per that, Annexure,
ಅಲಾಟ್ಮೆಂಟ್ ಪ್ರೈಸು ಕಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ.
EMD ಮೇಲೆ 50,000
EMD ಅಲ್ರಿ. ಅಲಾಟ್ಮೆಂಟ್ ಪ್ರೈಸ್ ಕಟ್ಟಿಲ್ವಾ ಅಂದ್ರೆ EMD ಮೇಲೆ
ಇಲ್ಲ, ಪೂರ್ತಿ ಅಮೌಂಟ್ ಕಟ್ಟಿಲ್ಲ ಸರ್. ಪೂರ್ತಿ ಅಮೌಂಟ್ ಕಟ್ಟಿಲ್ಲ.
Annexure F is the notification.
We had applied for subsidy also, that subsidy would also come as per my instructions. As per the allotment notification.
ಎಲ್ಲಿ ಆಕ್ಷನ್ಗೆ ಎಲ್ಲ ಹಾಕಿದ್ರಿ?
But it's not auction, it's a regular allotment, page number 30.
Now he says that yes, they have put it up for auction.
No, this we were, because there were we are permitted to submit these documents, Your Lordship, wherein
ಕೊಡಿ ಅದೇನು.
these are the sole documents, details regarding the persons who were, number of the person, list of the persons who are now applied for that. These the name.
Is this a corner property?
No, Your Lordship, it is not a corner.
Then?
Use the corner.
And you're not following any rules. There's no seniority list. You don't call for application. ಯಾರ್ಯಾರು ಬಂದ್ರು ಯಾರ್ಯಾರು ದುಡ್ಡು ಕೊಡ್ತಾರೋ ಅವ್ರ ಹತ್ರ ಇಸ್ಕೊಂಡು ಅಪ್ಲಿಕೇಶನ್ ತಗೊಳ್ಳೋದಾ ಹೆಂಗಿದು?
Well, as per the notification, those persons who are applied, that process we have followed.
ತೋರಿಸಿ.
Will follow.
Produce
The entire
what is the process that you undertake? Publication ಮಾಡಿದೀರಾ?
Yes.
Have you published?
It is there.
ತೋರಿಸಿ.
I may. Entire process will publications. It is there, we have published, but requires some 2 days time, Your Lordship, or to get all those documents, Your Lordship.
You published the
As per instructions, they have published it. On the publications only they have.
Yes, Ravi.
Annexure D is passed at Annexure D, the date of.
ಆಯ್ತು ನಿಮಗೆ ಅಲಾಟ್ ಆಯ್ತು ನಿಮ್ಗೆ ನೀವು ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ. What can be done?
We are ready to pay, because of unforeseen circumstances, not be paid in time.
We do not know whether
Being the only son, had to take care of a father.
that is not a ground ಬರ್ಕೊಡಿ.
Annexure D may request, one for a moment.
petitioner.
And the subsidy has also reached, the KSSIDC as per my instructions.
Yes.
It is for the scheduled caste candidate, this allotment was made.
Matter ಬರ್ಕೊಳ್ಳಿ. The petitioner has challenged the impugned communication bearing number so and so dated 8/11/2021, cancelling the allotment of an industrial plot for non-commissioning of the unit within the time stipulated. The petitioner has also has also challenged the notification bearing number so and so dated so and so issued by the respondent number 1, communicating the decision of the board. He has also sought for a writ in the nature of mandamus to direct the respondents 1 to 3 to consider the predicament of the petitioner for extension of time to pay the consideration, to pay the allotment price. Next para. The petitioner submits that he had filed an application seeking allotment of an industrial plot against a notification dated 12/2/2018. Full stop. He was allotted a plot bearing number Q-03, measuring 546 square feet, situated industrial area, Kolhar, Bidar, void allotment letter dated 19/2/2019. Full stop. The allotment was subject to conditions, namely that the petitioner was bound to pay the balance of the allotment price. Within
90 days.
Within 90 days.
Page number 31, your lordship.
Within 90 days.
Page
And
number
two,
30. Page number 31, para 3.
My lord, clause number 2 will apply. Clause number 2 in this order, my lord, will apply. End to trimester installment nal katbodu, and it is after
within 90 days. To pay rupees 2,33,000 within 90 days, and the balance 2,32,050 in 3 months installments, in 8 quarterly installments of rupees 33,232. Full stop. He was also required to obtain plans of the buildings within 1 year from the competent municipal authority, and to commence commercial production within how many years?
3 ವರ್ಷದೊಳಗೆ.
3 years or 2 years?
3 years. Clause number 5.
Clause number
5. Page number 31.
Within 3 years.
3 ವರ್ಷ.
Full stop. The petitioner could not comply with the above in view of since his father was diagnosed with certain medical ailments. Medical ailments. ಏನಾಯ್ತು ಅವ್ರಿಗೆ?
He has lost both eyes.
That is of the year
Medical
21.
ailments. Huh?
28/9/21
Lost
discharge
both
card.
eyes, my lord.
21 discharge card ಇದೆ ಮಾ.
ಅವಾಗೆ
Full stop. The respondents thereafter initiated proceedings for cancellation of the allotment for non-compliance of the terms of allotment, and passed the impugned order cancelling the allotment, which was intimated to the petitioner. The petitioner is therefore before this court seeking for challenging the aforesaid orders of the respondents. Next para. The learned counsel for the petitioner contends that the petitioner was prevented from sufficient cause in paying the amount, paying the allotment price, and also in implementing the project, and therefore implement the project. Full stop. He, however, contended that the petitioner is willing to pay the allotment, the present day allotment rate. Full stop. He submits that the petitioner belongs to scheduled caste, and therefore cancelling the allotment would cause irreparable loss and injury to the petitioner. Per contra, the learned counsel for the respondent submit that petitioner was allotted the industrial plot subject to certain conditions. So the petitioner had accepted the said conditions and had agreed to comply with the conditions. He therefore submits that the petitioner cannot now turn around and cite reasons for not implementing the project in time and in not paying the allotment price. We'll stop next para. The purpose of formation of any industrial area
Is also expressed reason
through
for.
the instrumentality of the state is to ensure industrial growth and generate employment, for which purpose the state government has evolved schemes and has such as granting subsidy for entrepreneurs who establish industries in remote parts of the state. Similarly, enormous benefits are provided by the state government for persons belonging to the scheduled caste, scheduled tribe, who establish industries. Full stop. Therefore, the whole purpose of allotment of an industrial plot is to encourage industrialization, provide employment, and generate income for the promoter, and thereby contribute to the national wealth. Full stop. In the case on hand, comma, though the petitioner was allotted an industrial plot by the respondents, and though he was well aware of his obligation to pay the allotment price within the time stipulated,
In 3 months.
comma, he failed to do so. Full stop. This court cannot lose sight of the fact that the formation of industrial area depends upon the allotment price received from the allottees. Full stop. Therefore, the reason mentioned by the petitioner for not paying the allotment price within time
Even there was a
is
COVID
unacceptable.
restriction. COVID, within 3 months, there was a COVID restrictions started.
ಏನ್ 3 months?
Allotment date ಆದ್ಮೇಲೆ 3
ನಿಮ್ಗೆ
ತಿಂಗಳು
ಯಾವಾಗ ಅಲಾಟ್ಮೆಂಟ್ ಆಗಿದೆ ಯಾವಾಗ?
November 2019. ಇಲ್ಲ February 2019.
ಮತ್ತೆ?
I am sorry.
Full stop. This apart, comma, the petitioner has not even taken any steps for obtaining a plan of the building to be constructed from the concerned municipal authority, has not made any groundwork such as placing indents for supply of equipment and machinery, recruiting employees for the intended unit, etc. Full stop. It therefore appears that the petitioner has obtained the allotment of the plot with no apparent desire to establish the unit. In that view of the matter, the respondents were justified in cancelling the allotment of the industrial plot to the petitioner. Now that the respondents have already notified the auction of the subject industrial plot, it is this court cannot come in the way of the respondents proceeding in the manner. So hence this writ petition lacks merit and is dismissed. The respondent shall conclude the auction. The respondents shall issue a fresh publication inviting bids from any person interested and proceed in accordance with law. The same shall be complied within a period of 3 months from the date of receipt of a copy of this order.
In the second matter,
Sanjeev
your
Kumar.
lordship. As per the instructions, there's the respondent number 3 has recently taken charge. And as per the respondent number 3, recently taken charge, and it is pertains to the bidder industrial development area.
ಅದೇ ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು 75.
One week time may be granted
Ah.
to verify whether that allotted plot is, whether agreement for lease cum agreement seal is executed in favor of those respondents or not.
But
1
for
week
the
time
learned-
may be given, within that we'll submit all those
The
documents.
learned counsel for the respondent number 5 is directed to secure information about the learned counsel for the respondents number 5, respondent number 5 is directed to secure information about the status of the
Allotment.
plot bearing number 3, bearing number
Special
special 3
at bidder
at Kolhar Industrial Area, Bidar.
and
Special number 41.
and special 41 at Humnabad.
Special.
ಹುಮ್ನಾಬಾದ್ ನಿಮ್ಗೆ ಅಲಾಟ್ ಆಗಿದೆಯಲ್ಲ?
Ready ಆಗಿದೆ.
ಅಲ್ಲ ಅದು 25 ದಿ ಎಕ್ಸ್ಟೆಂಟ್ ಈಸ್ ಮಿಲಾರ್ಡ್ ಲೆಸರ್. ಇವು ಎರಡು ಕಂಪೇರ್ ಮಾಡಿದ್ರೆ ಐ ಆಮ್ ದಿ ಹೈಯರ್.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ನಿಮ್ಗೆ ಹುಮ್ನಾಬಾದಲ್ಲಿ ಬೇಕೋ ಕೊಲ್ಲಾರ್?
ಬೀದರಲ್ಲಿ
ಅದನ್ನ ನೋಡೋಣ ಲಿಸ್ಟ್ ಆನ್ ಯಾವತ್ತು?
Next week, any day. Much.
Ravi B. Patil.
Okay. As I pointed out, my lord, this process, my lord, of issuing this certificate of registration till today is not been published, my lord, in the official gazette. My lord, the order sheet, my lord, I was drawing attention of the court, my lord, 219.
Two
219. This is the note sheet maintained by the secretariat, my lord, based on the recommendation of this certificate. My lord,
No, but if you look at the, what you call,
location.
no. If you look at the sketch prepared by the commissioner in FDP.
How?
And compare it with the sketch.
Sketch prepared suo moto by that person who has filed application.
ಅದ್ರಲ್ಲಿ ನೋಡಿ.
ಅದು ಅವ್ರು ಸ್ವಂತ ಮಾಡಿದ್ದು.
Not the entire portion lying to the south of the railway track ಇಲ್ಲ. To the north of the railway track ಇರೋದು.
ಹೌದು, ನಾರ್ತ್ ಆಫ್ ದ ರೈಲ್ವೆ ಟ್ರ್ಯಾಕ್ ಈಗ ಇಶ್ಯೂ ಇರೋದು ಅಲ್ಲೇ ತಾನು.
It's only regarding a small portion.
ಹೌದು, ಸ್ಮಾಲ್ ಪೋರ್ಷನ್. ಆ ಹಿಸ್ಸಾ ನಂಬರ್ 2 ಅಂತ ಏನಿದೆ.
We'll appoint a commissioner, let them go and find out if there are graves belonging to the Muslim community.
ಅದನ್ನು ತೋರಿಸ್ತೀನಿ. If I am permitted, this 219 where publication till today, it is not been done. Then I approached when this person started interfering in the property in the year 2019. I specifically approached the civil court and there is a decree passed also against that person who is claiming to get the property registered. Then I become aware that there is something, some documents are sought to be created behind the back of the petitioner. Therefore, we made a specific representation before the authority under the provisions of RTI, asking for the documents which are sought to be relied upon by the authority. Surprisingly, the authority may take your lordship to page number 262. 262, annexure T. This is the information furnished to the petitioner. I have sought specific issue the certificate copy of the survey report of the commissioner under section 4 of the Waqf Act in land survey number 5/2 of Jungle Koi, Bidar. Then this has been replied. Surprisingly, page number 263. This is the report which has been prepared in the FDP proceedings where Tahsildar was appointed as a court commissioner, bifurcating the property among ourselves. Nam family dalli agiro partition. This is the document which they furnished to us. Your lordship could see towards the left side. Senior civil judge, Bidar.
Yes.
And this document, they want to say that this is the report of the commissioner under my lord, the provisions of Waqf Act. And then my lord, I also my lord, sought for information. Next page, my lord, 264. Issue the certified copy of a grant of land of Waqf deed for granting this as a graveyard in land in survey number so and so. Then they furnish this one document, my lord, 265. Translation. My lord, my lord, the land survey number 5 granted from the government for Muslim graveyard. Purpose situated at Jungle Koi Bidar 3. In the above case, it is ordered and rectified on the government land situated at Jungle Koi bearing survey number 5 for Muslim graveyard for the purpose of funeral, Muslim and subordinate Mohilla Mustapur. Translation is not so properly not done.
We'll get somebody appointed and let them.
Yes, madam. I have produced my lord, the photographs also and the latest Pani my lord, standing in my name at page number 276.
Okay. Are there any graves of any?
No graves at all. My lord, I have
No, my
produced the
lord, there is a graves, my lord, as per the 266, my
that
letter
any
by the.
officials of my lord, the government advocate, practicing advocate can my lord, visit the premises and my lord, see whether there are any graves.
My lord, certificate of registration was issued, my lord, in year
A part of
1981.
this land which is my lord, given to my uncle is already been converted by the deputy commissioner by issuance a conversion of order.
Pexa Kundro, they are Nim colleague, huh? The one sitting in the corner. ನೀವೇ ಸ್ಪೆಕ್ಸ್ ಹಾಕಿರಿ ಯಾರು ನೀವೇ ತಾನೆ ಯಾರ ಕೊಲ್ಲಿಗ್ ನೀವು
ಸಚಿನ್ ಮಹಾಜನ್
ಸಚಿನ್ ಮಹಾಜನ್ ಕೊಲ್ಲಿಗ್ ಕಮಿಷನರ್ ಆಗಿ ಹೋಗ್ತೀರಿ
ಗೊತ್ತಿಲ್ಲ ಇನ್ನು
ಅಲ್ಲೋಗಿ ಮುಸ್ಲಿಂ ಗ್ರೇವ್ ಯಾರ್ಡ್ಸ್ ಇದೆಯಾ ಇಲ್ಲೋ ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಹೋಗ್ತೀರಾ ಎಷ್ಟು ಫೀಸ್ ಫೀಸ್ ಎಷ್ಟು ಹೇಳಿ
10,000.
ಎಲ್ಲಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದ್ರೆ ಕೇಳ್ಬಿಡಿ ಇದಾರ ಹೇಳಿ ಅವ್ರು ನೋಡಿದ್ರೆ 50,000 ಕೊಡ್ಬೋದು
ಇಲ್ಲ our ancestral property standing since 60 years.
Advocate has to go there. ನೀವು ಯಾವ ಊರ್ನವ್ರು ನೀವು ಲೋಕಲ್ ಕಲಬುರ್ಗಿ ಎಷ್ಟು ದೂರ ಆಗುತ್ತೆ ಇಲ್ಲಿಂದ ನಿಮ್ ಜಮೀನ್ಗೆ?
It's in Bidar.
120.
120.
Pay 25,000 rupees. ಬರ್ಕೊಳ್ಳಿ. The petitioner has challenged, petitioners have challenged the order at annexure order, annexure N ಅದು?
ಹೌದು. Certificate of registration.
have challenged the endorsement dated 7/11/2018 issued by the
corporation.
Respondent number 5, registering property number 9/1/463/1A to a graveyard in an area measuring 183 feet into 83 feet as a Waqf property.
Hello.
Stop. The petitioners have also challenged
Annexure N, my lord.
I have also challenged.
Annexure N.
Bande. I have also challenged a certificate of registration issued by the respondent number 4, dated 15/1/1981, registering the graveyard near Law College, Bidar, as Waqf property. The petitioner contends that no proceedings of whatsoever nature are taken out to register the property belonging to the petitioners as a Waqf, and that the certificate of registration referred above and the consequent registration of the Khata in the records of the City Municipal Council are all without basis. Full stop. Next para. When this court queried queried the learned counsel for the petitioners whether there are any graves in the portion of the land lying on the southern side of the railway line running from ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಅದು?
Bidar Zairabad road is main road. Towards the college.
Southern side ಅಂದ್ರೆ towards the northern side, sorry.
Other side.
Northern side.
Side of the railway line. The learned counsel for the petitioners contended that there are no graves in the said property. However, this is seriously disputed by the learned counsel for the respondent number 4 and 6.
Yes, madam.
Who submits that there are graves
Graves.
on the northern side of the land, in the land lying on the northern side of the railway line.
Railway line.
Stop. In order to verify this crucial fact, this court felt it appropriate to appoint a commissioner for local inspection to find out whether there are any graves of persons belonging to the Muslim community on the northern portion, on the northern side of the, on the north of the railway line, running between Illinda Elgadu,
Bidar Zairabad road.
Bidar to Zairabad.
By Zairabad road.
Huh?
Bidar Zairabad road it is.
Railway line,
Which could be found my lord in the.
Railway line.
Railway line is also Bidar Zairabad and main road is also Bidar Zairabad.
Bidar Zairabad. Full stop. Mr. Sharana Basappa Patil, who was present in the court, was requested to visit the property and submit his report. He agreed to inspect the property and submit a report. Consequently, is appointed as a court commissioner to visit the property and make inquiries whether there are any there are any graves belonging to the Muslim community on the northern side of the railway track. Full stop.
Photographs seconds.
The
287.
Commissioner's fee is tentatively fixed at a sum of rupees 25,000 payable by the petitioners to the commissioner at the spot. Full stop. The commissioner shall visit the property on yavat hogtiri? ನಾಳೆ ಇವತ್ತೇ ಹೋಗ್ತೀರಿ? ನಾಳೆ
Swami, ಬೇಡ.
ಹಬ್ಬ ಇದೆಯಾ?
Saturday. I can take him.
Melada.
Saturday.
ನಮಗೆ ವಕ್ಫ್ ಆಫೀಸರ್ಗೆ ಪ್ರೆಸೆನ್ಸ್ ಇಡಕ್ಕೆ I have present the Waqf officer on that day, my lord.
ಅಲ್ಲ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ವಕ್ಫ್ ಆಫೀಸರ್ ಇರ್ತಾರಲ್ಲ ಅಲ್ಲಿ.
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾವು ಇನ್ಫಾರ್ಮ್
ಮತ್ತೆ ಗಲಾಟೆ
on Saturday.
If they come and create pressure
at
on
11 a.m. At 11 a.m. Full stop. The commissioner shall also take photographs of the property. If there are any graves, submit a report to this court. The commissioner is also at liberty to seek necessary help from the police in the event of any disturbance for execution of the commissioner warrant. Is this petition on? 27.
Before 24th may I request. Before 24th may I request.
Sorry?
ಸ್ವಲ್ಪ
ಯಾವತ್ತು ನೋಡಿ ಯಾವತ್ತಿದೆ ಅದು?
22, 23,
20th,
please.
20th. Hmm. Sixty-eight adjourn ಆಯ್ತಲ್ಲ?
Yes, ma'am. Marriage certificate.
68 adjourn ಆಯ್ತಲ್ಲ, ಮೊಹಮ್ಮದ್ Hamid Khan.
Yes.
My lord, this matter is pending before the principal bench at Bangalore. And the same order which is authorized the Karnataka board and Waqf officer to issue the marriage certificate is issued by the honorable principal bench. And the matter is posted on 10/2/2025 for final hearing. In writ petition here, PIL.
So you have challenged the authority of the Qazi to issue a certificate.
Illa sir, to issue the certificate by the Waqf board and its officers.
ಅವ್ರಿಗೇನ್ ಪವರ್ ಇದೆ?
Under the Waqf Act 1995, there is no provision for the issuance of marriage certificate by the Waqf board.
ಅದೇ ಕರೆಕ್ಟ್.
Yes. I have challenged that order as an exor R.
Matter is pending before principal bench.
Proposal of WP number. Principal bench ಮೇಲೆ WP number ಕೊಡಿ.
Yes, WP. Writ petition
WP number sounds. Yes.
19/284.
Manjunath Ginni.
Time for the respond.
ಈ ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದ್ರೆ ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ? If the matter is pending before principal bench, you can argue it here.
Yes.
We can decide it, principal bench will follow.
Yes, sir. I'll argue. It may post within 2-3 days. I'll argue.
Right.
Otherwise,
ಯಾವ್ದು ಬೇಕೋ ತಗೊಳ್ಳಿ ಡೇಟ್, whichever date you want.
any short date be given. 21. Yes.
ಅದಂಗೆ ಹೊಡೆದಾಕಿದ್ದು. List down sounds. Yes, next.
20.
Manjunath Ginni.
Let's I am for the respondent 4.
20.
Thus, this is the case, my last, widening up the road, my last, without acquisition proceedings. This is the second round writ petition, my last.
Who has to answer?
The
Let's respondent 4
4
minutes.
TMC has answered, my last. Earlier, this writ petition is allowed, my last.
ನೀವ್ ಯಾರಿಗೆ? ಅಮರೇಶ್.
Let's respondent number 4 municipality minutes.
ಈ ಮುನ್ಸಿಪಾಲಿಟಿಗಾ?
Yes.
Who has acquired?
Without
it is-
acquisition, he has to acquire, my last, the
Yaru?
report number 4 TMC, my last. Because he is widening the road in the my
Road is
property.
widened by the town municipality. Whether road is widened by the municipality?
Yes, my last. He is widening.
Let's kindly see minutes annexure C minutes in the earlier litigation.
Annexure?
C, my last.
C, my lord.
62, page number
ಅವ್ರು
62.
ಹೇಳ್ತಾರೆ, ಯಾರೋ ಒಬ್ರು ಹೇಳಿ.
Page number 62, my lords. This is the earlier approached by the
They
petitioners.
made
my
a
lords.
complaint against the respondent number 4 minutes illegally demolished and made a wide road minutes. Kindly see at page 67 minutes, your lordship order, para 6. In that view of the matter, instead of allowing the issue to be further litigated, this court feels it appropriate to direct respondent number 4 to assess and award compensation payable to each of the petitioner in case their property is used for the purpose of widening of the road. This shall be complied by respondent number 4 within a period of 3 months from the date of receipt of certified copy of this order. Against this order, my lords, the municipality files an appeal. Lords, kindly see, my lords, para page 73, my lords. Taking note of the fact. Taking note of the fact, during the pendency of the writ petition, the authority, without following due procedure of law, demolished the building of the petitioner and same has utilized for widening of the road without paying any compensation. This court gave a positive direction to the authority to assess and award compensation to the writ petitioners in accordance with law. The learned single judge, however, after noticing the illegal and high-handed manner in which The authorities have undertaken the road work, widening work has not directed any action to be taken against the authorities. The authorities should be happy that the learned single judge has not taken any action for the forcibly demolishing the shop in spite of direction to the authority in terms of so and so. In the aforesaid writ petition, restraining the authority respondent 4 from demolishing the property belonging to the petitioner without leave of the court. In spite of such an action on the part of authorities, the present appeal has been filed seeking to set aside the order of a learned single judge. The learned single judge, considering the relief sought by the petitioner, has rightly held that the shops belonging to the petitioners and the petitioners are entitled for compensation under the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, directed to assess and award compensation to the petitioner in the event of properties used for the purpose of road widening. Against this, my lords, the petitioners files contempt petition, my lords, at Annexure E, page 78. Lords, para 6 is relevant, my lords. It starts from para 5. Para 5. This court has considered the contentions raised at the bar on behalf of the petitioner as will the respondent accused. The para 6 of the order dated so and so extracted above is very clear. This order reveals that in case the property of the petitioner are acquired, then the respondent authority is liable to pay compensation in accordance with law. In the writ petition, the court has not given a finding that the petitioner lands are utilized for widening the road. Prima facie, the annexure R6, the sketch reveals that the properties of the petitioner are not utilized for the purpose of road widening. This court in this contempt petition cannot examine the correctness of annexure 6. Prima facie, it appears that land of the petitioner is not utilized. This annexure R6 is called in question, my lords, now in the writ petition. My lords, in the statement of objection, my lords, filed by the municipal.
The documents, what was the width of the road?
Two times survey was conducted, my lords.
Nim records ilva. Does the municipality not have any records to show what was the width of the road before it was widened? And what was the width of the road after it was widened?
That's the reason, my lord, survey was conducted. And in contempt proceedings, my lords, what had happened? For illegal demolition, my lords, the fourth respondent paid a damages to all the petitioners, my lords, as regard damages is concerned. Lords, later survey was conducted. It is found that, my lords, only encroached area is removed from this thing, my lords.
Encroached area?
Encroached or encroach ಮಾಡಿದ್ರೆ ಅದಷ್ಟನೇ remove ಮಾಡಿವಂತ. There is a survey report, my lords. Time survey was conducted, my lords.
Encroached remove ಮಾಡಿದ್ರೆ on what basis did you decide it is encroached? On what basis did you decide it is encroached?
After conducting survey, my lords, it come to.
You notified them, is it?
Survey notify ಮಾಡಿ.
Earlier, there was no notified, there is no any encroachment report, my lords. 2021 ನಲ್ಲಿ ಸರ್ವೆ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಆಗ್ತಾರೆ. 2016 ನಲ್ಲಿ I have filed the writ petition. Writ petition was interim order was granted. The contempt petition is also filed, my lords. The contempt petition charge was also framed against the respondent number 4, my lords. In that ಅದರೊಳಗೆ ಎಲ್ಲಿನೂ ಸರ್ವೇನೇ ಮಾಡಿಲ್ಲ ಅವರು. In that after dismissal of the writ appeal, my lords, they have surveyed the property and given endorsement saying that this is the encroachment property. ಅದನ್ನು ಎಷ್ಟು encroachment ಅದ ಅಂತ ಎಲ್ಲಿ ಒಂದು ಅಕ್ಷರ ಮೆನ್ಷನ್ ಮಾಡಿ.
Yes,
I have produced the sealed deeds register.
Produce all the documents relating to the widening of the road.
Yes. And even my lords, the earlier this is the village road, my lords.
Whatever documents that you have.
This is earlier.
As regards the width of the road.
Widening of the road.
Widening of the.
ಎಷ್ಟು ಏನೇನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Please.
ಬರ್ಕೊಡಿ. The learned counsel for the respondent number 5. Is that,
Objections. Page number 4.
ನಾನು ಹೇಳಿದ್ದೀನಿ.
ಏನಾಯ್ತು?
ಸರ್ವೆ ಕಂಡಕ್ಟ್ ಆಗಿದ್ದ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿ.
ಏನಾಯ್ತು? Is directed to place on record the entire file relating to widening of the which road?
Shira Lingsur to Shira Road. This is the state highway.
Road, as well as the approval from the finance department for the aforesaid project. Full stop. they should also produce documents to establish the width of the road before it was widened. Yes, list on yavat ಮಾಡ್ತೀರಿ?
It's for removal of encroachment, my lords, it appears there is no need for approval of a finance
ಫಸ್ಟ್ ನೀವು ಅಲ್ಲ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಬಗ್ಗೆ ನಾನು ಕೇಳ್ತಾ ಇಲ್ಲ.
Please, my
ರೋಡ್ ವೈಡ್ನಿಂಗ್ಗೆ ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬೇಕಲ್ಲ.
lords, in case of acquisition, my lords, we need to take a financial approval from the finance
ಫಾರ್
department.
ಫಾರ್ಮೇಶನ್ ಆಫ್ ರೋಡ್ ಬೇಕಾಗಿಲ್ವಾ?
Pardon?
ಫಾರ್ ಫಾರ್ಮೇಶನ್ ವೈಡ್ನಿಂಗ್ ಆಫ್ ಎ ರೋಡ್.
In case of widening of a road, my lords, municipality has to request the government for acquisition. my lords.
ದಟ್ ಇಸ್ ಓಕೆ.
Please.
ದುಡ್ಡು ಖರ್ಚು ಮಾಡುವಾಗ FD ಇದು ಬೇಕಾಗಿಲ್ಲ ಅಪ್ರೂವಲ್.
ಇಲ್ಲ, municipality, they need to, my lords, generate their own source, my lords.
ಕರೆಕ್ಟ್, ಅದಕ್ಕೆ ಬೇಕಾಗಿಲ್ವಾ? FD ಏನು ಬೇಕಾಗಿಲ್ಲ.
ಬೇಕಾಗಿಲ್ಲ.
ಚೆಕ್ ಮಾಡಿ ನೋಡಿ, ಬಿಕಾಸ್ ದಿಸ್ ಇಸ್ ಇದು 371 ಜೇಲ್ ಬರ್ತದಲ್ಲ ಇದೆಲ್ಲಾನು. ಈಗ ಕಲಬುರ್ಗಿ ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಫಂಡ್ ಏನೋ ಇರುತ್ತಲ್ಲ.
ಇದು ವಿಜಯಪುರದ, ಇದು ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ.
ಕಲ್ಯಾಣ ಕರ್ನಾಟಕ ಬರಲ್ಲ ಇದು. ಇದು ಯಾವ ಊರು ಇದು?
ವಿಜಯಪುರ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ND ಇದು.
ಅದೇನು FD ದೇನ್ ಬೇಡ. ಏನಾಯ್ತು ಇದು?
ತಪ್ಪಿ ರೋಡ್
links to they shall also produce ಅದೇ ನೆಕ್ಸ್ಟ್ ಇತ್ತಲ್ಲ. It was widened. ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
That's 28.
List on 28.
But there is other provision under the Municipality Act, section 82, my lords. In case of a dispute in regard to, my lords, Deputy Commissioner has jurisdiction to, my lords, determine, my lords. In the meanwhile, if they make an application, my lords, it's.
ಹೈಕೋರ್ಟೇ ಡಿಸೈಡ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಏನ್ ಮಾಡ್ತಾರೆ? You're coming in the way of the High Court deciding the dispute.
Interim order may kind.
ಯಾವತ್ ಬೇಕು ಹೇಳ್ರಿ ಅವ್ರಿಗೆ ಯಾವ
28 months, 20.
20 ಯಾವತ್ ನೋಡ್ರಿ. LB
Next, 20th.
23rd. Please. Interim order may kindly.
Interim order is extended till the next date.
Much of this.
Mahadev S. Patil. Mahadev Patil.
On behalf of respondent, Veernagoda, he has to file statement of objection. He requests to 2 weeks' time.
Learned AGS, learned counsel for the response 1 to 4 6 time. List on DK Hiremat, Arun Chaudapurkar, BK Hiremat, Arun Chaudapurkar.
Portal number 2. Bharta side. The petitioner challenged annexure G, my lord.
Annexure
G, my lord. Wherein the respondent have passed an order against the order of the Assistant Commissioner, madam. The petitioner has filed file number 7 before respondent number 2. That he has
filed
file number 7, madam, before respondent number 2. So after bifurcation of talukas by Basavana Bhagavad and Nidagundi, they have been not considered my application, madam. During pendency of application, the respondent number 5 has purchased the land from respondent number 6, madam. So the mutation entry was challenged before Assistant Commissioner. That application was allowed by the Assistant Commissioner. Set aside the order of the Tahsildar. And by that order, the respondent number 5 preferred revision petition before respondent number 2, madam. It was allowed, madam. Therefore, the impugned order passed by
How
the.
can you challenge the mutation?
Sir?
Leaving mutation challenge ಮಾಡ್ತೀರಾ?
I am the protected tenant, madam.
Correct.
The mutation entry was affected by the Tahsildar, madam. Holding that, the Assistant Commissioner passed an order that the place of the bifurcation of talukas, madam, Basavana Bhagavati and Nidagundi comes. So Nidagundi was not existed till today, my lord. So therefore, the Assistant Commissioner passed an order that the mutation entry which was affected in the name of respondent number 5 is cancelled. And matter is remitted before. So during pendency of that application, my lord, the respondent number 2 passed an order.
Lordship, this is nothing but a third round of litigation. First, he filed a tenancy application before the concerned land tribunal. It was not considered, and subsequently he filed a writ petition before this honorable court. So with an opportunity to decide considerably, it was allowed. And then thereafter, he filed a contempt petition. And the government was pleased to prefer an writ appeal before this Honorable Court against the same order. And the Honorable High Court has dismissed his claim contempt petition and also the writ appeal of the government, reasoning that already mutation is rejected and there is no such contempt. As per the report, there is no such contempt. Thereafter, subsequently, mutation was effected on the basis of a sale date before the concerned Tehsildar, which was challenged by him, and before the Assistant Commissioner, which was allowed. And respondents 5 has preferred a revision petition before the concerned Deputy Commissioner under Section 136(3), which has set aside the order of the Assistant Commissioner, assigning all the reasons regarding the consideration of the contempt petition, then writ appeal, and on such a considered application of the mind, the Deputy Commissioner was pleased to reject the revision petition. Once again, he has approached this Honorable Court seeking quashing of that particular proceeding. I may submit with the permission of the court that even he has approached the Honorable Apex Court of Supreme Court against the said order, and it was dismissed at the stage of admission itself in November.
But when the matter is still under consideration, the form number 7 decide agilla.
Form number 7 yakandre form number 7 andre 30th to 19 some year. So
76
February ಏನಂದ್ರೆ 20th ಇದೆ 30th ಡೇಟೇ ಬರೋದಿಲ್ಲ ಅಂತ ಆ ದೃಷ್ಟಿಯಲ್ಲಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು. So subsequently on the same reasoning, the Honorable Court in the writ appeal also and the contempt petition has considered that the report in that regard is sufficient. There is no contempt proceedings, and also the writ appeal filed by the government was also not considered.
Whether the form number 7 is considered and
No, it is not considered.
It is not considered, my lord.
The concerned Tehsildar on the scrutiny of all his applications and representation has submitted the report before this Honorable Court. That there is no such application filed on 30th to so and so.
Where is it?
Annexure A ಇದೆ, my lord.
May I be permitted to read out Annexure C, my lord? That is the contempt petition and the writ petition.
The form 7 or form 7A na?
Form number 7 is
7, sir.
7.
Form number 7.
ಬಟ್ ಅವ್ರು ಏನ್ ಮಾಡಿದಾರೆ 30th February 1976 ಎಂಡೋಸ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಯಾರು
ಏನಂತ?
ತಾಲೂಕಾ ಇದು ತಹಶೀಲ್ದಾರ್ ಬಾಗೇವಾಡಿ TNCSR 30th to 1976. Actually 30th February ಬರೋಲ್ಲ, either 28 or 29 ಬರೋಕು, ಅದು ಅವ್ರು ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡು ಹಂಗೆ ಪೋಸ್ಟಿಂಗ್ ನಡೆದಿದ್ದಾರೆ. ಈವನ್ ಬಸವನ ಬಾಗೇವಾಡಿ ಡಿಸ್ಟಿಕ್ ತಾಲೂಕಾ ಡಿವೈಡ್ ಆಗಿದೆ ಸರ್ ನಿಡ್ಗೊಂದ, ಅಲ್ಲಿನೂ ಅವರು ಇನ್ನ ತಕ ಡಿಸೈಡ್ ಮಾಡಿಲ್ಲ ಫಾರ್ಮ್ ನಂಬರ್ 7.
I am permitted to read the observation of the Honorable High Court in writ petition, writ appeal, my lord. Annexure C, para number 2. If I am not mistaken, it is page number 26. Annexure C produced by the complainant himself along with the present contempt petition clearly depicts that Tehsildar, being Secretary of the Land Tribunal Person Bagewadi, has issued an endorsement dated 31/7/2018 rejecting his claim on the ground that his father had not at all filed form number 7. Thereby, the order of the learned single judge has been complied. It is also relevant to note that at this stage, that according to the complainant, his father has filed form number 7 on 30th to 1976. Admittedly, as per the calendar, there is only 28 or 29 days in the month of February and not 30 days. In view of the above, the order of the learned single judge has been complied by the issuing the endorsement dated 31/7/2018. It is very strange to note that though the Tehsildar has complied with the order passed by the learned single judge by an endorsement dated 31/7/2018, the state government has filed a writ appeal number so and so against the order passed by the learned single judge, which has already been implemented. Therefore, very writ appeal filed by the state government is not maintainable. The state government should be careful while filing the writ appeal, not spending public money and not wasting public time, especially the court time, when the order is already implemented. For some other reason, the writ appeal was filed and same.
Where is that endorsement? 31/7.
31/7/2018, madam.
ಎಲ್ಲಿದೆ ಅದು?
I think he has not produced it.
ಯಾವುದು?
As
Annexure A.
endorsement of the Tehsildar.
Annexure A production.
Annexure A ಅಲ್ರಿ ಇವ್ರೆ. Tehsildar 31/7 ಅಂತ. He has not produced it.
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ? ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ?
ನನ್ನ ಬಳಿ ಇಲ್ಲ. I will secure it, sir.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಇಲ್ಲ
I will secure it.
Yes, if form number 7 is ಫೈಲೇ ಮಾಡಿಲ್ಲ ಅಂತ ಎಂಡೋರ್ಸ್ಮೆಂಟ್
ಇಲ್ಲ ಇದೆ ಸರ್, ಫಾರ್ಮ್ ನಂಬರ್ 7 ಇದೆ ಅಲ್ಲ, ಅನೆಕ್ಷರ್ ಎದಲ್ಲೇ ಇದೆ ಸರ್.
ಅದು ಅನೆಕ್ಷರ್ ಏನ್ ನಿಮ್ಮ ಹತ್ರ ಇದೆ
ಸರ್.
ತಹಸೀಲ್ದಾರು ಅಂತದ್ದು ಕೊಟ್ಟೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಕೊಡ್ಲಾರ್ದೆ ಅವ್ರು ಹೆಂಗ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ?
Because you challenge that endorsement.
Yes, my lord.
ಎಲ್ಲಿ?
Challenge.
Petition
WP
ಅಲ್ಲ?
number 206411 of sir.
ಆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನ ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಹಿರೇಮಠ ಅವರೇ?
ಬಸವನ ಬಾಗೇವಾಡಿ ತಹಶೀಲ್ದಾರ್ ಬಳಿ.
ಅದು
ಆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನ ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಿ?
ಅದು ರಿಟರ್ನ್ ಅಲ್ಲಿ ಮಾಡಿ ಸರ್, 200641 ಅಲ್ಲಿ
ಅವಾಗ ಆಗಿದ್ದಿಲ್ಲ ಸರ್ ಅದು.
ಬಂದಿದೆ, ಅನೆಕ್ಷರ್ ಬಿ ಬಂದಿದೆ ನೋಡಿ ಸರ್.
ರಿಟ್ ಒಳಗೆ ಇಲ್ಲ.
ಅನೆಕ್ಷರ್ ಬಿ ದಲ್ಲಿ ಇದೆ ಸರ್.
ಓದಿ.
The petitioner is in the above writ petition has sought for a writ of mandamus directing the respondent number 2, Land Tribunal Bagewadi, to dispose of form number 7 filed by his father on 30th/2/1970 as per Annexure A in accordance with law and as early as possible.
ಎಲ್ಲಿದೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್? ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ?
No endorsement.
No, sir. His prayer is respondent number 2, Land Tribunal B Bagewadi is hereby directed to consider and dispose of form number 7 Annexure A filed by the
Sir,
father.
ಏನಿದೆ ಸರ್ ಅದು?
ಸರ್, ಈ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ನ ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ?
ಇದರೇ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು. ಅದು ಮ್ಯಾಟರ್ ವಾಸ್ ರಿಮಿಟೆಡ್ ಬ್ಯಾಕ್ ಟು
Lordship, I will produce it, sir.
Back to file.
Short it.
The learned counsel for the petitioner, the learned counsel for the respondents are directed to place on record the endorsement dated
Yes.
31/7/2018
Yes, ma'am.
rejecting form number 7 filed by the petitioner.
21 cards. It may be posted on 23 or something.
27.
20, oh yes. Yes. Yes.
Kulkarni Srinath,
Kindly have it on 16th.
why not today?
Today, Kulkarni Srinath is attending to that corporate matter, Bijapur matter on 16th physically.
Learned counsel for the petitioner seeks time list on. ಕೆಲಸ ಮಾಡಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ದಂಗ್ ಮಾಡ್ತೀರಪ್ಪ ವಕೀಲರು. ನಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ದಂಗ್ ಮಾಡ್ತೀರ. ಈಗ ನಮ್ಮಿಂದ ಕೆಲಸ ತೆಗಿಬೇಕು, ಬಟ್ ನಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ದಂಗ್ ಮಾಡ್ತೀರ. ಏನು ಗಾಡ್ ಓನ್ಲಿ ಸೇವ್.
Petitioner was appointed as a draftsman in the year. My lord, petitioner was appointed as a draftsman in the respondent authority.
Please use the mic, Nartam now.
Please. Lord, in this petitioner was appointed as a draftsman in the respondent authority on 15/11/1984, my lord. After completion of 10 year, my lord, he has given a letter to authority to consider his regularization. My lord, the total letter.
ಯಾವಾಗ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದು?
15/11/1984, my lord.
84.
Yes, my lord. After completion of 10 year, my lord, he has wrote letter to the respondent authority to regularize his service, my lord. My lord, meanwhile, they have approached the honorable court by filing a writ petition at Annexure D, my lord, page number 28, my lord. Annexure D, my lord, the similar employee has filed a writ petition, my lord. They have not considered the order passed at Annexure F, my lord. The Annexure F is passed.
2006 ಇವಾಗ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ದೀರಾ?
Yes, my lord. So after up to retirement, we are waiting for regularization, my lord.
You already retired?
Now in the 2024, he has retired, my lord.
ರಿಟೈರ್ ಆದ್ಮೇಲೆ ಇವಾಗ ರೆಗ್ಯುಲೈಸೇಷನ್ ಈಗ ಚಾಲೆಂಜ್.
ಅಂದ್ರೆ in the earlier.
After 18 years.
Yes, my lord. Earlier, my lord, at Annexure C, my lord, he has approached the honorable court and obtained the order, my lord, to regularize his service, my lord.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಹೆಸರು? ಎಲ್ಲಿದೆ?
Page number 20, my lord. Page number 20. annexure C,
20?
page number 20, my lord, annexure C.
ನಿಮ್ಮ ಹೆಸರಲ್ಲಿದೆ.
Serial number 5, petitioner number 5 is Vittal Rao,
Ah.
son of Narayan Rao, Patwari. My lord, this petition is came to be allowed, my lord.
Ah.
The government has passed the order in the year 2006 at annexure F, my lord. Annexure F, page number 23, my lord, relevant page number 39, my lord. Dated 6 to
Gaurish Kashampur.
My lord, he is not, he is formal party, my lord. The government has to consider the representation, my lord.
Is government?
2 times our, this court is.
Government.
Get the instruction, my lord. I will take it.
Our lordship
Also,
last,
you also appear for government.
Yes, my lord.
my lord, in the last occasion also they have taken a time, my lord, just to consider the representation, my lord. That is
ನೀವು
the-
ಇಷ್ಟು ವರ್ಷ ಬಂದ್ರೆ
To retirement we are waiting, my lord.
ಅದೇ 18 ವರ್ಷ ಮಲಗಿದ್ದು 18 ವರ್ಷ ಮಲಗಿದ್ದು ಇವಾಗ ಬಂದ್ರು ಅರ್ಜೆಂಟ್ ಅಂತಿದ್ರು.
Urgent, 2 times they have taken.
18 ವರ್ಷದಿಂದ ಫೈಲ್ ತೆಗಿಬೇಕಲ್ಲ ಅವರು. ಇವತ್ತಿನ ಕೇಳಿದ್ರೆ ಗೌರ್ಮೆಂಟ್ ತೆಗಿಯಲ್ಲ. Learned AG ಏನೋ
SGP.
learned HCGP seeks time to file objections. List on ಯಾವತ್ತು ಬೇಕು?
28.
ಸರಿ ಯಾವತ್ತು ಬೇಕು? Next.
22, please.
KM Gate, Ravi B. Patil.
It is plaintiff's writ petition. The plaintiff has filed a suit for partition and superposition. During pendency of the suit, my lord, the contesting defendants who have filed the written statement on 23/10/2018, my lord. 23/10/2018, when they filed the written statement regarding defendant number 3, my lord, who was widow, her husband was no more, and she was considered as one of the family member. Written statement was filed, all of them jointly. In the said written statement, my lord, about position of defendant number 13, that he is being adopted by the defendant number 3, was not being disclosed in the written statement, my lord. Based upon that written statement, my lord, the evidence of DW1 was let in. When the defendant number 2 as DW1 was under cross-examination, at that time he disclosed, my lord, that defendant number 3 had adopted the defendant number 13 as adopted son, my lord. So moment that came to the knowledge of the plaintiff files an application getting impleading the said defendant number 13, my lord. Defendant of 13 was impleaded, and he has also filed the written statement.
Where is the amendment sought for? What is the amendment sought for?
Amendment sought for, my lord, requesting the honorable trial court to allow the plaintiff to challenge that adoption deed, my lord. Page 85, my lord, my affidavit with regard to this amendment. I said, my lord, when the DW1 was examined, by that time only it was disclosed.
The defendant number 3 written statement ಅಲ್ಲಿ adoption ಬಗ್ಗೆ ಹೇಳಿಲ್ವಾ?
ಏನೇನು ಹೇಳಿಲ್ಲ, nothing.
ಎಲ್ಲಿದೆ
It was a joint written statement, my lord. Kindly, page page 46, my lord. Defendant number 1 to 5 and 7 and 8, my lord. They have taken so many contentions that all the properties standing on the name of different defendants, they are the self-acquired properties. That was the only defense, my lord. So far as defendant number 3, who was already party to the written statement, it was never disclosed in the written statement, my lord, that she has taken this defendant number 13 in adoption. But the first time, my lord, when the defendant number 2 was under cross-examination as DW1, he disclosed, my lord. So on his disclosure, an application was filed. Defendant number 13 was brought on record, and he has filed the written statement. Thereafter, the evidence of DW1 was completed, and there were no other witnesses being examined by the contesting defendant, my lord. And this defendant number 13, when I have got him impleaded, my lord, on that day he was minor, represented by his guardian, my lord. So his guardian also did not choose to enter into witness box. Then what happened, my lord, when the matter was posted for argument, it was revealed that the issue is already framed to that effect regarding that adoption, my lord.
How was the issue framed when there's no?
Issue is framed based upon the written statement filed by defendant number 13. So when that issue is on record, my lord, 7/10/2023, whether the defendant number 13 proves that he was adopted by the defendant number 3 as per adoption deed dated so and so. My lord, page 81, my lord. There are additional issues were framed. Based upon this, my lord, I filed an application, 4 applications, my lord, before the Honorable Trial Court. All those 4 applications were seeking production of document, that is exhibit, adoption deed, my lord, and getting a reopened side of the plaintiff for the purpose of getting marked those documents, and also application under Order 13 to Rule 11 and 12, because by this application was filed the defendant number 13, he became major, my lord. So I sought for the discharge of the guardianship. All these applications came to be allowed, except I number 35 under Order 6 Rule 17 is being rejected. So my respectful submission, my lord, when this amendment, I have filed amendment application, the objection was required to be filed by the defendant number 13 or his guardian, my lord.
Alre, you state ನಿಮ್ಮ affidavit ಬನ್ನಿ.
Yes, my lord.
Para 2 ಬನ್ನಿ.
Yes.
Last but 3 sentences.
Yes, para number 11 may be permitted to amended as para number 11A. The plaintiff submits that during pendency of the suit at the time of evidence of DW1, he has disclosed about execution of the adoption deed by defendant number 3. In favor of defendant number 13, the husband of defendant number 3 and defendant number 3 both died as undivided joint family members, and their death ceremonies have been also performed by the plaintiffs and defendants. Husband of defendant number 3, namely Shatrughan, during his lifetime had no intention to take defendant number 13 in adoption. It is after his death, the deceased defendant number 1 and defendant number 2, they have illegally, without any authority of law, managed to create adoption deed bearing document number so and so dated 2011 behind and back of the plaintiff, and the said document is required to be declared as null and void and not binding upon the rights and interests of the plaintiff in respect of the suit settled properties. My respectful submission, my lord, the person who has executed the adoption, when she was already before the court, my lord, she never disclosed anything. It is only after that, when it was disclosed that there is an adoption on the name of this defendant number 13, all the properties are the joint family properties, my lord. Though they are contesting that it is a self-acquired property. So it is a matter subject to the outcome of the trial court's litigation, my lord. So by this time, when the written statement is filed, and I was allowed to produce the document also, and I was allowed to enter into witness box by getting reopened the side, my lord. Once this amendment is rejected, my lord, even if I go for marking the document, the exhaustive relief which I am seeking as against this defendant number 13, my lord, so that will be affect my rights, my lord.
Defendant number 13 is examined?
No, my lord.
He is still not
Not
examined.
examined.
Defendant number 3 is DW1.
Yes, my lord. Defendant number 2 is the DW1.
Defendant number 3 is still not examined.
Not examined. After filing the written statement, she died, my lord. So
D3.
D3, she died. Then I filed a memo, got deleted her name. For deletion also, there was no objection by the other defendants, nor it was brought to the Honorable Trial Court's notice that defendant number 3 had any executed will in favor of this defendant number 13. After completion of that procedure, when the evidence of the parties was let in, defendant number 2, who is examined as DW1, he tried to disclose that defendant number 3 has got adopted this defendant number 13 as the adopted
Yes,
son.
Ravi Patil.
So because of that, my respectful submission, my lord,
Yes.
all the applications have been allowed.
Yes, Ravi Patil.
This application is filed at the stage of final arguments. But the admittedly burden is on the defendant number 3 to establish whether he is an adopted son or not. Issue framed on putting a burden on the defendant number 13. Now the registered document is of the year 2011. He being aware of the document has filed an application impleading defendant number 13. And after he being impleaded in the proceeding also, there was no application filed for amendment. It is only at the stage of final arguments they are coming, and
They will not lead any evidence. Plaintiffs will not lead any evidence.
no, since burden, your lordship could see, the burden is on
upon-
me.
Burden is upon you, but this is a registered instrument.
How?
If it's a registered instrument, tomorrow if it has to be cancelled, you need a decree for that.
No, he is not a person, he is claiming only 1/5 share of the, in the suit. He will not be affected, whether it is, I belong to, I prove, whether I adopted son of a defendant number 3 or not. Nowhere relevant.
Yes.
How he will get affected, to the extent of his share.
What
is
he's
not-
saying is that if defendant number 3 died intestate, if defendant number 3 died intestate, he says that he would have got the entire.
Primary defense in the written statement of defendant number 1, 2, 3 are, these properties already been partitioned long back, and these are the absolute properties of defendant number 1, 2, 3. They have acquired this property independent to, from the source of their own income. Unless that issue is been shown, he will not get any,
How related to defendant number 3? How related to defendant number 3?
we are defendant number 1 and 2, other relatives, who are being brought in.
You are for defendant number 13.
I
No,
have,
it is not for
I
defendant
have,
number
I have
13.
filed wakalat for, the defendant number, respondent 9, 10, 11.
5, 7, 8, my lord.
13,
They
14,
filed the objection to the amendment application.
Defendant
No
number-
relief is sought against them.
defendant number 13 file madlilva?
No, he has not filed objections to the amendment application.
Yes, he's
13, I have filed power also.
No, you
for
have filed
13.
power before the trial court.
Yes.
Kindly see
13
the
ನಾನು power
objection.
ಹಾಕಿದ್ದೀನಿ.
6 rule 17 ಗೆ ನೀವು application ಗೆ amendment ಹಾಕಿದಿರಾ? ಈಗ
Yes.
objection ಹಾಕಿದಿರಾ ಇಲ್ವಾ?
No, my lord.
13 has not filed, but others have also filed.
Others
Others have
control, they
filed.
can.
How are you? What is your locus standi to
I
file?
am 13, I am also representing respondent number 13.
Here,
Here you are.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಐಎಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 13.
I was a minor, all applications were filed together.
No, no, you are.
Second-
Have you filed
Guardian.
objections? Have you filed objections to?
Guardian has, joined, the objections filed by other defendants.
ಆಯ್ತಪ್ಪ, have you filed objections to the IA under order 6 rule 17?
No.
For the first time, I have received notice personally, in the.
You have not filed objections.
No, my guardian has joined. My
ಎಲ್ಲಿದೆ?
guardian,
Has your guardian filed objections to IA under order 6 rule 17?
No.
Six rule 17, defendant number 2 to 5, 7 and 8.
Therefore, we'll allow this application. This application is directed against defendant number 13.
How?
He has not filed any objections.
But this is seeking an amendment, seeking a declaration of adoption
Yes.
after lapse of 14 years.
Yes.
But
When
has
was
well
defendant-
settled proposition of law. He cannot be a person to challenge the adoption.
When was defendant number 13 impleaded?
But he was implemented in the year 2021.
Yes.
21. After the
2023.
death of defendant number 3, after the death of defendant number 3, I was implemented. I implementing or not?
Application ಇದ್ರಾಗಿಲ್ಲ.
ಹಾಕಿಲ್ಲ.
ಅದು defendant number 3 died and deleted on 26/3/2021.
Defendant number 3 ಯಾರು?
Defendant number 3 is Vithabai, who is
Sorry.
brother, who is
adoptive
wife of
mother.
one of the brother who died, my lord.
My adoptive mother.
Both this brother and his wife, they died issueless, my lord. So therefore, we filed a memo, God deleted her name.
For the brothers Bharat Rao, ಆಮೇಲೆ
Bharat Rao, Arvind, given the pedigree, my lord, on page 30 of my plain tile mention ಮಾಡಿ. Bharat Rao, Shatrughan, Satyabhama, Devendra, Rukmini, Radhabai, Ravindra, Arvinda. These are all the family members, my lord.
ಎಲ್ಲಿದೆ?
Shatrughan died.
ಭರತ್ ರಾವ್, ಶತ್ರುಘ್ನ್,
Yes, ma'am.
ಸತ್ಯಭಾಮ, page number 13, ದೇವೇಂದ್ರ, ರುಕ್ಮಿಣಿ. ಹಾ,
So Devendra, Bharat Rao, Shatrughan, Ravindra and Arvind, they are the brothers, my lord.
Yeah, but what is your right to seek for adoption, setting aside the adoption?
No, adoption, what happens, my lord? I said that during the joint family status, Vitabai, she becomes since one of the co-partner or the member within the joint family, my lord. And she does not get exclusive rights to get adoption or make some properties transferred to the some third person.
How do you say that she doesn't have right to adopt?
Please, my lord.
How do you say
No, that I have to prove, my lord.
ವಿಟಾಬಾಯಿಗೆ ಅಡಾಪ್ಟ್ ಮಾಡಕ್ಕೆ ಅಧಿಕಾರ ಇಲ್ಲ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತಿದ್ದೀರಾ?
No, because we say, my lord, till I filed this suit, we were all joint. Even till today, we are joint. Vitapai died as a joint family member. And it was no adoption, nothing, my lord. It was not within the knowledge of the plaintiff also. If at all he had a knowledge about this, my lord, certainly while filing the suit in the year 2013, see, he could have taken that defense. And very interestingly, it was not mentioned in the written statement also.
Yes.
So for the first time during the year 2022-23, when this story of adoption deed has come into picture, I say, my lord, that adoption was not made by Vidabai. It was by defendant number 1 and the defendant number 2.
Let defendant number 13 prove that fact of adoption.
Yes.
Defendant number 13 prove madly.
Let him prove, but as a procedure, at least I have to challenge that document.
Why?
Because I say that that document is null and void, not binding upon my rights.
It's for him to prove it, Allah.
But even then, if he proves also, in my plaint, my lord, unless I challenge it, now additional issues framed, if I mark the document, my lord, if I am tomorrow claiming some relief as against the defendant number 13, that by virtue of adoption deed, he cannot become the owner of all the properties left by defendant number 3 and her husband. Because those properties are also part of the joint family properties. So
Yes.
therefore, there, my lord, the plaintiff's right will be affected. And ultimately, this defendant number 13, by virtue of this document, my lord, he will be become absolute owner of all those properties which have been referred in the adoption deed, my lord.
Yes.
So that takes away the right of the plaintiff.
Yes.
So therefore, my lord, the formal amendment to that effect, bringing the fact that after filing the suit, I had a knowledge of that document. So that document is not genuine document.
Yes.
So that stand I have to take, my lord. Because of that, I have sought for amendment.
ಅಷ್ಟೇನಾ?
Merely because he is seeking for a succession or a partition in the family doesn't mean that the one of the defendant cannot adopt the
And one more interesting aspect, my lord. Defendant number 13, who has filed the written statement through his guardian, my lord. There is no counterclaim with respect to the properties based on the adoption deed, my lord. So that is also there. So therefore, my humble submission,
when a
so it is a
primary
partition
defense-
suit, my lord. Whatever developments have taken place during pendency of the suit, so that wherever my rights are going to be affected, my lord. So I must say before the trial court that this document is not binding upon my rights in the properties, my lord. Otherwise, my lord, those properties will be excluded tomorrow if I don't say anything in the plaint, my lord.
First of all, please tell us,
Please, my lord.
who are you to challenge the adoption?
I am one of the joint family member.
Fair enough.
Please.
Between the husband and wife. Between the husband and wife.
Please, my lord.
It is either the husband or the wife who
Yes.
can challenge adoption.
Yes.
Correct?
No, let them take adoption, my lord. See, fact remains, if the adoption was made known to me before filing of the suit, certainly I could have taken a stand that during lifetime of my brother, he had no intention to make the adoption. And when defendant number 3 was also made an adoption,
Sir,
she has also not disclosed.
ಅದು ಹಳೆ ಕಾಲ. Under the old Hindu law,
Please.
the widow could not adopt.
Yes, my lord.
That is under the old Hindu law.
Please, my lord.
After 1956,
Yes.
widow can adopt.
She can adopt, yes. She can
Okay.
adopt, yes.
If you say that she can adopt,
Yes.
who are you to challenge that adoption?
Challenge regarding the properties which have been brought
Admit.
under the adoption, my lord.
If it is, adoption is proved,
Yes, my lord.
if adoption is proved,
Please, my lord.
and if you are able to prove that the properties were not partitioned earlier,
Yes,
then you're entitled for partition,
yes, yes.
including the properties which are the subject matter of adoption.
Please, my lord.
If you're able to prove
Please, my lord.
that there was no partition,
Yes.
you are still entitled to claim share in the properties which are also the subject matter of the adoption.
Please, please, my lord.
But who are you to challenge the adoption is what I'm asking you.
Because it is affecting my rights.
How does it affect?
Because the properties which were undivided joint family properties, my undivided rights is there in the property which is shown even in the will deed, this adoption deed, or by
ಈಗ
virtue.
ಅದನ್ನೇ ಹೇಳ್ತಿದ್ದೀರ.
Please,
ನೀವು ಭಾಗಕ್ಕೆ ಹಾಕೊಂಡಿದ್ದೀರಿ,
yes,
ಪಾರ್ಟಿಷನ್ಗೆ ಹಾಕೊಂಡಿದ್ದೀರಿ.
please, my lord.
Correct ಅಲ್ವಾ?
Yes,
You have included the properties which are mentioned in the adoption deed.
please, my
Correct?
lord. Please,
Now, defendant number 13,
yes,
there's an issue against him, whether he proves the adoption.
please, my lord.
Correct?
Please,
If you are able to prove that the properties are not partitioned, and if the defendants, other defendants 1 to 12 are able to prove that it was partitioned, then your suit for partition will be dismissed.
please, my lord.
Correct?
Yes.
Then what should happen to the adoption?
No, that adoption will become
Enforceable.
a document in favor of the defendant number 13.
It becomes enforceable.
Yes, my lord.
Correct?
Yes,
So therefore, it is for you to prove the relief sought for in the suit. It is for the defendant number 13
please, my lord.
to establish the adoption deed, to claim the property which has the mentioned in the adoption deed.
But anyway, that document is there, my lord. I have been permitted to produce.
Anyway, then the amendment angle ಬಿಡಕ್ಕ.
No, no, that will affect my rights, my lord.
How?
Because if I don't say anything about that document in my partition suit, merely because under presumption that if I succeed in partition, this adoption will go. So that may not be a proper.
No, no.
Because the question will come, why you are not challenged?
Clarify that. Clarify that.
Please, my lord.
The plaintiff in OS number, the plaintiff in OS number 16/2013 on the file of the principal senior civil judge and CJM Bidar is before this court challenging the rejection of an application filed by him under Order 6 Rule 17 to amend the plaint and to incorporate an additional prayer and additional pleadings. Next para. The suit in OS number 16/2013 was filed for partition and separate possession of the plaintiff's share in the plaintiff's 1/5 share in the suit shell properties. Full stop. The plaintiff claimed that he and the defendants constituted a joint family and that the family possessed the suit shell properties which are held commonly and which are held jointly by the plaintiffs and defendants. Full stop. The plaintiff claimed that his request for partition was not accepted and he was therefore advised to file a suit for partition. Full stop. The suit was contested by the defendants 1 to 5, 7 and 8, who contended that there was a prior partition.
Yes, my lord. Their stand is prior partition.
There was a prior partition in terms of which certain properties were allotted to the plaintiff and some properties were allotted to the defendants. Full stop.
And also, my lord, with regard to self-acquisition. And also with regard to self-acquisition of certain properties.
So they also claimed that certain properties were purchased by them out of their own earnings. Full stop. During the course of cross-examination of DW1,
please,
comma, the DW1 arrow?
DW1, defend number 2, my lord, Arvind.
During the course of cross-examination DW1, comma, he disclosed that defendant number 3 had executed a defendant number 3 had taken the defendant number 13 in adoption. Full stop. The plaintiff therefore impleaded defendant number 13 in the suit. Full stop. The defendant number 13 filed his written statement. Is a harra. Defendant number 13 is a
Yes, my lord. Page 74, my lord.
his
Page 74, through his guardian.
His written statement through his guardian
Yes.
contending that he was taken in adoption by the defendant number 3, which was evidenced by a deed of adoption dated 29/11/2011. Full stop. The defendant number 13 adopted the written statement filed by the defendants 1 to 5, 7 and 8 and contended that he too is entitled to an equal share in the properties of deceased Gorakhnath. Full stop. The plaintiff there, full stop. When the suit was set down for, ಯಾವ stage
Argument stage.
Suit was set down for arguments, the plaintiff filed an application under Order 6 Rule 17 to incorporate the following. Page number 85 alli, a red pencil mark. 86 alli red pencil mark. Full stop. This application was opposed by the defendants 2 to 5, 7 and 8, who contended that the application cannot be entertained at the fag end of the proceedings.
7 was my guardian.
Huh?
7 was my guardian.
Full stop. ಅಷ್ಟೊಂದು discharge ಆಗಿತ್ತಲ್ಲ.
ಇದೇ ಆರ್ಡರ್ ನಲ್ಲಿ ಆಗಿದೆ.
Full stop. They also contended that the plaintiff has not demonstrated as to how the proposed amendment was necessary for the adjudication of the suit. Next, the trial court, in terms of the impugned order, rejected the application on the ground that
Filed belatedly at the
ground that
Page 10, my lord. Point number 2.
on the ground that the plaintiff did not disclose as to when he came to know about the execution of the adoption deed. It held that when the plaintiff did not disclose the said relevant fact, he cannot be permitted to file an application for amendment of the plaint at a belated stage of the suit. Consequently, it rejected the application in terms of the impugned order. Being agreed with the said order, the plaintiff is before this court. Next one. The learned counsel for the plaintiff contends that the defendant number 13 had claimed to be the adopted son of defendant number 3, and therefore defendant number 3, and that the properties that had fallen to the share of defendant number 3 was transferred to the defendant number 13 under the said adoption deed. He therefore contends that if the plaintiff is able to establish that the said adoption deed was not validly executed, then the plaintiff too is entitled for a share therein. Full stop. Thus, he contends that the amendment sought for was necessary and the trial court committed an error in rejecting it. Per contra, the learned counsel for the defendant number
I appear for respondents.
Defendant number
9, 10, 11, 13, 14.
All of them I have got dispensed with the notice. Notice is order only for respondent number 13 here.
ಅವ್ರಿಗೂ ಹಾಕಿ.
Defendant number
13.
13.
Defendant number defendant number
ಎಲ್ಲರಿಗೂ ಜಾರಿ ಮಾಡಿ
ನೀವು ಎಲ್ಲರಿಗೂ ಅಪೇರ್ ಆಗ್ತಿದ್ರಲ್ಲ.
ಹೌದು.
1 to 5, 7 and 8 and 13 contends that the trial court has framed an issue as to whether the defendant number 13 proves that the defendant number 3 had executed a deed of adoption. He therefore contends that the burden of proving the said issue is upon the defendant number 13, and therefore there is no need for the plaintiff to amend the suit to seek for a declaration that the adoption deed is not binding upon him. He submits that the plaintiff has no locus standi to challenge the adoption, as the adoption is only between the defendant number 13 and the defendant number 3. Full stop. Next, I consider submissions made by the learned counsel for the plaintiff and the learned counsel for the defendants. Next paragraph. In the suit for partition, while the plaintiff claimed that the suit properties were held jointly, the defendants contended to the contrary and claimed that there was a prior partition and that some of the properties were purchased out of their self-earnings. Therefore, it is upon the plaintiff to establish the fact that the properties were held jointly as on the date of the suit and that there was no partition. Full stop. The defendants are bound to prove the prior partition, and the onus upon the defendants is more than the plaintiff, as the defendants, by claiming that there was a prior partition, had admitted that the suit properties belong to the family. Full stop. Insofar as the defendant number 13 is concerned, mere execution of a deed of adoption would not dispense its proof, and did not dispense its proof, and the defendant number 13 was bound to establish that there was a valid adoption. Full stop. Therefore, the trial court has rightly framed an issue as to whether defendant number 13 proves that he was adopted by the defendant number 3 in terms of the deed of adoption dated 29/11/2011. In the event the defendant number 13 is not able to establish that he was adopted by the defendant number 3, then the 3 and if he is able to establish and if the other defendants are not able to establish a prior petition, then it goes without saying that the plaintiff would be entitled to a share in all the properties, including the properties that are the subject matter of the adoption deed executed, adoption deed dated 29/11/2011. Full stop. Next para. Though the trial court was not, though the reasoning of the trial court in rejecting the application cannot be accepted, but yet the application was rightly rejected, as the amendment sought for by the plaintiff was not really necessary for the consideration of the suit. Full stop. In that way of the matter, and subject to the observations made above, this writ petition stands disposed of. Full stop. The liberty is reserved to the petitioner to raise this as a ground in an appeal that may be filed by the petitioner against the judgment that may be passed in the suit. Yes. ನೀವು ಸೂಟಲ್ಲಿ ಗೆದ್ರೆ ಅದರಲ್ಲೂ ಸಿಗುತ್ತೆ ಅಂತ ಬರ್ದಿದೆ. ಸಚಿನ್ ಮಹಾಜನ್
ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡಲ್ಲ. ಅಡಾಪ್ಷನ್ ಅಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಯಾವ್ದು ಬಂದ್
ಅವ್ರು ಹೇಳ್ತಾರೆ ಅದೇ ತಾನೆ,
ಅಡಾಪ್ಷನ್ ಅಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಯಾವ್ದು ಹೇಳಿಲ್ಲ, ಅಡಾಪ್ಷನ್ ಅಷ್ಟೇ.
ಅವ್ರು ಹೇಳಿದ್ರು ಅದು ಅಡಾಪ್ಷನ್ ಏನೋ ಪ್ರಾಪರ್ಟಿ ತೋರಿಸಿದ್ರಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಇದೆಯಾ? ಇಲ್ಲ ಅಂತಾರೆ ಅವರು.
Adoption deed I have produced there also. Illu kuda adoption deed ide. Some properties have been shown in adoption also.
ಆಯ್ತು ಬಿಡಿ, ಪ್ರಾಪರ್ಟಿ. Yes, Mr. Sachin Mahajan.
Some properties have shown in adoption.
Sachin.
Yes, ma'am. May it please, my lord. The petitioner in the present petition is respondent in the before the trial court, my lord.
Hmm.
And the petition before the trial court is to seek the decree for divorce by the husband. That is the respondent in the present petition, my lord. My lord, the respondent before the trial court made I number 2 under section 24 and 26 of Hindu Marriage Act and for litigation expenses, and the objection was filed for the same, and my application was rejected by the impugned order dated 9/8/24, my lord.
Why? On what ground?
The findings of the impugned order is that, my lord, the assets and the affidavit of assets and liabilities filed by the respondent before the trial court discloses that there is a file pending before the learned civil judge JMFC in criminal miscellaneous 1153 of 22, my lord. In that, the learned civil judge had already granted an interim maintenance of rupees 10,000. That is 5,000 for the wife and 5,000 for the daughter, my lord.
Hmm.
My lord, my contention is that the interim order granted by the learned civil judge is not a litigation expenses. It does not includes the advocate fees and other litigation expenses which would have been incurred by the respondent during the pendency of the litigation.
You are also working, Alva.
My lord,
You are also working as a beautician. And you're running a
the
beauty-
income is not definite, my lord.
Make it definite. Do some good work.
She is running a beauty parlor and the income is not definite.
Correct, Mr. Beauty parlor correct ಆಗಿ ಕೆಲಸ ಮಾಡಿದ್ರೆ ಜನ ಬರ್ತಾರಪ್ಪ.
My lord.
ಬ್ಯೂಟಿ ಪಾರ್ಲರ್ ಜನ ಬರ್ದೇ ಇರೋ ಯಾರ ಇದಾರ?
ಬರ್ತಾರೆ.
ನಾಗರಾಮ ಬಾಬು ಏನ್ ಇವನ್ ಕೆಲಸ ಏನು ಒಂದು? What does Nagarama Babu do?
He is running a service center, my lord. And
ಏನ್ ಸರ್ವಿಸ್ ಸೆಂಟ್ರು? ಏನಂತ ಹೇಳಿದಿರ? 1 lakh rupees litigation expense.
Yes, my lord.
What does he do, mister?
Yes, my lord.
ಅವ್ರೇನ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಗಂಡ? Notice is also served. ಮಗಳು ಅವ್ರ ಜೊತೆನೇ ಇದಾರಲ್ಲ? The daughter is also with the
There are
husband.
2 daughters out of wedlock, my lord.
No, one daughter is with the husband.
No, my lord. Ibro wife ಕೂಡ ಇದೆ.
Please come to page 28. Petitioner's husband is living with his father, aged about 71 years, and daughter P. Girishma Chaudhary.
Yes, my lord. And he is running a business of TVS two-wheeler showroom at Manvi.
ಎಲ್ಲಿದೆ?
Manvi ದಾಗಿದೆ. ಇದು ರನ್ನಿಂಗ್ ಪೇಜ್ ನಂಬರ್ 14, my lord. In the return segment.
Where have we mentioned?
14, my lord. 14, last para. Second line.
ನೀವೆಲ್ಲ ಹೇಳಿದ್ರಿ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಬ್ಯೂಟಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೀನಿ ಅಂತ? Where have you mentioned in your affidavit in the
Affidavits of assets and liabilities.
ಎಲ್ಲಿದೆ?
Before trial. ಇದು ಇಲ್ಲಿ ಅಟ್ಯಾಚ್ ಮಾಡಿಲ್ಲ.
Have you filed the assets and liabilities?
Yes.
Affidavit. Because Learned Counsel for the petition is directed to file an affidavit regarding her assets and liabilities as held by the apex court in the case of Rajneesh versus Neha.
Yes.
ಅಥವಾ Neha versus Rajneesh, whatever ನೋಡಿ. Yes. The list on date.
Please, my lord.
Jayanandaya.
Well, I am filing the regional application kindly placed and today's objection is given to me. Objection ಇವತ್ತೇ ಕೊಟ್ಟಿದ್ದಾರೆ sir. I have
ಏನು
take-
objection?
Take instructions to the defendant given the your
ನಿಮ್ ಕೇಸ್ ಹೇಳ್ರಿ.
please
Suit is filed in which year?
please.
Suit ಏನಕ್ಕೆ ಹಾಕಿರೋದು?
ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅವ್ರ ಮೇಲೆ ಸೂಟ್ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ಆರ್ ಕಲ್ಯಾಣಿ.
ಆಯ್ತು, ಏನಕ್ಕೆ ಹಾಕಿರೋ ಸೂಟ್ ಒಂದೇ? ಡಿಕ್ಲರೇಷನ್, ಇಂಜಂಕ್ಷನ್.
I am the Shivananda defend number 3 my lord in the lower court.
Defend number 3.
Please my lord.
What is the application filed?
Application filed by the that may be
To
defend
recall-
number 192 that is signed the same is allowed in the 7/8/2024 by imposing the cost of the 1,000 rupees my lord. But in spite of the permitting the cross examination period 192 defendants have not shown the cross ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಇದು ಮಾಡಿದ್ದಾರೆ ಸರ್.
Interim application filed by defend number 3.
Please.
ಎಷ್ಟೊತ್ತಿ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀರಾ?
ಇಲ್ಲ
How many
sir.
times you file the application?
ಇಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಹಾಕಿದ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ 192 ರಿಕಾಲ್ ಮಾಡಿ 1,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು ಆಮೇಲೆ ಅಟೆಂಡ್ ಆಗಿಲ್ಲ ಅದಕ್ಕೆ ಮತ್ತೆ ಅವರು
ಎಷ್ಟು
ರಿಜೆಕ್ಟ್
ಕೊಡ್ತೀರಾ
ಮಾಡಿದ್ರು.
ಕಾಸ್ಟ್?
ಪ್ಲೀಸ್
ಇವಾಗ ಎಷ್ಟು ಕಾಸ್ಟ್?
ಈಗ 500 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ.
500 ರೂಪಾಯಿ ಅಲ್ಲ, 10,000 ರೂಪಾಯಿ. If you are willing to pay 10,000 rupees, we will allow.
Some advocate and party in person same advocate that or Kalyani that may be
My lord.
advocate and party in person is some that may be class ಮಾಡ್ಲಿಕ್ಕೆ ಇದು ಮಾಡ್ಲಿಕ್ಕೆ ಇದೆ.
Advocate party in person.
Please, please, please.
My humble submission, my brother has not claimed any relief against me, just to harass me for the last 4 years. He is neither cross-examined nor conducted the case
What
properly.
is your name?
My name is Kalyani brothers.
Kalyani. Rajkumar is your brother.
My brother's, my elder brother's son. He is the person who is opposing the case is my natural brother.
Correct. ಇಲ್ಲಿ ನಾನು ಹೇಳ್ತಿರೋದು.
Is a declaration issued based on the partition effected by the father.
You succeed in the suit.
I filed a judgment of the division bench of the Honorable Court, which was filed for the it was allowed to conduct trial because division bench already allowed him once.
Sir, 1,000 ರೂಪಾಯಿ ದಂಡ ಹಾಕಿ PW1, PW2 ರಿಕಾಲ್ ಮಾಡಿದ್ರು. ಇವ್ರು ಬರ್ಲಿಲ್ಲ.
ಇಲ್ಲಿ ಒಂದ್ಸಲ ಅಲ್ಲ ಸರ್ ಇದು 4 years.
ಅದಕ್ಕೆ 10,000 ರೂಪಾಯಿ ದಂಡ ಹಾಕ್ತೀನಿ.
ಅಂದ್ರೆ ಸರ್ ಅವ್ನಿಗೆ ಏನ್ ರಿಲೀಫ್ ಬೇಕು ಅದು ಬೇಕಲ್ರಿ ಈ ಕೇಸ್ನಾಗ ಅವ್ನ ಪ್ರಾಪರ್ಟಿ ಎಂಜಾಯ್ ಮಾಡ್ತಾನವ. ಆಮೇಲೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಆಲ್ರೆಡಿ ಅವ ಪಡವ ಹಾಕ್ಬಿಟ್ಟಾನ 1 ವರ್ಷದಿಂದ ಊರಲ್ಲಿ.
ಕಲ್ಯಾಣಿ ಅವರೇ,
ಸರ್
ಒಂದು ವೇಳೆ ನೀವು ಗೆದ್ರಿ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ,
ಸರ್
ಕೇಸಲ್ಲಿ ಗೆದ್ರಿ, ಅವ್ರು ಅಪೀಲ್ ಆಗ್ತಾರೆ ಮತ್ತು ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಇಂದ ರಿಮ್ಯಾಂಡ್ ಆಗುತ್ತೆ ಕೇಸು.
ದಿಸ್ ಇಸ್ ವಾಟ್ ದಿಸ್ ಇಸ್ ದ ಸೆಕೆಂಡ್ ಮೈ ಲಾರ್ಡ್
ಅದಕ್ಕೆ ಹೇಳ್ತಿರೋದು ವಿಲ್ ಅಲೋ ಒನ್ ಮೋರ್ ಆಪರ್ಚುನಿಟಿ.
My lord, he is not at all conducted the case for the last 4 years.
ಯಾವತ್ತಿದೆ ಕೇಸು?
ನಾಳೆ ಬಿಟ್ಟು ನಾಡಿದೆ ಸರ್.
ನಾಡಿದ್ದ?
12th January.
ಯಾವತ್ತಿದೆ ಕೇಸು?
Day after tomorrow sir.
15th.
Day after tomorrow ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಲಿ.
My lord, he is not interested my lord.
10,000 ರೂಪಾಯಿ ದಂಡ ಕಟ್ಟಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಲಿ. ಮಾಡದೇ ಇದ್ರೆ ವಿಲ್ ಟೆಲ್ ದ ಕೋರ್ಟ್ ಟು ಪ್ರೊಸೀಡ್. ಆಗ್ಬೋದಾ?
If there is no infirmity with the order, my lord, the court has given sufficient publicity. Honorable, I may be, my humble submission to look into the order of the possible trial court.
ಬರ್ಕೊಳ್ಳಿ. The defendant number 3 in voice number so and so on the file of so and so is before this court challenging the correctness of an order dated 26 November 2024 by which an application filed by him under section 151 to recall PW1 and PW2 for cross-examination was rejected with cost. Next para. The suit in OS number 24 of 21 was filed for declaration of title and for perpetual injunction and other reliefs. Full stop. The suit was contested by the defendant number 3. Full stop. The trial court framed issues and set down the case for evidence. The plaintiff examined PW1 and PW2. Full stop. Since they were not cross-examined, the evidence of the cross-examination, their cross-examination was treated as closed. The defendant number 3 then filed an application under section 151 to recall PW1 and PW2 which was allowed on payment of cost of ₹1,000. However, the defendant number 3 did not cross-examine the witnesses, and the trial court again treated the cross-examination of PW1 and PW2 as nil. The defendant number 3 again filed another application to recall the said witnesses, which were rejected in terms of the impugned order. Being agreed by the said order, the defendant number 3 is before this court. Next, the learned counsel for the defendant number 3 contended that the defendant number 3 ಏನಕ್ಕೆ ನೀವು ಮಾಡಕ್ಕಾಗ್ಲಿಲ್ಲ?
ಆರಾಮದಿಲ್ಲ sir.
No reasons have been
Not
assigned.
appear before the date.
Not one side.
You're not well.
Please.
There's not, no reasons, no
Defendant number
documents.
3 was unwell, and therefore he could not give sufficient instructions to his counsel to cross-examine PW1 and PW2. This is, however, countered by the learned counsel for the plaintiff, who contends that the defendant number 3 has been prolonging the cross-examination of PW1 and PW2 for more than 4 years.
About, running 4 years. I'm going
for
4 years.
nearly 4 years. ಇನ್ನ ಸೂಟ್ ಹಾಕಿ 4 ವರ್ಷ ಆಗಿಲ್ವಲ್ಲ?
21 ದಾಗ ಹಾಕಿ ಸರ್, 21 ದಾಗ.
For nearly 3 years. Full stop. He contends that the trial court had given enough opportunity to cross-examine PW1 and PW2, and that it was the defendant number 3 who did not avail of the said opportunities. Full stop. Next, but I have considered submissions of the learned counsel for the defendant number 3 and the learned counsel and the plaintiff who has appeared in person. Next para. The suit is filed for declaration and consequential relief of perpetual injunction and other reliefs. Full stop. Though the plaintiff claimed title to the suit property, the defendant denied his title. Full stop. Therefore, the defendant number 3, full stop, title full stop. It appears from the record that the defendant number 3 has procrastinated the adjudication of the suit by allowing PW1 and PW2 to record their evidence and not cross-examining them. Full stop. The trial court has also given enormous opportunity to the defendant number 3 to cross-examine PW1 and PW2, and it is the defendant number 3 who has not availed of those opportunities. In that circumstance, the impugned order is unexceptionable, as the court cannot unendingly wait for the defendant number 3 to conclude the cross-examination. Nonetheless, since the decree of the suit might result in civil consequences upon the defendant number 3, it is appropriate that an opportunity is granted to the defendant number 3 to cross-examine PW1 and PW2 on the next date of hearing by placing him on terms, so as to ensure that he does not further protract the proceedings. In that view of the matter, this petition is allowed and the impugned order passed by the trial court is set aside. The application filed by the defendant number 3 under section 151 of CPC to recall PW1 and PW2 is allowed, subject to payment of cost of ₹10,000.
Please.
Full stop. It is the plaintiff, the defendant number 3 shall without fail cross-examine PW1 and PW2 on the next date of hearing unless it is inconvenient to the court. Full stop. If the defendant number 3 does not avail of this opportunity, the trial court is requested to dispose of the suit in accordance with law. Yes.
ಸಂಕ್ರಮಣ ಕರೀದ್ರು ಅವರು ಬರ್ತಾರಲ್ಲ, ಅಟೆಂಡ್ ಆಗ್ತಾರಲ್ಲ ಕೋರ್ಟ್ ನಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ 15th ಇದೆ ಸರ್. ಅದಕ್ಕೆ
ಇವತ್ತು ಕಾಪಿ ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ ನಾನು. ಇವತ್ತೇ ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ.
ರಿಕ್ವೆಸ್ಟ್ ಟು 5,000 ಮಾಡಿ ಸರ್. ಅದು 1,500 5,000
₹10,000 ನೀವು ಮಾಡೋದಕ್ಕೆ ಇನ್ನು ಮುಂದೆ ಮಾಡಬಾರ್ದು ಅನ್ನೋ ದೃಷ್ಟಿಯಿಂದ. ನಾಟ್ ದಟ್ ವಿ ವಾಂಟ್ ಟು ಪೀನಲೈಸ್ ಯು. ಇನ್ನು ಮುಂದೆ ಈ ತರ ಮಾಡಬಾರ್ದು ಅಂತ. ₹500 ಅಂದ್ರೆ ಇನ್ನು 10 ಸತಿ ಮಾಡ್ತೀರಿ.
ಅಲ್ಲ, ₹5,000
₹500 ಕಾಸ್ಟ್ ಹಾಕಿದ್ರೆ ಇನ್ನು 10 ಸತಿ ಮಾಡ್ತೀರಿ. ₹500 ತಾನೇ ಹಾಕೋದು. Therefore, it is exemplary cost. Yes, Halali.
Lord, This is a case, my lord, the had taken IEM in the year 2014 and had taken the land also and so converted to NA. And there was a delay in taking approval from the government and had to file several writ petitions.
File objection,
Lord,
file what?
finally,
You consider, you
Allah, my request is only to, now the order is passed, my lord, the accepting my lord, my request to extend the IEM period without, my lord, excluding the period spent in the courts, my lord. That's only in view of, so Swami Samartha, my lord. The period spent in the court is to be excluded. That's only my request, but I have given representation orally also requested, they did not do it. And I have given written request on.
already excluded. That order is
Already excluded.
excluded.
ಇಲ್ಲ exclude ಮಾಡಿಲ್ಲ.
ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ನೋಡ್ರಿ, ಕಾಪಿ ಕೊಡ್ರಿ ಅವ್ರಿಗೊಂದು.
20.
ಇಲ್ಲ ಸ್ವಾಮಿ, I have already given representation. May kindly be not seen the Lord annexure, Lord page so 70.
No, Mr. Alali, 2nd
Yes.
January 2025, there is some order.
Yes, my lord, that's.
2nd
ಹೌದು
January.
ಅದರಲ್ಲಿ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿಲ್ಲ, ಪೀರಿಯಡ್ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
Regularize.
ಅಲ್ಲ ಅದನ್ನೇ that period is excluded, then I did not pay the excluded period ಗೆ ನಾನು ಅಮೌಂಟ್ ಕೊಡ್ಬೇಕಾಗಿಲ್ಲ. They are now collecting the about 50 lakhs DD and 50 lakhs about the bank guarantee. If that is excluded, I did not pay it. That's what they have considered and regularized and have validated it.
As per the order of the this honorable court in WP Malaysia, you consider we will pass the order in accordance with law.
Order of this court in what?
Representation. Representation ಕೊಟ್ಟಿದ್ದಾರೆ, fresh representation. Along with memo, he submitted the
Will
representation.
not, may take your lordship's attention to Lord Swami Samartha case, Lord Supreme Court.
You argue on some other. Yes, next.
ಇಲ್ಲ my lord, only to consider that, my lord, in view of the Supreme Court judgment, Lord.
No, you
May I
please go
request,
through
my lord?
this. Please come to the court, Alali.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲ 19ಕ್ಕೆ ಮತ್ತೆ ಪೀರಿಯಡ್ ಮುಗಿತದ, then I will have to pay more money, my lord. I have paid 1 crore already, my lord. 2 crores I have paid already.
Please come to the court. You are simply, ನೀವು ಅಲ್ಲೆಲ್ಲೋ ಇದ್ದೀರಿ ನೀವು, you are not able to relate. What is that you want to say?
Not the writ of mandamus annexure D with respect
ಯಾವುದು?
to police protection
ಅಲ್ಲ
charges.
ಅಲ್ಲ short date, my lord, short date, my lord, may I request not short date.
Syed Fayazuddin.
Yes, ma'am. Annexure D, my lord, it is a writ of mandamus, my lord, for not considering the annexure D at page 19 for the review of the police protection charges. We have filed it before the
Police protection charges.
yes, my lord.
ಏನದು police protection charges?
They have taken 1,50,000 per month, my lord. For that.
Why, mister?
My lordship, as per the circular 2021, the different, my lordship, if we want PC, there is a charges of 4,200, my lordship.
For PC,
Per
it is
day, 48 hours.
For PC, as per their circular only, let them submit it. There is 2,270 there, PC.
My lordship, kindly have it on my 16th, my lordship, we will file detail.
No, it is not. Already 2-3 days they have taken, they are already removed the police protection of my client.
Day after tomorrow.
He is
Day
giving on
after
that threat.
tomorrow.
The problem is that they have already removed the police protection. He is already paid. 3 times charges he has paid.
Day after tomorrow.
Please, my lord.
Correct.
But this is a date given matter, my lord, is not listed. In fact, this is a date given matter, my lord, which is not listed. Pursuant to the interim order granted by this court on 19th, my lord, date was fixed on 13th today, my lord. In the meanwhile, I had moved the matter on 8th, my lord, for seeking clarification of, my lord, the order. Adu agide. Now, after this, my lord, again, my lord, the authorities are, my lord, finding a fault with the order of this court. My lord, contending that, my lord, annexure J, which is passed by them. Annexure J, page number 43. ಇದ್ರ ಮೇಲೆ ಸ್ಟೇ ಇಲ್ಲ, ಅದ್ರ ಸಲಕ್ಕೆ ನಾವು ಕಂಪ್ಲೈ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಏನ್ ಸ್ಟೇ ಇದು?
Annexure J is, my lord, a communication where, my lord, they directed us not to, my lord, take admissions for academic year 2023-24. This is dated 6/3/2024.
Yes, government.
My lord, the last date for taking admission was in the month of December 23, which was already taken. Now admission ತಕೊಂಡ್ ಆದ್ಮೇಲೆ ಅವರು order ಮಾಡ್ತಾರೆ.
And AGA seeks time to file objections.
ನಾಡಿದ್ದಿಂದ exam is some, they are not.
In view of the request of the learned counsel in view of the contention of the learned counsel for the petitioner, that the respondents, despite the order dated so-and-so passed by this court, are not permitting the students of the petitioner to face the examinations, as the letter dated 6/3/2024 issued by the Board of Examining Authority, D Pharma, Annexure J, is not stayed. Full stop. In view of the earlier orders passed by this court, referred supra, the impugned, the order dated 6/3/2024, Annexure J, issued by the Board of Examining Authority, D Pharma, is also stayed. Full stop. The respondent shall take all steps required to ensure that the students of the petitioner face the examinations that are scheduled on
15th.
On 15th, scheduled to commence on 15th January 2025.
Let government advocate communicate the order.
Ayank, AGA, please communicate.
Yes, my lord.
AGA is directed to communicate this order to the concerned for immediate implementation. Yes. Anna Raya.
That order is in operation till today.
My lord, petitioner challenging the tender notification issued by the respondent to railway authorities for the contact, change work and other services. And petitioner and respondent number 4 has been applied for the open tender. The second respondent has given the said bid contract to the respondent number 4 without following the Annexure F. My lord, Annexure F, page number 26. Second para, last line.
Ian, what have you challenged?
Challenge Annexure K, my lord.
Annexure?
Bid G1, my lord. G1.
G1.
Yes, my lord.
ಏನದು G1 ಏನು? What have you challenged, Mr.? You have challenged the tender.
Tender along with tender schedule, my lord.
Why?
The respondent number 2 has not followed as per railway guidelines, as per Annexure F, para number 2.
Participate ಮಾಡಿದಿರಾ?
Is participate.
You participated. ನೀವು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದಿರಿ ಟೆಂಡರ್ ಅಲ್ಲಿ?
ಮಾಡಿದೀವಿ.
ಮತ್ತೆ ಹೆಂಗ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀರಾ?
Challenge, but ನಮ್ ಕೊಡ್ಲಿಲ್ಲ, ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. It should be given on the system of manpower, my lord. Kindly see the Annexure F, para number 2, last line, my lord. It should be issued on manpower based contract system as per the external instruction.
Annexure
on
F.
manpower based, Annexure F, page number 26.
ಎಲ್ಲಿದೆ ಏನಂತ?
My lord, para number 2, last line. It should be issued on manpower based contract
The
system.
matter has been examined in this office and it has been decided to enforce contract of hygiene, watering and linen activities in train should be issued on manpower based contract system as per extant instructions on manpower based contracts.
But it has given on the basis of activities to the respondent number 4.
ನೀವೇನ್ ಮಾಡಿದ್ರಿ? ನೀವು ಮ್ಯಾನ್ ಪವರ್ ಸಪ್ಲೈ ಮಾಡೋದಾ?
Manpower supplier. I have license with 44.
Why did you not challenge the tender before?
Where, my lord?
ನೀವು ಟೆಂಡರ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ಮೇಲೆ,
ಹೌದು.
ಟೆಂಡರ್ ಸೋತ್ ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಕ್ ಬರುತ್ತಾ? ನೀವು ಟೆಂಡರ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದಿರಿ,
ಹೌದು.
ಟೆಂಡರ್ ಸೋತಿದ್ದೀರಿ.
ಬಟ್ ನಮ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್ Annexure F
Why
ಕೊಡ್ಬೇಕಾಗಿತ್ತು.
did you not challenge it
ಬಟ್ ಅವ್ರು ನಮ್ಗೆ ಓರಲಿ ನಿಮ್ಗೆ ಕೊಡ್ತೀವಿ ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್ ಮ್ಯಾನ್ ಪವರ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. ಅದಕ್ಕೆ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ.
Yes. Why did you ನೀವು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಕ್ ಮುಂಚೆ ಬರ್ಬೇಕಾಗಿತ್ತು.
As per Annexure K, my lords, as already approved the contract. As per Annexure K, that is also in challenge. On the basis of the activities, that is locomotive activities. You approved the contract to respondent number 4.
ಇದು ವರ್ಕೌಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಆಗ್ಲೇ.
No, that is, we approved the contract, but his service starts from 15/1/2025. In service details, my lordship, Annexure K, last para, service details, service start date 15 January 2025.
When was the tender when was the tender invited?
Invited on, as per Annexure G, my lords. G1, as per Annexure G1, 16/8/2024. We accept the
ಎಫ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತೀರಾ ಮತ್ತೆ?
Please.
Annexure F ಬಗ್ಗೆ.
Then he is contending that, my lordship, the railway has not followed the Annexure F, my lordship. As per Annexure L, my lordship, already Western Railway has adopted that activities, my lordship. That is the manpower based activities. But the Central Railway has not adopted the manpower activities.
Already Annexure F is the government railway board
Board ಕೊಟ್ಟಿದೆ.
ಮತ್ತೆ ರೈಲ್ವೆ ಬೋರ್ಡ್ ಮಾಡೋದು ಉಪಯೋಗ ದೊಡ್ಡದಾ ಅಥವಾ ಇವು ವೆಸ್ಟರ್ನ್ ರೈಲ್ವೆ ಮಾಡೋದು ದೊಡ್ಡದಾ?
ಇಲ್ಲ, Western Railway already adopted the, that is the as per Annexure F, my lordship. But Central Railway ಮಾಡಿಲ್ಲ ಅಂತ ಅವ್ರ ಕಂಟೆನ್ಷನ್.
ಅದೇ ತಪ್ಪಲ್ವಾ? ಮತ್ತೆ ಅವ್ರ ಕೆಲ್ಸಕ್ಕೆ ಇಟ್ಕೊಂಡ್ರಲ್ಲ ಏನಾಗ್ಬೇಕು?
ಆಲ್ರೆಡಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ದಿ ಸರ್ವಿಸ್ ಮಾಡಿ ಅವರೇ ಇದ್ರ ಸರ್ವಿಸ್ ಅಲ್ಲಿ.
Therefore ಅವ್ರ ಕೆಲ್ಸದವನ್ನೆಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕು ಅವರು? ಈ ಟೆಂಡರ್ ಅಲ್ಲಿ ಯಾರಿಗೆ ಎಲಿಜಿಬಿಲಿಟಿ ಯಾರಿಗಿತ್ತು?
ಆಸ್ ಪರ್ ಮೂರೇ ಜನ ಇದ್ದಾರೆ.
ಮೂರೇ ಜನ
ಇದ್ದಾರೆ ಆಸ್ ಪರ್ Annexure J. Annexure J. Page number 36. Mega Construction, Prabhakar Enterprises, and petitioner N.A. Khan.
Page number 36.
36.
When was the tender called? Tender call ಮಾಡಿದ್ ಯಾವಾಗ?
16 as per Annexure
16/8/2024.
ಮತ್ತೆ ನೀವು ಯಾಕೆ why you kept quiet?
16/8/2024.
ಸುಮ್ಮನಿದ್ರಿ ನೀವು, ತಪ್ಪು ಮಾಡಿದ್ರಿ, ಮುಂಚೆ ಬರ್ಬೇಕಾಗಿತ್ತು.
ಬಟ್ ನಮ್ಗೆ ಓರಲ್ಲಿ ಅವ್ರು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಓರಲ್ಲಿ ಹೋಗಿ ಕೇಳಿ ಕೊಡ್ತೀನಿ ಅಂತ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕೇಳಿ ಅಷ್ಟೇ. You should have come early. Take out notice ಅಷ್ಟೇ. Issue emergent notice. ಇದು
1 and 3 I am
Deputy Solicitor General of India is directed to accept notice for respondent number
1 to 3
and 2.
3 also.
3 na?
He is reporting officer.
1, 2 and 3.
3.
1, 2 and 3. Issue emergent notice to respondent number 4. The contract awarded to the respondent number 4 is subject to the result of this writ petition. ನೀವು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ಮೇಲೆ ಈ ಕಂಡೀಷನ್ಸ್ ಸರಿಗಿಲ್ಲ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ. ಒಂದ್ಸತಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ಮೇಲೆ ಊಟ ಎಲ್ಲ ಮಾಡಿ ಕ್ಲೀನಾಗೆಲ್ಲ ತೊಳೆದು ಬಳೆದು ಎಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ ಉಪ್ಪಿನಕಾಯಿ ಸರಿಗಿಲ್ಲ ಅಂತ ಹೇಳಂಗಿಲ್ಲ. ಅವಾಗಲೇ ಹೇಳ್ಬಿಡ್ಬೇಕು, ಹಿಂಗೆ ಅಂದ್ಬಿಟ್ಟು ಉಪ್ಪಿನಕಾಯಿ ಸರಿಗಿಲ್ಲ ಅಂತ ಆಗ್ಲೇ ಹೇಳ್ಬೇಕು. ಎಸ್ ಮೇಡಮ್.
Exams are scheduled, D Pharma first year students, Millards, exams are scheduled on 15th. Their admissions are approved, Millards, only because the reason quoted by the respondent 3, the member secretary saying that I have not turned up for document verification. I have already submitted the original marks cards of entire students, Millards, page number, that is 39 students. I have uploaded the documents, admissions are approved, and documents are also have submitted as per Annexure C, page number 21, Millards, and there is also endorsement on their behalf, Millards. And I have made several representations saying that I was present on that day. Despite of it, Milord, neither they reject it, nor they
What is the ground on which it is rejected?
not rejected. They have just kept on squatting on that my representation request letter saying that I am not turned up. My lordship may kindly see the reason quoted by them is Annexure E, page number 23. Notice ಕೊಡ್ತಾರೆ ನೀವು ಬಂದಿಲ್ಲ ಆವತ್ತು ಅಂತ ನಾ ರಿಪ್ಲೈ ಕೊಡ್ತೀನಿ. I was there on that day, my staff was there, and it was already document were verified ಅಂತ, and all the documents are with them ಅಂತೇಳಿ Annexure C, page number 21, it is already there, my lords. That is an endorsement saying that all the original certificates, if they had provided me an opportunity, another opportunity, if they are not satisfied.
My lord, due to payment, late payment, my lord, they have paid affiliation fees, they have paid early. Student fees, they have paid on 9/1/2020.
ಅಷ್ಟೇ ತಾನೇ.
ಇಲ್ಲ ಅದು ಕರೆಕ್ಟ್ ಇದೆ, ಬಟ್ ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್ ನಲ್ಲಿ
Direct them to appear and produce all the documents for
ಬಟ್
verification.
ಈಗ ಎಕ್ಸಾಮ್ ನಾವು ಪ್ರಿಪೇರ್ ಮಾಡೋದಕ್ಕೆ ನಮ್ಗೆ ಇಶ್ಯೂ ಮಾಡೋದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ ಮ್ಯಾಮ್.
ಬರ್ಕೊಳ್ಳಿ. AG is directed to accept notice for respondents 1 and 2. Issue emergent notice to respondent number 3. In view of the contention of the learned counsel for the petitioner was always ready for verification of the documents of the students admitted for the year 2023-24. And the impugned order at annexure, impugned notice at annexure E is impugned notice at annexure E does not state the facts properly. And in view of her statement that the examinations to the which year?
D Pharma first year,
D Pharma first year is scheduled on
15th. day after.
15th January 2024-25. It is appropriate to permit the students of the petition. Court fees kattidira? Kattidira?
Yes, I have paid.
It is it is appropriate but the respondent number 3 is directed to permit the students of the petitioner to face the examination scheduled on 15th January 2025. Full stop. The results of the examination shall however not be announced until announced. Full stop. In the meanwhile, the petitioner shall appear before the respondent number 3 on yavat?
Any date fixed.
On
Any date fixed.
24th January 2000.
Great.
24th January 2025 for verification. Failing which, verification. It is made clear that in case if the petitioner fails to appear before the respondent number 3 and satisfy the respondent number 3 about the documents of the students admitted in the year 2023-24, this writ petition shall be disposed of in accordance with law. Yes.
Grateful. Hand delivery, may I request for hand delivery?
Yes, next.
The advocate may be directed to intimate.
AG is directed to accept notice for response 1 and
3, 1, 2, 3.
1 to 3. Baswa Kiran.
May be directed to intimate the respondent.
ಕೊಡ್ತೀವಲ್ಲ ಈಗ.
Yeah, otherwise they will not, because day after tomorrow is
I will
exam.
intimate.
And AG is directed to intimate the respondent number 3 about this order. and to take all necessary steps to enable the students of the petitioner to face the examination.
Grateful.
Yes, next.
Grateful, my lords.
Basava Kiran.
Please, my lord. Your lordship, in this writ petition, I am challenging certain conditions of the for submission of technical bid enlisted at Annexure D, which is the tender notification issued by the Minority Welfare Department, my lord, of which the Deputy Commissioner is the head of.
Please wait.
Yes.
Page number?
Annexure D is at page number
yes,
21, my lord, but the conditions are enlisted at page 40, my lord.
Page 40.
Condition number 13 and condition number 14 pertain to the turnover, my lord, and the work experience certificate that has to be submitted during the. Yes, my lord. 13 2021, 2022, 23 ಮತ್ತು 2023, 24ನೇ ಸಾಲಿನಲ್ಲಿ ಸಂಸ್ಥೆಯ ಅಥವಾ ಏಜೆನ್ಸಿಯವರ ಟೆಂಡರ್ದಾರರ ಕಳೆದ 3 ವರ್ಷಗಳ ಸರಾಸರಿ ವಹಿವಾಟು ಕನಿಷ್ಠ ಟೆಂಡರ್ಗೆ ನಿಗದಿಪಡಿಸಿರುವ ಬಿಡ್ ಮೊತ್ತವನ್ನು ಮೊತ್ತದಷ್ಟು ಹೊಂದಿರಬೇಕು. ಈ ಬಗ್ಗೆ ಚಾರ್ಟರ್ಡ್ ಅಕೌಂಟೆಂಟ್ ರವರಿಂದ ಪಡೆದ ಟರ್ನ್ ಓವರ್ ಸರ್ಟಿಫಿಕೇಟ್ UIDN ಸಂಖ್ಯೆಯೊಂದಿಗೆ ಸಲ್ಲಿಸುವುದು. ಸದರಿ ವಹಿವಾಟು ಕಡ್ಡಾಯವಾಗಿ ಆಹಾರ ಸಾಮಗ್ರಿಗಳ ಸರಬರಾಜು ಮಾತ್ರ ಇರಬೇಕು. This is the primary condition which I am challenging, my lord, that it should not be primarily with respect to ahara samagrigala sarabaraju, because the items listed in the tender pertain to food items, vegetables, fruits and toiletries.
The similar matter we stayed at Telva, yadu monne.
ಒಂದಾಗಿದೆ ಸ್ವಾಮಿ, ಅದು my
You
coordinate.
participate.
Please, my lord. I have annexed the coordinate bench order also at the end of this.
No, I think a few days back I passed some order.
Okay, please, my lord.
Berkeley AG is directed to accept notice for respondents 1 to 3.
Yes.
Having regard to the contentions raised in the writ petition and also having regard to the nature of work put to tender and the eligibility of the petitioner to participate, it is appropriate to permit the petitioner to participate in the tender invited by the respondent number 3.
Respondent number 2 and 3, my lord.
Respondent number 2 and 3 for
supply of food items and other food and other items.
For supply of
food and other items, my lord.
food and other items to
Morarji Desai School.
Morarji Desai Residential School, Dr. APJ Abdul Kalam Residential School,
and pre-metric. Pre-metric and post-metric.
Residential, pre-metric and post-metric.
Boys and girls hostels.
Hostels for the year 2024-25.
Maintained by the Minority Welfare Department. Maintained by the Minority Welfare Department. ಅಲ್ಪಸಂಖ್ಯಾತ ಇಲಾಖೆ.
ಎಲ್ಲಿದೆ?
ಅಲ್ಪಸಂಖ್ಯಾತ ಕಲ್ಯಾಣ ಇಲಾಖೆ ಮೇಲೆ ಇದು ಇಶ್ಯೂ ಮಾಡಿದ್ದು.
Okay, respond.
Yes.
Invited by the Department of Minorities, Raichur. This is however subject to the result of this petition.
Last Friday, stayed, my lord. Srinivas Advocate, Bangalore. 3 writ petition filed, man.
ಅದು ಹಾಕಿದ್ರು.
ಹೌದು, ಅಂತ 3 petitions.
Please, my lord, hand delivery may be permitted. Much obliged.
I request for hand delivery in seal number 1 also.
Submission.
Yes.
Petition number, I have given the list at Annexure B, my lords, all the list of the students. Petition number 1 to 39.
ಅದು ಹೆಂಗೆ ಸೇರ್ಸಕ್ಕಾಗತ್ತೆ?
ಅಲ್ಲ, interim order ಹಂಗೆ ಕೇಳಿದ್ರು. Prayer is needed. ಯಾಕೆಂತ ಹೇಳಿದ್ರೆ ಅಷ್ಟು ಒಬ್ಬರು ಮಾತ್ರ approve
Whatever
ಆಗಿಲ್ಲ.
you ask for the interim order, same thing will
My
be.
lords, please.
Whatever interim order that you ask will.
Great. Great.
You will supply to the Raji Desai. License competition malaka. Yes, yes. Very good.